Good morning, good afternoon, good evening, everyone. Welcome to Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan, and I'm really very thrilled to have you join us today across YouTube, LinkedIn, Facebook. And thank you for tuning in, by the way, folks. I totally encourage you to participate. But before we start off today's session, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, definitely, I encourage you to participate in the conversation, friends, wherever you're watching us from. Join us by commenting in the comments as comment section, and feel free to ask your questions or share your thoughts throughout the webinar. And if you have any questions or experience to share, even you may feel free. So, we love to hear from our audience. That's what I need you to know. And thank you once again for joining. And today on Immigration and Jobs Talk Show on this very webinar, we have a very special guest once again. This is Justin Rivera joining us. I think this will be the third time joining us for another webinar. Well, thank you so much, Justin, for joining us once again. It's really such a pleasure to have you here.
hmm Thank you so much for having me. It's always nice to be on.
Thank you, thank you. And for folks out there who are maybe seeing Justin for the first time here on Immigration and Jobs Talk Show, let me tell you that Justin Rivera is an esteemed employment-based immigration law attorney with Wasden Law. And Justin is not only a defender of H1B visa applicants, but is also uh, dedicated community advocate. So it's really such a pleasure to have you once again with us, Justin.
Thanks.
And once again, we are going to be speaking about the H1B cap lottery. I mean, last session we spoke about the second lottery, the announcements, and some of you got selected. But today's session, I think, is going to be more for those of you all who couldn't get selected in this second lottery. And what next then? Not just in the second lottery, but in this whole lottery. So thank you so much, Justin. What can folks out there expect from us this session?
Yeah, I think we'll touch a little bit on the issues. Sorry, wife calling. I think we'll touch a little bit on what do you do if you've been selected from an employer and employee perspective, and then what to do in circumstances where you weren't selected, kind of what your options are. And then I
Mhm.
think maybe some more general topics of just kind of discussing a little bit more regarding some of the recent FAQs that have come out for the H1B visa.
True. Absolutely. So we'll dive into what options are available if you were not selected in the lottery and probably how to navigate your career and your immigration journey to the United States. So without
Mhm.
further ado, I think we'll just dive into our questions directly since Justin is here for a short while only. So Justin, can you elaborate on the recent USCIS announcement regarding the second H1B lottery for the fiscal year 2025 cap, and what are the key details that petitioners should be aware of?
Yeah, so it's closed. That second lottery has been run. Everyone who's been selected, the petitioner, which is going to be your employer, has been notified. So at this point, more likely than not, if you haven't heard from your employer, then your case was likely not selected. What this means is that selected individuals they have 90 days to file their H1Bs with USCIS.
Mhm.
You need to file within that window. Like the last lottery, there's kind of a general statement that USCIS is not going to provide any exceptions for people who file late. So you do want to get that filing in. Now, that being said, um, last lottery, they did provide a small extension for filings based on some technical difficulties that had occurred. So they did give a little bit longer window, but I would not bank on that this time. Definitely try and file your cases early. The reason why you really want to file early or well before that deadline is cases can be rejected, and there have been instances of proper rejection and improper rejection. There's a litany of reasons why a case could be rejected, maybe a lack of signatures in specific areas, lack of correct fees, maybe somehow the case was sent to the wrong location, and then worst of all, an improper rejection by the by USCIS. So
Hmm.
in that circumstance, you're probably not going to see that packet that's been rejected for probably a week, maybe longer, depending on mailing, where you are, where it was sent. So that's why I would definitely say, be aware of your deadline, but I would say try to make sure that your case is submitted at least 2 weeks before that deadline if you're able to do so.
There you go, friends. You know what to do. And 2 weeks, I mean, try to have some time in hand so that at least if you have to rework on something, you still have some time and not
Right.
going to submit at the nick of time. And even if you have to make any changes, you just don't have time anymore for that.
Mhm.
So thank you, Justin, for taking that up. Moving on now, I think I got the second question. So next is, what specific criteria must registrations meet to qualify for selection in the second lottery? But since it's already done, it's closed. Are there any
Mhm.
particular factors that could influence a registration's eligibility?
So for this round, we were looking at regular cap only. So everybody that that's been selected was out of that grouping, that regular cap. So you weren't in a situation where having an advanced degree, U.S. master's degree or higher, is going to put you at an advantage. So kind of
Hmm.
a quick understanding of how the normal lottery works is the normal lottery, you have the initial lottery run, and then you have the advanced degree lottery run. And the reason why that's so advantageous for people with advanced degrees is you basically get a second lottery run that's going to be just for you and other people with the US master's degree criteria met. And it's
Hmm.
run after the first. So you've already had people taken out of the pot that have master's degrees. So it gives you an advantage when you're being selected. That wasn't the case here. So in this circumstance, you're looking at everyone in that regular cap being um, sorry about that. You have
It's all right.
everyone coming in at an equal playing field. Everyone's coming in at the same level. Now, that being said, I do want to point something out that's kind of nice to have this time around. There's only a regular cap. You have to select
Hmm.
which cap you are filing under at the time that you file. A pitfall that I definitely advise making sure is taken care of is making sure that you select the right cap. That's kind of a point of no return. If you select the wrong cap when you file, you're going to be in trouble. You're gonna have issues where you're going to see an RFE asking for justification why you filed in the wrong cap. This
Yes.
time, it's all regular cap. Everybody's selecting the same box. You don't have to look at the selection notice to make a determination. It's already said right
Hmm.
there for you. It's just going to be regular cap across the board.
Thank you. Thank you. I'm sure, Justin, I think you're in a hurry, right?
Yeah,
Is there an
I'm
emergency?
not too much of a hurry. I'm okay. I just my wife's asking me stuff.
Okay, that's fine then. All right. Thank you. Thank you for being patient. And folks out there, we are here. So thank you, Nishant, for your questions. Stay with us. We will take them up. For now, Justin, if you could just tell us, what steps should applicants take immediately after learning that they have been or not been selected in the second lottery, in the second H1B lottery? So first, let's go with if they have been selected.
So, people who have been selected, I think what you're looking at here is you need to move forward in tandem with your employer to make sure that you're filing as quickly as possible while ensuring that the proper documentation is included in your petition. So, obviously, you need that certified LCA. That takes 7 days to certify. Your employer needs to comply with the posting and notice requirements in that time frame. You're going to need to file with the I-129 form with the correct requisite signatures. Big thing
Mm-hmm.
to remember on signatures. I know it's a small thing to think about, but you are now allowed to use a copy of a handwritten signature. So if time is
Okay.
of the essence and you're in a circumstance where you don't want to mail forms back and forth, the client is completely capable of printing, signing, scanning, and returning a copy of the document signed. And you can use that as an alternative. Now, I will say, it's a preference of a law firm. Maybe some law firms like to use the more traditional paper route because they have a system in place. But
Mm-hmm.
I'm more of the belief that if you're given an easier way to do something, you should do that. So the signatures, the offer letter, you need the description of employment. Maybe if you're working at a third party, you might need evidence of that consulting engagement, via, contracts with the vendor, client letters, maybe, if those are available. I think the biggest focus is going to be, what does USCIS have the ability to look at? And that's going to be, does the position qualify as a specialty occupation?
Mm-hmm.
Has the position been placed in the right SOC code, the right occupational category? An example of that would be, let's say someone's a software developer and you're filing an H1B for a software developer, and for
Mm-hmm.
whatever reason they use the SOC code for a computer systems analyst. Um, you have to really get down to what the person's doing, the job duties that are being performed, to make the determination of where the position qualifies. An attorney is going to be able to take care of that for you, but in order to do that, you have to give the attorney as detailed a description as possible of what the position is. You're going to be including that in a support letter, a document that's going to be signed by the client explaining the position. And the other big thing to remember is the beneficiary's qualifications. Obviously, you have to show how you're qualified for the specialty occupation position. To do that, if you have a non-U.S. degree, a foreign degree,
Mm-hmm.
you must submit an evaluation. I'm sorry, not an evaluation, a translation, a certified English translation. I think an evaluation should also be done as well. Just knock it out. Do the eval with the translation, show that it's consummate to a U.S. degree, makes everything a lot easier for you. The other thing is looking at the type of degree that's being used to qualify someone for the position and making sure that there is that nexus. There needs to be a
Mm-hmm.
connectivity between what the person's doing and their field of study. If there is not a nexus that's clearly identifiable, then you're getting into, do we need to do, there's different phrases for this, combo eval, an education plus experience eval. That's where you're going to be
Mm-hmm.
looking at taking work experience, professional work experience, combining it with the education, to show that the person has a hybrid of the two that's equivalent to a degree in an applicable field. So
Mm-hmm.
again, those are really kind of the big issues to look at, if whether or not that's going to line up. You can always file and see if the case gets an RFE, to kind of save money if you don't want to do the evals. But I think that you should definitely just go ahead and present the strongest case you have up front, especially for this one. This is the first H1B. This is going to be giving someone cap exempt status moving forward. So
Mm-hmm.
that would be my general recommendation. And then I believe you had asked, kind of on the flip side of that, about people who were not selected.
Yes, that's my
Yep.
second part. I mean, what if people were not selected in this lottery? What do they do? What's their next
So
step?
so I think John and I had talked about this a little bit on Wednesday, if I remember right. Gosh, the week goes by fast.
I
Um,
know, right?
we had spoken about this a little bit previously, and we had talked about going to and try looking for H1B cap exempt employers. So there
Mm-hmm.
are entities that are able to file H1Bs without an individual that has gone through the lottery. So an
Mm-hmm.
example of that's going to be nonprofit higher institutions, nonprofits that are working in tandem with a higher institution, and then nonprofits or U.S. government research organizations. So these are all different employers that they don't have to have the employee have gone through the lottery in order to hire them on an H1B. So I would definitely look at that. Another option that I think is often talked about is if you're on an F1 and you're running out of time. I think the most common issue is your STEM OPT, or maybe you're on
Mm-hmm.
OPT and your degree didn't qualify for STEM. Um, the issue of maxing out on that time for work authorization. I think you have the option of moving up a degree level. So if
Mm-hmm.
maybe you have a bachelor's degree and you haven't pursued that master's, moving up to a master's. If you're from a master's, moving up to a PhD. So moving up a degree level, and then maybe thinking about pursuing CPT. I definitely would generally advise trying, if possible, to stay away from doing CPT at the same degree level that you've already completed OPT at. Those second master's ideals, where people, they already have a degree from school X and they go to school Y, um, and they're at the same degree level. I definitely, in the past, have seen pushback from USCIS regarding maintenance of F1 status when someone does that. So I would be careful for that. But if you are able to move up a degree level, I think that that's a good option. You have the spouse option, which we've talked about before, which is not applicable to
Yes, we
everyone.
did.
But if you have a partner that's on H1B, perhaps you move over to H4. You have an L1 partner, you move over to L2, you get that employment incident to status, and you're authorized to work. Other options that I kind of just had thought about because we had talked about this a bit on Wednesday, the L1.
Hmm.
So the L1 would definitely be something to consider if you are someone who's been registered in the lottery outside the United States and you haven't been selected. Now, you have to have that full year working abroad with a foreign employer, and the foreign employer has to have a qualifying relationship with the U.S. entity in order for you to be sponsored. Now, there's other qualifications. An L1A is for a manager, and L1B is for specialized knowledge. But at the outset, I look at first, is there a qualifying relationship between your current foreign employer and maybe the U.S. company that tried to sponsor you for that H1B that you weren't selected on? Right?
Hmm.
So if that's the case, and you've got that 1 year of continuous employment within the past 3 years, I would try to explore the option of looking for an L1. The specialized knowledge route that's going to be, based on what kind of intimate understanding you have of your organization and how it's applicable to moving over to work in the U.S. The manager is a little bit, L1A manager is a little, I don't want to say more hard line. Basically, my way to say it for this is the L1A manager is pretty like clear cut. Are you managing people? Like, are you managing individuals? Are you managing professional employees? There's also the option of a functional manager, which I'm not going to get into detail about. If you think about that as an option, schedule a consultation with an attorney so that you can really get into the nitty gritty of that. But that's an option too. And then I also would say the TN visa for people who
Hmm.
have Canadian or Mexican nationality or passports. That's another option that you can explore too for work authorization. For
Hmm.
the teams, for the Canadians, it's actually a pretty clear cut deal. They can actually apply right at the port of entry for TN status. They actually don't even have to go through the consulate. Whereas, unfortunately, if Mexico is the route you're going by, you are going to have to at least first schedule that appointment at the consulate. But that's another option based on your country of origin or your nationality. And that's pretty much all I can think of off the top of my head. We can get into details more later if we want about the E1 and E2, but I think those are even more nuanced options that
For sure.
require further analysis.
So true. And thank you so much, Justin, really for touching up again. And folks out there, I would really like to tell you at this moment that you should definitely check out our channel, Immigration and Jobs Talk Show, because we've had Justin and also Jonathan Wasden join us earlier, and we've discussed about the second lottery, what are the options, and even actually, Justin, we had an episode earlier, though it wasn't so clear because of our internet issues, technical issues, but we did discuss and definitely check them out as well. These webinars are very, very informative, and you might not want to miss out on them. All right.
Yeah.
So, right, Justin, we spoke about very important things last time. Yeah. So, now my next question for you is like, how critical is it for selected applicants to file their H1B petitions promptly? And what are the potential risks or delays or inaccuracies in the filing process? Are there any common pitfalls that they should avoid or can avoid?
Huh. Yeah. I mean, obviously, kind of as we touched on, it's very important that you file as expeditiously as quickly as possible to make sure that you're filing within that window and that your case is received by USCIS properly. Um,
Mhm.
the things to look out for are going to be rejections, obviously. So that's an instance where, for whatever reason, the case is rejected by USCIS. That's why I advise you try to file early. I know you have that 90-day window, but I would really say cut 2 weeks off that window and say this is your definitive deadline for filing, just in the event that you deal with a rejection. Um, Other things that I would probably look to avoid, your LCA needs to be correct. And what I mean by that is your LCA should properly reflect the actual work locations where you're going to be performing services. So if you are someone who is working at a client location, then that address
Mhm.
needs to be included on your LCA. If you're working at home, that address needs to be included on the LCA. It is important to make sure that your labor condition application is accurate, not only for when your case is being processed by USCIS, but later on down the road when you're looking into potential compliance issues with FDNS.
Hmm.
So for those who don't know, FDNS has the ability to investigate any petitions that have been approved by USCIS. This means that at any point, they could visit a work site and request information on what the employee's been doing, call a
Hmm.
supervisor, things of that nature. So you want to make sure all of that information is accurately reflected. The last two would definitely be, make sure that it's actually great to go back and kind of talk on this for a second. When you are selecting the SOC code, making sure that the person's the right position type, another important thing to consider is the wage. How much you're paying the individual and whether or not that wage is compliant.
Hmm.
So if you're paying, somebody to do work where they're managing a large group of people or maybe a large number of projects, and you say that it's an entry level position because you want to pay the level one wage, that's that's probably a red flag to USCIS because they're looking at the nature of what the person's doing and they're saying, how is this an entry level position? If this person is, a large scale manager, they should probably
Hmm.
be at a higher wage level based on that, maybe a level three or a level four. Um, so that's another thing to consider because that's definitely something that USCIS can come back on. I remember specifically in I believe it was the first year of the Trump administration, there was just a colossal influx of RFEs and related to the level one wage.
Hmm.
Specifically, that basically, all of these companies were just saying all these positions were entry level and then not bothering to do a real detailed analysis of what the people were doing in these positions.
Okay.
So you have to be able to defend that, you have to be able to defend what it is that you're putting in the petition. So the way that I like to look at it is this: every petition that I'm reviewing and submitting to USCIS, my thought process is always, what can the officer attack? What is it
Okay.
that's missing or deficient from this petition that would give them a justification to issue an RFE? And what can I do to make sure that that's not the case? I mean, the simple matter is sometimes there's not document X available. It's not there. Or, you've already filed the LCA and you're kind of, you need to get the case done because you're running out of time and you do a second look and you think, oh, maybe the wage level's on. You still have to put the case out and get it filed. But I would definitely say make sure you do your due diligence. And that really comes back to starting early. I mean, we know now who's been
Yes.
selected. You have plenty of time. You have about three
Right.
months to get these
3 months,
cases in.
90 days, right?
Right. So you really need to make sure that what you're doing is presenting the strongest petition possible.
So it's the correct time, friends, to go out there. If you don't have an attorney yet, go get one and do everything right. And just like Justin has mentioned, how can you be attacked and make sure that you will not be attacked. So make
Yeah.
sure that you don't get an RFE also for that matter.
Yeah, and I mean these are
All right.
these are incredibly important filings. I mean, the as we've learned from looking at the data from this year's lottery, it looks like there's a negative trend towards selection rate, meaning that
Yes.
the probability of you being selected in the lottery is trending downward right now. It's becoming more difficult for people to be selected based on the changes that have been made over the last couple of years, combined
Yeah.
probably with the negative impacts of the economy that are creating a less willingness for people to file. John and I had
Right.
talked about this last week. These increased fees. What is the impact of these increased fees on the
Hmm.
probability of companies continuing to want to file for new H1Bs? I'm not professing that I know the future, but it's logical to conclude that, like John said, as the amount something costs goes up, the demand for it is going to go down. So
Go down. Right.
those of you who have been selected this year, I mean, this is incredibly pivotal for you. You really, really, really need to do everything possible to ensure that you're able to get
Yes.
that case approved this year.
Yes. Make it count, friends. I mean, nobody just gets lucky in a lottery, so make it count. And also another thing is, if you should definitely go follow Wasden Immigration Litigation on LinkedIn for more updates on anything related to immigration. All right, so thank you so much, Justin, for taking that up. And yes, I think we should definitely move on to our audience out there. So Sam Dilton says, "Hi, Justin. And he has a question. Is it possible to apply for an O1 visa if I have extraordinary abilities in my field? Or if I have STEM education, wanted to check the options after being not selected in the lottery.
Okay. Yeah. So I think we've seen this question come up a couple times in regards to the O1. So the O1 can be a viable option for someone that is able to show extraordinary ability. It's a high bar, okay? That's a higher bar than there is for an H1B. It's a higher bar than there is for an L1. It's simply a much higher bar. Extraordinary ability is things like, you know, international acclaim, awards, research papers. You've judged competitions. You've worked
Mhm.
with distinguished companies. It's a very, very high bar. The factors are available on USCIS's website if you want to look at them. I will say that people in AI, because of recent changes made in the Biden administration, people who are working in AI now have a better chance filing for an O1 because the Biden administration has made it known this is something that they want. They want to retain international talent that is proficient at AI. So I would definitely say if that's the specific field that you're in, you
Mhm.
might want to look into speaking with an attorney about whether or not you qualify. Maybe you need to
Qualifying, yeah.
strategize. You need to look in and say, what actually am I missing and what do I need to do in order to eventually qualify for an O1 and begin taking those steps. I definitely
Mhm.
think that it's not easy to be a kid that goes straight out of college to an O1. I don't think that
Got it.
it's easy because you have to produce a lot of justified documentation to show that you qualify. Now, that being said, I've seen it happen. I've actually seen a case recently where someone got an O1 for their interactive work with artificial intelligence, and they had just come out of
Wow.
school. They had judged competitions while they were in school. They were very
Wow.
distinguished in their field. They had, written papers. They had worked for big, cutting edge AI company, and they were moving over to work for a new startup company that was going to be sponsoring them. And they were able to get an O1 approved. So it can be done, but you have to work with an attorney. It's I nothing short of insane to try to file an O1 on your own. They are so
Interesting.
document intensive and they have to comply so specifically with the rigorous requirements of USCIS that I would definitely say, make sure you do that. Make sure you work with an attorney that has
Right.
good experience doing O1s as well.
That's great. That's great. Thank you so much, Justin. But just in case, I mean, Sam, not to, I mean, discourage you or anything, but just in case if Sam doesn't qualify for an O1, what other option does he have?
Well, I mean, if he's on the F1 and he's hopefully taken advantage, obviously, of his OPT and that STEM OPT. We've talked about a little bit about the options that people have moving up a degree level if they have the ability to do so. So
Hmm.
moving up from that bachelor's to master's, that master's to a PhD if they have the ability to do so. And then you're probably looking at maybe working with a cap exempt employer as well. That could even be twofold if you're trying to build your docket up for an O1. Maybe you can go work with a research, a government research organization that is going to allow you to produce work product that can later be used to justify the qualifications for an O1. So
Okay.
I would probably explore those options and see if there's anything that's available to you.
I was thinking you'll say P3 or something because when I think about O1, it's mostly like artists and extraordinary people who are really world famous and stuff like that.
Mhm.
So, but
You know,
yeah,
it's surprising, but that is true. The O1 is that very high threshold, but I've definitely seen people get O1s that no one has heard of unless they're working within that industry. My favorite
true.
case that I've done for an O1 was someone who extraordinary ability in marketing. Someone that had worked on a
Oh,
bunch of very interesting campaigns for some big clients.
wow.
Can't say their names, obviously, but really big. And it was actually very cool to work on because in the moment I actually
Sure.
learned, oh, well, that's who made that
Mm.
commercial. That's the commercial for, or company A that you see on
Oh,
TV all the time or on the internet all the time. This person's the one who put everything in place. They came up with the idea. They helped hire.
wow.
Yeah. So what I mean by that to say is that yes, the O1 is for distinguished and talented individuals, but it's really going to be in the field that you're looking at. So just because you're someone that doesn't have a Nobel Prize, that's the I think the easiest go to. You have a Nobel Prize, or you're an O1 because you won an Olympic medal. Like, yeah, those are going to be pretty clear cut O1s. But there are ways to qualify for an O1 outside of those kind of clear cut options.
Okay, thank you. Thank you so much. That was very well explained, and I'm sure, Sam, you have more clarity on how to go about this now. Moving on, let's take up this next one. This is from Nishant asking, my OPT stem is expiring December 21st, 2024. I am on a full time with a banking client. They
Mhm.
have confirmed that I was not shortlisted. What are my options? And I don't want to move to CPT.
I mean, you're kind of putting yourself in a situation if you're taking CPT off the table, but it's understandable. I would say you have to. My first thing would be going up a degree level if you can. Would be the first thought process if you're trying to maintain work authorization, because that's probably going to be the easiest option for you. Outside of that, you kind of have to look at what's this person's nationality. Do they have the opportunity to maybe try for a TN as opposed to an H1B? Since they're not going to be able to qualify for that. You're not going to
Mhm.
be able to stay with that banking client if you're trying to move to a cap exempt H, because they're not going to qualify, I'm guessing. So really, I think what you're looking at is going up a degree level. And even if you don't want to do CPT, that's probably how you're going to maintain your work authorization. Because the only other real option for you is maybe seeing if you are qualifying for a TN. Maybe explore the E1 or E2 options. But if you're a student just coming out of school, I don't know if you're going to be able to meet those thresholds. So yeah, I'm sorry. I know you probably don't want to do CPT, but that might be your best pick if you're trying to stay with
Okay.
that client. The only other option, like just spitballing off the top of my head, would maybe be, are you open to working outside of the US for a year? And maybe, if the company has a foreign affiliate, can you go to Canada and work in Canada for a year? You're still staying in North America. You can work with that foreign affiliate for a year, and then maybe they can explore the option of doing an L1 for you. Or maybe you're working at a company in Mexico. So that's it. That's kind of all I got for you. Sorry you weren't picked, and it's probably not the answer you want, but it's the answer I have.
Thank you. And all the best, Nishant. Look for it and try and maybe give CPT a chance as well. Moving on, this is Pedo Drew. Hi, my H1B has not picked in the second lottery. Can we expect the lottery this year? And what is the current job market in the US? Can we expect any changes in the next year?
Okay, so first off, we've disclaimered this already about legal advice, but to further disclaimer, I'm not like a CNN analyst or something that has the ability to predict the economy. All I really know about is what happens with my retirement at this point. So yeah, I think it's very hard to be predictive of the job market. I mean, international things are going to impact that. As you can see, there's turmoil overseas in multiple areas where there's active conflict.
Right.
We don't know what's going to happen with that. We have no idea who's going to win the election. That's going to be another thing that could be outcome determinative for the economy and the job
Mhm.
market. Um, can we expect a third lottery this year, though? I think we may have touched on this a little bit previously. The problem with a third lottery is time. I just feel it's very difficult to think that USCIS is going to have time. This current filing window runs all the way up until November. I would assume they wait until it's pretty close to closing, if not closing, if they were going to make any sort of determination. And at that point, what do you do with a third lottery? I mean, are you picking people and telling them that they can file from November to March? Because then you're literally running into registration for next year. And so you
Right.
do have to
And
think. Yeah,
It's like we'll have
USCI.
the holiday period in between, like December,
Right.
January. I don't think people will work
Right.
at
You're
all.
dealing with office closures. This is a government entity. To think that they're going to be putting in overtime for this is ridiculous. Um,
Yes.
so no, I cannot realistically see there being a third lottery. But I will say the exact same thing I said last time. I hope I'm wrong. I would love to be incorrect and for there to be a third lottery. But I just looking at the factors don't think that that's going to happen. So
Right.
that's my input on that. And then about the job market, I have no idea, guys. I don't know. I have no idea. I mean, you've seen recent layoffs in the tech industry. We actually just saw layoffs in healthcare to an extent. There's some
Yeah.
hospitals down here in Texas that actually cut 5% of their staffs. I'm hoping there's not a recession because that never benefits anybody. I mean, that just makes everything more difficult for everyone. But we'll have to see what happens. We'll have to keep our fingers crossed and hope that things
Yes.
trend upwards.
True, true. And Peruju, I think, can we expect changes? Yes, we can always expect changes because that's the only thing that's constant. And
It's
let's hope for the
change.
best,
Yeah.
Peruju. Yes. All right, let's move on now to the next question we have. Let's take up Madhu. Nishant is continuing to say, my job
Yeah. So
required
that,
to stay in the
yeah,
US.
which I understand that takes off the L option for you. So it's just not, yeah, available to you. I'm sorry. So know, even though you're adverse to the idea of CPT, I do think if you're moving up a degree level that you're going to be in better shape. I would try not to engage in like a second master's or something like that.
Mhm. All right, I think we'll just take a quick break now, if that's fine, folks out there. You keep commenting, we'll take up your questions. And once again, I would like to say that please follow Wasden Immigration Litigation on LinkedIn for more immigration updates. And also don't forget to subscribe to Immigration and Jobs Talk Show on YouTube, Facebook, LinkedIn, and we would be happy to take up your questions as well. So also feel free to contact Justin, and his details are on the screen. All right. So you can contact Justin and definitely check out their website as well, wasden.law. And you can note down his phone number. His phone number is 844-592-7336. And you can mail him at support@wasden.law. Thank you so much. Let's go for a short break.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hey, sorry guys, I don't have any audio, so I'm not able to hear the
Control stepping
question.
in. You have no audio.
Very good.
Control stepping in. You have no audio.
All right. I hope you can
Now
hear
you
me,
are.
folks. Can you hear me?
Now good.
Now we
Okay.
now we got
So,
you.
yes, I think it's not a smooth webinar.
Control
We
Alt.
don't have any technical difficulties. But thank you so much letting me know. I hope I'm audible. And I'm very happy to welcome all you folks back to Immigration and Jobs Talk Show. We are streaming live on YouTube, LinkedIn, and Facebook. And thank you so much for all your questions so far. And wherever you're watching us, you can keep commenting because Justin is here to take up your answers. And today we're discussing of if you didn't get selected in the H1B cap lottery, what's next? What can you do? So I think let's take up more questions from the audience. That's fine. Let's take up Madhu. This is on YouTube. Madhu is asking, my application was shortlisted in the second lottery, but my L1B max out period is August 18, 2024. What are my options if I don't want to travel out of the country? That's like 9 days from now.
Yeah, I mean, file a change of status as quickly as possible. Just file a change of status to H1B, but the problem is your age can't take effect until 10/1. So even if you file prior to that timeline, you're going to have a dead period from when your current L1 maxes until the start date on that H1B. You will be in POSA bag, a period of stay authorized by the Attorney General. What that basically means is you've timely filed a valid change of status petition that gives you authorization to remain legally in the United States during its adjudication, but you're not going to be able to begin working until 10/1 because that's the threshold. That's the first date that you can actually be on H1B status for the fiscal year.
Okay. All the best, Madhu. And I'm sure, I hope you are able to make it on time.
Yeah, I
All
mean,
right.
the
So,
alternative to that is you consular process, and I know you don't want to leave, but you leave the United States, you wait till the H gets approved, you file for, you schedule a visa appointment abroad, and you go attend the visa interview, get your visa stamp, and come in. You should be able to, top of my head, I think it's like 90 days before the H kicks in that you can schedule a visa appointment. Please don't quote me on that. It could be 60. But you can go to the visa appointment before the start date on the H, and then I believe you can enter the United States up to 10 days prior to the start date of that validity period. So I know you don't want to leave, but you could leave for maybe a month and then come back in right before your H kicks and start working. So I don't think it'd be that big of a deal.
mhm.
The alternative is you hang out here for a little bit, and then you kind of wait and see what happens.
Okay. Thank you. Thank you for taking that up for Madhu, Justin.
Mm-hmm.
Now, this next question on the screen is from RK on YouTube. Are J visa options for tech workers and are the impact on future H1B and green card?
Okay, so yeah, I don't want to get too into the weeds with this. To be honest, if you're using a J visa or you've used if you're on a J visa and you're looking at H1B going into the lottery change status H1B, there are additional extra considerations that come in. There actually are even specific questions about the J visa contained within the I-129 because there are special requirements associated with that visa. But the thing about those requirements is they actually can even be tied to the country that the person comes from and or the work that the person is doing. So I would definitely say if you are using a J, you're going to need a little bit more extra work on your case than somebody who's moving from like an F or maybe an H4 where it's going to be more straightforward. So yeah, it plays a role definitely in the process. And so I would definitely make sure that you're working with an experienced attorney on that to make sure that they are able to properly determine your eligibility prior to filing.
Okay. Thank you so much for that, Justin. And well, there you go, RK. I hope you got your answer. Okay, moving on now. Do we? This one is from Rish. Since I wasn't selected in the lottery, I'm considering enrolling in another degree program to maintain my F1 status. Are there any risks of this strategy?
So
That's it.
the problem with this for me becomes enrolling for another degree program at the same degree level after you have utilized 12 months of OPT. The reason for that is USCIS seems to have taken the holding that if you utilize those 12 months of OPT at, let's say, the master's degree level, and then you go and apply for a second master's because you've maxed out your time and you want to engage in CPT. USCIS seems to have taken the holding that you're not supposed to be allowed to do that, or that it's a violation of F1 status to do that. So I would definitely say that in that situation, where you're making that determination, always try to go up a degree level, because if you don't go up a degree level, then you're going to be in a circumstance where if you end up getting to change status, where you get to go from file a change status from F1 to H1B, you could end up with a request for evidence showing that you have failed to maintain status. And that means that you could end up in a situation where your case gets approved without an I-94. And so in that circumstance where your case gets approved without an I-94, you are forced to go abroad, meaning you're not able to remain in the United States in order to activate that H1B. It's not going to change status for you on 10-1, and it's going to require you to go to the consulate for a visa interview. Now, where things get even more problematic in that circumstance is if you're attending a visa interview and you're found to have had a violation of your F1 status. That's possibly a question that's going to come up at the consulate. If that question comes up at the consulate and you don't answer truthfully, then you could be found inadmissible, meaning that they won't give you the visa stamp. They won't allow you to come into the United States. So all of that can be a direct effect of choosing to remain at the same degree level or go up a degree level. Basically, I would definitely say that's the risk associated. I would probably stay away from the second master's. I'm sorry, I'm starting to get close to wrap up time.
Sure.
So I would definitely say when you're looking at a second master's, just make sure that you realize that there is a possible penalty if you've utilized all that OPT time already at the same degree level.
Thank you. Thank you for taking that up. And I think this will give us to this last question, all right, from Drive. Hey, Justin, love your energy. I have a question actually. My current visa status allows me to stay in the US, but not to work. What are my legal options if I want to continue working without violating my status?
It's an interesting question. I mean, I think that'd be status, based. I mean, for example, what's the underlying non-immigrant status that you're currently on? So, if you're on an H4, you have the option of acquiring an EAD in the event that your spouse has that approved I-140. But if you're on, maybe say like a B2, a visitor visa or something like that, that doesn't permit work authorization, you have to change status to another non-immigrant status that carries with it work authorization. Yeah, I mean, don't ever perform unauthorized work. That would be the best advice I can give anyone. Don't perform unauthorized work, because you may think that you're getting away with it and not realize that the government is going to look at your entire record when you go to adjust status, if that's something you plan on doing in the future. And I cannot tell you, unfortunately, how many pitfalls I have seen where you're in a circumstance where, gosh forbid, you're adjusting status, you file the 485, and you get hit with, an accusation of a status violation or some sort of issue. Now, there are obviously ways you can overcome those certain issues. I'm not going to go into the nuances of that specifically, but the best thing you can do is present, a squeaky clean immigration record when you're going to file. So yeah, I mean, you have to move to another non-immigrant status. That's going to permit you work authorization. And if not, you have to continue to just live in the United States and not work. But again, it really does kind of depend on what your underlying status is.
All right. All right. So thank you so much, Justin. Is that it? Should we wrap up, or do you still have time for one more question, maybe?
I do apologize, but I'm pretty short on time. I did, if you guys
No
wanted to,
worries.
I did want to maybe see if we could touch on the updates that had gone on with USCIS just real quick, because I thought it was very
Sure.
interesting that they had actually, for the whole time I've been practicing, H1B ownership of a business has been something that people wonder about. it's tough when you're tied to, just one employer, and you can only work for that
Yes.
employer, and you're not capable, you're not able to start your own business.
Right. I
They've
had a
come back.
question, so it's there on the screen. I couldn't reach up
Oh,
to there, but there you go.
no
Yeah, go
worries.
on.
So I just wanted to touch base on that because it was something I had been looking at over the past couple of days that I thought was really interesting. Before, passive investment and ownership was basically the only route that you could go. So what that means is you could have ownership in a business, but you couldn't actively work in the business. It had to be passive investment only.
Yes.
Now it looks like you can have a controlling interest, and potentially qualify for an H1B with the employer that you own. Um, they're calling this beneficiary owner, which I think is an interesting
Interesting.
phrase. Something I've never heard
Very
before.
interesting.
But yeah, beneficiary
Yeah.
owner. The idea that you are the owner, basically your company sponsors you for an H1B. So
Yeah.
I thought that
How
that's
cool is that?
interesting. It's in its infancy. It's new. There right now there is regulation pending on the performance of non-specialty occupation work. So because I think you're going to get into a lot of weeds here with, beneficiary owner, are you performing specialty occupation work? How are you qualifying? What's the SOC code you're using? What wage are you being paid? I don't think you can be an entry level owner, or can you? I don't
Mhm.
know. So these are all like new and exciting things that I think are awesome. We love to hammer the agency when they do stuff wrong. So I do want to at least give them credit when they do something right. And I think that this is an awesome idea that's going to help innovation, and it's going to give H1B workers, particularly the people that are stuck in this backlog, it's going to
Yes.
give them opportunities to hopefully, explore their entrepreneurial abilities. Because I definitely think the best entrepreneurs in the world are typically immigrants. So giving them this
Okay.
opportunity is going to be colossal. I think it's great. We'll learn more about it, and maybe I can tell you guys updates as I learn them.
Sure, me too, me too. I'm looking for more updates, and maybe when we meet up next time, Justin will sure catch up more on this and maybe
Yeah.
have our folks more clarified with this new thing that's there now.
Hmm.
Um, yeah, thank you. Thank you so much, Justin. I won't hold you up much, but thank you so much for
No worries.
doing this. It was really lovely having you. I mean, for all your actionable advice as well, for all these folks who joined us with their questions and all these insights you had for us, these alternative visa options also, and the deep understanding we got today. So thank you so much once again on behalf of Immigration and Jobs Talk Show, and looking forward for another webinar maybe in the coming week.
Yeah, absolutely. Looking forward to speaking to you again. Thank you very much for your time.
Thank you, Justin. You too. Bye bye.
Mhm.
Have a great
Bye.
day. Have a happy weekend. Yeah.
You too.
Thank you, friends. You too, for joining us. It was really lovely having you join us with your questions. And as we wrap up today's session, really thank you all for your active participation and for making this a vibrant discussion. So, a huge thank you once again to none other than Justin Rivera for sharing such invaluable insights with us. And remember, even if the H1B lottery didn't work out this time, there's always paths forward, friends. So don't lose hope. Always stay positive and keep working hard. And we're here to guide you in every step of the way. So anything immigration related, feel free to contact us as well. And my details are on the screen. You can call me or WhatsApp me on this number, 408-335-6444. You can even email me, nipa@higheritpeople.com. And definitely to get to know more about us, check out our website, www.higheritpeople.com. Also, you can contact me if you're looking for project placements, H4, EADs, green cards, anything related to immigration. If you have any questions, feel free to drop me a mail or a message. Thank you so much, friends, for joining us today. And in case you're watching this webinar after the stream has ended, you can keep commenting your questions because we have our experts who will be more than happy to reach out to you with answers. So thank you. This is Napasa Pradhan signing off for now from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone, and welcome to Immigration and Jobs Talk Show. And before I move ahead, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rivera, your host, and today we are tackling a topic that is both timely and crucial for countless international students pursuing their dreams in the United States. Whether you are about to embark on your academic journey or you're already navigating life as an F1 student, this episode is one you cannot afford to miss. Well, imagine this. You have done everything right. Secured your F1 visa, packed your bags, and prepared yourself for an exciting future. But upon your arrival in the US, you're stopped at the airport, questioned, and before you know it, you're facing the possibility of being sent back home. This nightmare scenario is unfortunately a reality for some students who fall afoul of US immigration laws. So, what can you do to avoid falling into this trap? And also, what are some common pitfalls and how can you safeguard your future? To discuss about all this, we have today with us none other than litigation attorney Jonathan Wasden. So, without any further ado, let's welcome him once again to our show. John, welcome back once again to Immigration and Jobs Talk Show.
Good seeing you again.
Thank you so much. Likewise. And to our lovely viewers, I would like to tell you that we are live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any question that you would like to ask from John, so please keep commenting them in the comment section. Keep asking your questions. We'll be glad to take them. And now, John, before I talk about, today's topic, which is F1 students, how to avoid deportation. Before I talk about that, I also would like to ask you about the H1B second round of lottery, which was announced yesterday. So if you can, please provide a brief overview about the second H1B lottery announced by USCIS, and why do you think it was necessary?
Yeah, sure. So up until a few years ago, the way they ran the lottery was they would run everybody through the first round and then get to that 65,000 bachelor's cap. and then they would run the master's cap. So they flipped that, and now they run the master's cap first, and then they run the bachelor's cap. So this year, what happened is the master's cap was full after the first round of the lottery, but the bachelor's cap still was not full. They didn't have enough petitions filed after selection. So they're running the bachelor's cap again. Now, it's kind of a confusing way to phrase it, because the people with masters, PhDs, and bachelors all get run through the bachelor's cap all together. So it's for a master's degree or higher, it's really your third bite at the apple, and bachelor's, it's your second bite of the apple. So to me, the reasons for it, just they didn't get the volume of petitions that they needed to fully fill up their 85,000, and so they're going to redo the draft. It should happen relatively soon, because these visas have to be awarded prior to the end of the fiscal year, and that's September 30th. So I would anticipate we'd be seeing the new lottery in the next few weeks, maybe a month at the most, and then selection notices will be coming out then.
All right. So, and what about the applicants? I mean, what can they expect, and what is that they should be looking out for?
So just updates from USCIS about the lottery being run, and then checking their online account to see if they were selected.
Right. And now that the second lottery has been announced, do you think there's a possibility of also having a third lottery?
I don't think so. I think the second one will probably fill it up. I mean, we're already at August, so we've only got 2 months left in the fiscal year. So I don't know that we have actual time for a third lottery even. So I would expect this would be the last one.
Okay. All right. Thank you so much for answering the questions related to H1B second lottery, John. Now let's come to the topic that why we are here. To discuss the topic that we are here for, which is F1 students and how to avoid deportation. So my very first question about this topic is, so John, there has been a specific section of US immigration law, section 212A, 6 and C, that has been causing a lot of concern basically among the F1 students. So if you can please explain what section 212A, 6 C covers and why it's particularly relevant for F1 students.
Yeah, sure. The 6C finding is what the commonly referred to in immigration world is a fraud finding. It covers fraud or material misrepresentations that were knowingly made by the foreign national in an attempt to get an immigration benefit. So all of those things have to be met in order to substantiate a 6C finding. When USCIS makes a 6C finding in, say, a petition process, that's something that's very easy to challenge and take to court, because there's no protections for USCIS going to court. One of the most frustrating things, though, in immigration law is that the law makes decisions at the port of entry bulletproof to judicial attack. And so it's very frustrating, because you have very low information CBP officers making decisions on people's lives that have a far-reaching impact, and sometimes they're not doing it with all the best information or best motives at heart. So port of entry is an inherently dangerous situation for anybody coming to the country on a non-immigrant visa.
Okay. So, it sounds like this section covers some serious grounds on inadmissibility, right? So, So, how often do you see these cases where students are unaware that they violated the section? And do you think more awareness could prevent some of these issues in the future?
So it's really scary, because I've seen cases where the famous one was the Atlanta case a few months back, or maybe actually a year back now, where there was a group of students on a flight coming from India, right, and they all got stopped, sent to secondary, and sent home with fraud findings saying that their F1s were shams or frauds. These students many of them had evidence on their phones that they had acceptance letters from universities, they had paid for tuition, they had lined up housing, they had done everything in the world to show that they were actually going to school. But some yokel CBP officer decided that, that was fraud. Really, it's just a way to hassle people at the port of entry. I'm not a big fan of CBP. I don't think they do a great job, just full disclosure. And I think they have way too much power and authority for what they do and for the level of knowledge that they have. So it really comes down to protecting yourself from these low information government bureaucrats at the port of entry. One thing that we commonly see happen at the port of entry is your constitutional protections are lower at the port of entry inherently. So unlike a traffic stop or something like that where they need a warrant to search, the rules are more flexible at the port of entry. They can take your electronics, they can take your phone, they can go through your bags. So, you see oftentimes they'll go through somebody's phone, looking through all their old email accounts or WhatsApp messages, looking for anything that they can to, substantiate their theory of what's going on.
Right.
So, you got to ask yourself, is it worth it to carry your phone? Is it better to go without your portable brain for a couple of days, FedEx that to yourself, and then get it when you get here, instead of just exposing yourself to CBP rifling through your private information on your phone? So, that would probably be, something advisable if you're worried about this, just to FedEx your phone to yourself, just to avoid the potential problem that could happen.
Right, but what according to you should be their first step? Because, in a situation like this, when you have no clue about anything and your phones are taken away and, other things, mostly you are left with nothing, right? And you're in a country where you don't know what to do and whom to contact. So in a situation like this, what do you think the students should do?
So for F1s, I think it's important to know your contacts. People at the school that you've been dealing with have their phone numbers, have their emails, have their names. So when you're asked any questions, you can give that to CBP and they have somebody that they can contact to verify information. So I would take all of this just in a folder, just paper copies. That way you can just hand it over to the CBP people. Your acceptance letters for university, all of those types of things, proof that you've got housing lined up. All of that would be helpful to have in a tidy little folder that you can just hand over.
Right. Okay, thank you so much for answering the question, John. Also, John, I would like to know from you that what are some of the most common mistakes that F1 students might unintentionally make, that could lead to issues of fraud or misrepresentation under this section?
Sure. So there's maintenance of status issues, and then there's fraud issues.
Right.
What USCIS considers to be fraud, I think the biggest thing we're seeing right now is people that were scammed by fraudulent employers who were preying on recent college graduates with F1s, telling them that they were going to hire them, place them on a project, but you just need a little bit more training before they can put you on a project. And oh, by the way, we do the training and it's going to cost you. So that scheme is relatively common, or was more common recently. And anybody that was caught up with one of those companies, eventually at some point or time in the future, you're going to get, sent to secondary. You're going to have problems with, DHS with this issue. It might be at the State Department of the consulate, might be at the port of entry, but those fraudulent scam employers are the biggest threat probably right now that I see to people on an F1.
Mm-hmm, mm-hmm. And are there any support or help available for these students?
So you can request that you be able to call an attorney. Again, at the port of entry, your rights are very limited. if you do carry your cell phone, or if you do carry, a dummy phone or a burner phone with you through the airport,
Right.
I would just ask them if it's okay if you can record the conversation so that you have, make sure there's no language barriers or problems with understanding, so you have a clear record of actually what was said. If they have a problem with that, that lets you know you're not dealing with an honest officer. If somebody's afraid to be recorded, that's a red flag. The other thing that I would say is, excuse me, let me grab some water.
Sure.
Now I lost my train of thought. But yeah, I would say, ask them if you can record them. If they say no, be very suspicious of them at that point in time.
Right. Thank you so much for that great advice, John. And also, John, given how easily these mistakes can happen, so would you say these issues are mostly due to lack of understanding of the visa requirements, or are there other factors at play too?
So I think a lack of awareness on students' parts about, the scam employers is probably the biggest problem. USCIS didn't really help anybody out in this regard either, because they were aware of these scam companies out there. They had, identified them, they had blacklisted them and flagged them in the system, and then just waited for people to get caught in the scam. So, what a legitimate, law enforcement agency should do is alert the public that there's a problem out there and to be aware of it. But USCIS almost, fanned the flames here. They knew these companies were in existence. They didn't decertify them from E-Verify. They let people blindly walk into it and then held them accountable for the fraud that the company perpetrated. So, you gotta really advocate for yourself in these situations and really thoroughly vet anybody you're taking a job from to make sure there's no problems. As a general rule, I would say anybody that's asking for payment for training or a letter or anything, you should not only stay away from, but run away from.
Right. And any specific advice you would like to give these students to avoid these pitfalls? I mean, so that they don't get into these things. I mean, because
to the extent you can, I mean, social media is a great thing. To the extent you can, contact people that have worked there. Go off referrals from friends. Make sure that, if you're on STEM OPT, that you're following all the requirements for STEM OPT, or that company is actually following them. Because if you have a STEM OPT employer and you're not following the training plan or any of that, then if there's an RFE on whether or not you maintain status and you don't have that information, you're going to be in the world of hurt. And you will be found to have not maintained status because your employer wasn't documenting correctly. And then that'll mean you have to consular process. And as anybody knows, consular processing right now is a nightmare. It's, the number of 221Gs going out is just astronomical right now. So you want to avoid that as much as possible. So you really have to advocate. And if your employer is not complying with the rules, you should probably look for a new employer, and just to protect yourself, consider reporting it to DHS just so you have a documented history of saying, hey, there was a problem, it wasn't my fault, I'm finding a new employer. So you may have to be a little bit more proactive. Now, that said, if you're going to go that route, highly recommend talking with an attorney first and maybe having them do the letter and them do the correspondence for you, just to make sure that you're not inadvertently saying something that's going to hurt your future.
Right. And is there a way to also find the right attorney for such cases?
Again, word of mouth, people that you trust, just, Google reviews, just look for somebody that has experience in this area that you can trust.
Right. Also, John, so beyond misrepresentation, what are the other main reasons, international students might face deportation? And again, how can they avoid finding themselves in such situations?
So there's two different things. One is non-immigrant intent, and then the other is not having the right travel documents. The travel document one is, I think it's an A7. It's kind of disingenuous for them to give you an A7, because typically what they're saying is, you show up with a valid visa and the CBP officer says you don't have the required documents because we're revoking your visa, but they're revoking it because of A6 for the fraud finding. And so, you're getting an expedited removal and it's for not having documents, but really it's a lifetime bar because of the fraud finding. The maintenance of status issue is something we're starting to see more commonly recently, where they start, looking into whether or not you're going to be returning home at the end of your stay. We see it a lot on B2 visas, especially, but F1s as well. So they will, be constantly probing to see if your intent at the time you enter the US is to stay permanently, or if your intent is to finish your program and leave. And so, you just have to keep in mind what your non-immigrant intent is. One other thing before I forget, when you get pulled into secondary, if they're going to remove you, do a 235 removal, sometimes they will give you the option to withdraw your application for admission. If they ever give you that option, that is the best course of action to take, because that avoids having any bars against you from reapplying for admission. You can go to the consulate, you can do a trip report, you can try and fix whatever the problem is that CBP believes there was, and then reapply for admission. But if you get that expedited removal, it's much, much harder to get back into the country.
Right. And also, it is said that the visa officers also see your intentions. What are your intentions? So how can the student, show their correct intentions to the visa officers?
So for the students, it's a tough one, right? Because you're young, you don't own a home, you don't, have a lot of substantial business ties or anything like that. Yeah. So it's tough. You just have to, say the truth. You're just coming to get an education. This is the best place for it. And, you probably will, look for OPT to get experience to solidify your education. For the B2s, what we typically see them looking for is, proof that you have a residence in India that you're going to return to. Again, if you're younger, that's going to be tough to do, because if you're going to be gone for 6 months, you may not maintain an apartment. So, those are the types of things that they're looking for. Again, the system is set up to give CBP a lot of discretion on what they decide. And it really comes down to the eye of the beholder. What does that individual CBP officer think or want to find? And so, that's why I said earlier, if you can record them or request to record them, if they say no, you're not dealing with an honest broker. You're dealing with somebody that wants to just find the facts to support their assumptions.
Right.
Along those lines, a lot of times they'll have you do a written statement, or what they'll do is they'll interview you. They will type up a summary of the statement, and then they'll put your signature on it. They get your signature electronically before the beginning of that interview. And then they affix your signature to that written statement after the interview without letting you see that written statement. And that becomes the official record. So I would not sign anything when you go into that secondary. If they give you that digital signature pad, I wouldn't sign it. I'd say I'll wait until I see a written statement before I sign anything, because I want to make sure it's accurate, and demand that you see that written statement before you sign it. Read through and make sure it's accurate. Make annotations to it if it's wrong. So you really have to be assertive. You really have to protect yourself and advocate for yourself in that situation.
Right. Thank you so much for such great tips, John. Also, I would like to discuss, about this case. I think I don't know if this was the same case that you were also mentioning about the 33 students who were deported at the USA Chicago airport on January 15th this year, 2024. So, this incident has understandably caused a lot of concern. So, how can such cases be prevented in the future?
So the biggest things that I would say is never go through Chicago. Chicago's CBP is notorious. They
Okay.
are, without question, the worst airport in the world to travel through for abusive law enforcement tactics.
And why is that?
It has to do with leadership for that particular office would be my guess, but it's been bad. I think the people that are working there just have a bias, and it's just someplace I would avoid like the plague if I could. So I would make your port of entry someplace, someplace other than that, or Atlanta. Atlanta's also got an overly aggressive CBP office that, they shoot first and ask questions later, so to speak. So I'd avoid those two places as your first line of defense. Even if it means taking a few extra hours to get to your destination, it's probably worth it.
Okay, and what role can universities and immigration advisors play in preventing these unfortunate events?
So that's a frustrating question because some of these people, I talked with some of those students, and there is nothing in the world, there is no more information that they could have possibly had or presented to that officer to show that they were a legit student, that they were going to be engaged in a program of study, and everything lined up, all their documentation lined up, but it didn't matter. They just, did the expedited removal and said, you're not coming here to study, and sent them away. These are people right at the beginning of master's programs, these at legit universities, like University of Chicago, some of them, like very, very solid, well-known, reputable colleges. And they had paid tuition, but it didn't matter. They had housing lined up, it didn't matter. So for those people, it's frustrating because there is nothing in the world they could have done to alter the outcome other than possibly change the airport that they flew through.
Right. Okay, and also I would like to take a moment to also discuss about when students first enter the US. So how do these immigration officials at the port of entry determine if an F1 student is inadmissible under Section 212, AC6? So, and what are the key factors? Are there any key factors they consider doing this?
So there's a database that's called the
Okay.
Consular Consolidated Database. And the Department of State, the consulate, can upload information to it and access information. CBP can access the information and upload to it, as well as USCIS. For the OPT scam employers, what they're doing is USCIS is identifying who is associated with these companies. They're going through their records, they're matching up, they rated the companies, they took their list of employees, and then they started matching up names. And so then they uploaded that to the CCD, that database. Now, some of these people stayed in the country, got H1Bs, extensions of H1Bs multiple times, and never heard a word from USCIS that there was a problem with their OPT experience. It's not until they go to the consulate or they go to the port of entry that they learn about this. Because the first thing that happens at both the consulate and the port of entry is they get your biometrics and they pull up your file in the CCD. And if there's any flags or any hits in the system, you're immediately going to the secondary, or you're getting focused and attention. And USCIS is flagging people in the system and then waiting for them to go to the port of entry or go for stamping at the consulate, and that's where they're hitting problems. That's the very first thing that happens is they notice that flag and they're pulled in.
Right. And let's say that if the immigration officer suspects something is wrong, then what happens next? And how can In a situation like that, how can the student respond during that moment? That can impact their situation.
Yeah, so the first thing to remember, if you get pulled into secondary, by and large, these people are bullies. They are basically mini little Trumps working around and just trying to throw their weight around in their authority. And so it is not uncommon at all for them to try and bully you, intimidate you, yell and scream at you, keep presenting you with a scenario of facts that they believe and demand that you agree with them. And if you don't agree with them, for them to lose their temper and basically throw a tantrum like a toddler. So just be aware that that is their MO, that's their process that they go through. And when it happens, don't get flustered. Just stay calm, disagree with them where you need to. Again, ask for recording and refuse to sign anything, because if they're throwing a tantrum like that and making wild accusations, their summary of your conversation is not likely to be accurate.
Do you have a case, where something similar happened that you would like to discuss with us and the audiences?
Yeah, I mean that's such a common scenario where you get pulled into secondary and somebody starts yelling and screaming at you and accusing you of having done something wrong.
Right.
And no matter what you say, no matter what evidence you bring, in support of yourself, they keep on screaming. It's almost like they have a quota of people that they have to reject at the board of entry. So they're, maybe at the end of the month, you see this happen more as they're hitting their time for their quota. But, it happens all the time. Like I say, some airports are worse than others. But it's not exactly the way you'd want a reputable government agency to behave, but it's how they operate.
Right. All right. Thank you so much for answering the questions, John. And I can see people have started commenting their questions. So I would like to take a couple of them from the audiences. Okay, let's take maybe Ramesh's. So Ramesh is here and he says, I know this session is for F1, but related to H1B fiscal year 2023. My petition was revoked and back to India. What are my chances to secure my cap number back where there no fault of mine and issues for fiscal year 2025? What do you have to say, John?
So this is an issue we've been suing USCIS on, and we're not at the end of the process yet, but so far the signs are positive. What we're trying to do is, for people in that situation, is to recapture their cap number that they initially were assigned. Now, when we first started suing USCIS, what was happening was people would be going to the consulate for a new visa category, and they were told that they had a fraud finding applied against them based on their employer's multiple registrations. And so that was game over. They had a fraud finding in the system. We started suing and challenging that issue, and USCIS almost immediately realized that they were doing it wrong, and they changed their policy and the way that they were handling that situation. So now if you're the employee who was the subject of a multiple registration, you are no longer getting penalized by USCIS. And that's a huge change, and that's a huge benefit to you. So what that means is, on future H1B lotteries, it shouldn't have any impact on your ability to get a visa.
Right. And he also has a second part. He says, my H1B petition for fiscal 2023 was revoked due to multiple registrations. Even though I wasn't involved, I had returned to India. What are my chances of getting a cap number for 2025? Any advice?
Yeah, there's not going to be anything, ideally nothing that is going to follow you or impact you from that multiple selection. If you get an RFE on it, we should talk and strategize for how to respond to that, because USCIS is on record in all kinds of court documents saying that they will not penalize the employee for the employer's alleged misconduct. So, it shouldn't have any impact on your 2025 petition. I think you should be fine there.
Right. Okay. So, Ramesh, you don't have to worry. And yes, thank you so much for your question. Let us know if you have a follow up or if you'd like to know an answer to another question. Thank you so much for posting your question. Let's quickly take RK's question also. So, RK is here and he says, is there any truth that attorneys litigated against USCIS asking employers proof having a project before approved because few employers use not requiring to show proof to take a genuine cab and bench their workers while looking for a project while genuine students miss out? We know it's wrong what they are doing, but last chance students are losing out.
The structure of the H1B lottery system is very flawed, I guess, to say it in a very kind way. The lottery is held in March. And if you're working for a staffing company, the industry standard for a lot of these companies is to operate on 6-month projects. So the best case scenario is if you get selected, you get approved, and the stars line up and you get a visa stamp and you're able to enter the country by the beginning of that visa period, you're already past 6 months. And so it's almost impossible to have a project that's guaranteed at the time they file your registration. And really, no employer in the world is going to sign a legally binding contract for an employee to work at a client site when they don't even know the outcome of the lottery yet. And so it's really impossible to have that project requirement. And more importantly, that's just not my view of it. It's what the law says that Congress created. So the Congress, when they created the H1B restructuring, what they said is that you can legally bench people, but you have to pay them while benched. And so that's the protection, that's the trade-off, is that employers can take that risk. But once you're in the country and available for work, if they're not paying you, they have a substantial legal liability. And so that's the system is flawed, but that's the best remedy that people have. I think his question is really going more towards the people that were selected in the lottery still in India and are not able to get visas. That's a tough one, because if the employer doesn't have a project and they are not going to bring you, there's not much you can do there. But it's really more a flaw in the system than it is in the employers doing something wrong.
Right. He also has one more question. I would like to read that out. He says, how is it that they selected 130K with a 20K for the master cab, which was filed, for the remaining 110K, they weren't able to get 65K. Does this indicate employers just registering applicants?
Yeah, probably. There's a gap there. They registered, then business situations change. We're now, like 5 months past the initial lottery. A lot changes in 5 months. If you look at the tech industry, there's a lot of layoffs going on. And I think the rate of filing petitions kind of tracks the greater tech industry in general. So as the tech industry is shedding jobs, there's really not a need for those H1Bs you'd anticipated coming into the country and working on H1B. So, a lot of things in the business world can change and impact filing rates. And I think that's probably what we're seeing here.
Right. Thank you so much, RK, for your question. I hope you've got the answer. We still have a lot of questions from the viewers, John. But before I take them, I would like to go for a short break. And after the break, I would like to take these questions from the viewers, if that's okay to you.
Sure.
All right, so guys, it's time to go for a short break, but you guys don't go anywhere because post the break, we are going to take up questions from you. So, yes, keep on watching Immigration and Jobs Talk Show and stay tuned with us.
Consultant seeking a new opportunity? We offer job placement. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm your host, Rajni Parana, and today I'm here with none other than immigration litigation attorney Jonathan Wasden. And today we are discussing about F1 students, how to avoid deportation. And yes, we are getting questions from you. So now, without any further ado, let me take another question. So the next question that we have is from Vishwa Das. Let's take Vishwa's question. He says, currently on F1 visa and my program end date is in 2 months. However, I need more time to complete my thesis. Can I apply for a program extension? And if so, what documentation do I need to provide?
So if you're still working on your program, theoretically, you should be able to get an extension of that. Now, the caveat being is you got to know your limitations. My limitation is I don't file these petitions. Yeah, I litigate on the fraud findings, I litigate on denied petitions, and kind of try and fix things that were broken in the process after the fact. So I would say talk to an immigration attorney that actually files this type of petition, because they're going to have standard formats that they've done this 1,000 times, and they can run you through it, and they can give you that information, and they can line up your package to make it as strong as possible to get what you need done.
Right. Okay. So Vishwa, I hope you've got the answer. Thank you so much for your question. Let us know if you have another one. Meanwhile, let's take Imran's question. So Imran says, I am on F1 visa and got married to a US citizen. Can I apply for a change of status to a spouse visa, CR2, or do I need to leave the US and apply for CR1 visa?
So if you're married to a US citizen, you would be looking to adjust status, and you should be able to do that while you're here in the country. So, I don't know that you would need to leave the country. Again, the caveat being I don't file these. It's not my area that I practice in on a regular basis, the family petitions. But my understanding is you can stay in the country while you make that application.
Okay, and he also has a part two, John. He says, what are the benefits and drawbacks of each option? and what are the required documents and filing fees?
So if given a chance, seeking immigration benefits for marriage to a U.S. citizen is always your top choice. There's really no easier or better way to get that. Now, with U.S. citizens marrying foreign nationals, there's a lot of scrutiny that they give your application. They look for evidence or indicators of marriage fraud, things like that. So you're really going to want to go through and just show that the marriage is bona fide, and probably pictures of dating time, pictures of weddings, lists of who was at the wedding, things like that, just to show that this was a legit marriage and it's not just for the purpose of getting immigration benefits. Signs of cohabitation, shared utility bills, shared leases, shared addresses. Just anything that shows that you are a married couple is going to be very useful for your application. And the filing fees, like I said, I don't file these, so I don't know off the top of my head what the filing fees are. But you can just Google that on USCIS's website and it'll pop right up.
Right. So you can check that out on USCIS website, Imran. And thank you for your question. Let us know if you have another part or a follow-up or maybe another question for John. Let's take Dipesh's question in the meanwhile. And he says, I have received an RFE on my F1 visa application stating that my bank statement doesn't show sufficient funds. However, I have since deposited more money into my bank account. Can I submit an updated bank statement or do I need to reapply entirely?
So if you haven't replied to the RFE yet, you can provide the new bank statement. If you've already replied to the RFE, you can try and do a supplemental. A lot of times USCIS will not accept the supplemental filing, but you can try. There's nothing that says you can't do it. So, I would say if you're past the point where you're outside that window of the normal reply time, maybe reapplying would be the way to go.
Right. So, Dipesh, I think, like John said, you should reapply then. Then Paul is also here, and Paul says, I was on F1 visa and worked part-time for 6 months without authorization. I have since stopped working and want to apply for OPT. Can I apply for OPT or will my unauthorized work impact my eligibility?
If USCIS knows about the unauthorized employment, it will definitely be a problem. And that is one thing that they are, when they have that information, they don't always have it. A lot of times there's no way for them to know. But if they have that information, it's definitely going to be a problem for you. Unauthorized employment as a student can, create a 3-year bar to re-entry into the U.S. So it definitely will be an issue. My guess is if they have any information about that, they'll be giving you an RFE or an NOID. And so you'll be responding to that.
Right. So, Paul, thanks so much for your question. I hope you have got the answer. Ramesh's question, I think we already have taken. Vishwa's question also, I think we already took. RK also, I think we already have taken. Alok is also here, and he says, I have been on F1 visa for 6 years and have completed 2 master's degree. I want to apply for a PhD program, but I'm concerned about the impact on my F1 status. Can I apply for a 3rd degree on an F1 visa, or do I need to change my status to an H1B or J1 visa? What are the rules and regulations regarding F1 status and multiple degrees?
So typically as long as you're advancing, making progress up the educational ladder, you should be fine. So a PhD, it's kind of a natural progression. You go from bachelor's, master's, PhD. So I wouldn't expect that to be a problem for you. I would expect if you filed for a 3rd master's degree to get a lot of scrutiny in the application process. But for the PhD program, I think you're fine. But if you have the option of an H1, why not go for that and then do your PhD in part-time. The one thing I will caution about PhD programs is just make sure that it's from a legit university, because they have a list at USCIS of colleges that are suspect, and degree mills, things like that, places that only exist to issue CPT. And you don't want to be involved with one of those colleges. You want to be with a no kidding university that has a PhD program that has some legitimacy.
Right. But John, is there a reason behind the lot of scrutiny that you said?
Sorry, say again?
So is there a particular reason about the scrutiny that you mentioned?
Yeah, because it questions whether or not you're really looking to get an education, or if you're just really trying to stick around to work. And so if the immigration agency looks at it as you're just trying to game the system to work, they will inquire further into your application.
Right. Thank you so much for answering the question. And Alok, thank you so much for your question. Let us know if you have another follow-up or maybe another question. Meanwhile, Biraj is also here, and he says, I'm on F1 visa and was recently arrested for a DUI. Will this affect my F1 status, and can I still apply for OPT or a green card in the future? Okay, let's
So
take
so it could impact your F1 status.
Mm-hmm.
So typically the way these things work is your arrest record gets reported to DHS. DHS uploads that to the consular consolidated database, you're flagged. Then it goes to the consulate, and the consulate decides whether or not to revoke your F1 visa. If they send you an email, and I would keep an eye on your spam folder, I would keep an eye on your email inbox. If they send you an email contacting you saying that your F1 is revoked, what that means is you don't have to leave the country right away. You just won't be able to come back into the country once you leave. So it shouldn't be, a problem for finishing your program. I doubt it's something that will come up in the OPT process. They could RFE on it, but it's not one of the things that they would typically, focus in on an OPT.
Okay, and he also has a second part, and he says, what are the potential consequences of a criminal record on my immigration status?
Yeah. So, the real problem is going to be going for stamping, or whether or not you maintain, if they're going to find that to be some type of violation of your non-immigrant status. USCIS may deny a change of status or an extension of status. Probably not the most likely outcome. The most likely scenario is going to the consulate, and the consulate making a decision on you because of your criminal, conviction for DUI.
Right. Okay, so Biraj, thank you so much for your question. I hope you have got the answer. Malika Arjun Rao is also here. Let's take his question. So he says, I am currently on an F1 visa and want to transfer to a different university. Can I transfer my service record to the new university, or do I need to apply for a new F1 visa?
So again, limitations are I don't file these, but I believe you can transfer to a new university without having to file a new F1 visa. So, talk with your DSO, the designated school officer, or the DSO. They know this process backwards and forwards. So, get an appointment to go in and speak with them about how to do that. Now, if you're transferring universities, again, the caution I give everybody on F1 is make sure the university you're going to is not a degree mill. It's not a CPT mill. It's a legit university that's offering legit course of studies, that it's reputable. And that's, very important for avoiding problems in the future.
Right. And he also, again, has a second part, and he says, what are the requirements and procedures for transferring my service record?
Yeah, again, you want to talk to your DSO, and the DSO will be able to walk you through that whole process.
Okay, so Mallikarjun, I hope you have got the answer to all your questions. Thank you so much for posting them in the comment section. And John, I also have questions from the viewers actually on my WhatsApp. So let me quickly read these questions. I'm so sorry, I'm taking a bit time. Okay, so here it is. The question is, will I be deported if I say that I'm staying at my friend's place because the university is close to his locality?
You mean, I guess they're asking if when they're coming through the port of entry, if they're asking where they're living. That wouldn't necessarily be a deal breaker. But if you have a lease or you have some type of documentation of where you're going to be living, that would be best. If you have some type of agreement with your friend to split costs, if you can get that in writing, that would be a great piece of information to have. But just staying at a friend's place isn't going to be a deal breaker. People have roommates all the time, so.
Okay, all right. Thank you so much for answering the question also, John. And again, okay, so I have one more question for you. And this question is actually from a guy, and he says, I already got my F1 visa, but just after, where is it? I already got my F1 visa, but just after it was issued, my I-130 filed by my stepmother got approved. Will this be a problem at immigration?
I've never seen that scenario come up. It shouldn't be. Although typically when you have an immigrant visa petition and a non-immigrant visa petition, they focus on your non-immigrant intent. What are you going to do? I don't know how long the wait period is, for a I-130 in this situation, but you're just going to want to make clear that at the end of your F1 program that you plan to return back home until your priority date's current. You can get a visa on the 130. And that's really going to be the issue. What is your non-immigrant intent coming in on the F1?
Right, and I also have one more question, and the question is, where is it? Okay, what should I do if my F1 visa got revoked and I received a 5-year ban? Can I go to the USA for my studies again?
So it really depends on why it was revoked. If it was revoked with a fraud finding, no. You're going to have to deal with that fraud finding before you can get another visa. If you're still within that 5-year ban window, you're going to have to, get a waiver for that, or figure out a way around that. But if it's not for fraud and you're outside that 5-year period, theoretically you should be fine. Now, when you go for stamping, or you go for, the port of entry, they may ask you questions about it, and you just have to, answer that as best as you can. I'd say consult with a, immigration attorney before you go to the consulate or before you go to the port of entry, just to get some, pointers on what the questions will be based on your specific facts, and how best to answer that based on your history.
Right, and these are some questions posted in some groups, so we try to look for these questions also. And one more question, one last question for this episode. I got my USA visa on 12th January, and I'm going to the University of South Dakota in July. I have paid my enrollment deposit and first semester fee, and all my documents are legit. However, I'm afraid due to the recent news about deportation involving students from South Dakota. Any suggestions?
So I hadn't heard about students in South Dakota facing issues. My first suggestion would be buy the warmest clothes you can possibly find, because South Dakota is the coldest place I've ever been. In terms of documentation, same rules apply. Just make sure that you've got proof that you can pay for the tuition, or you have paid for the tuition. You've got housing lined up. Correspondence back and forth between the school if you've got it. have a contact at the school that can vouch for you and say, yes, they're coming. Yes, I've been discussing with them. Just make sure that you have all of your bases covered when you go through the port of entry. And again, Chicago might be convenient to South Dakota for port of entry, but I would avoid it. I would look for a different place to go as your initial stop in the U.S.
Right, right. Okay, so John, one last question before I let you go. Any last feedback or any last suggestion for the F1 students, who might be worried about their deportation at the moment?
Yeah, so I would say you have to be your biggest advocate. You have to be assertive, and you have to look out for your future. So, when it comes to picking a university or a college for a program, make sure they're legit. Make sure they're reputable. They're offering real courses of study, and it's not just a degree mill. When we're talking about post-employment on OPT, make sure that they're following the rules. The employer's following the rules. Watch out for people that are asking to, receive money for you to work for them. Avoid those types of situations and make sure. There are worse things than being unemployed and having to return back home because you don't have a job. And that worst thing is never being able to come back into the U.S. again if they find you have committed immigration fraud. So, be very, very careful with your choices on F1, and you've got to protect yourself that way.
Right, right. Thank you so much again, John, for coming and doing the show. It was, again, a great, great episode. And to our lovely viewers, I would like to say that if you want to get in touch with John, so you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. You can email him at support@wasden.law. Is that right, John?
Correct, yes.
Yeah. And you can also visit his website, which is wasden.law. So you can also check that out. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1 732 9151. My email is rajni@higheritpeople.com. And our website is www.higheritpeople.com. Remember, we sponsor H1B visas and other work visas based on job availability and regulations. All right. With that, thank you so much again, John. Hoping to see you next week with another great episode and great topic.
It's good being with you. Thank you.
Thank you so much. And to our lovely viewers, thank you so much again for turning in such huge numbers and continuously posting your questions, asking your questions. It really means a lot. If you like the episode, don't forget to like it, share it, and also comment down below. And yes, keep watching and keep subscribing to Immigration and Jobs Talk Show. We have 2 more webinars coming up at 12 and 2, so don't forget to check that out. And for now, I will have to take your leave too, and I'll be meeting with you soon. But yes, for now, I'm Rajni Bharara signing off. You guys take care and keep on subscribing.
Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone, and welcome back once again to Immigration and Jobs Talk Show. I'm feeling great to be here today on a Friday and looking ahead for a very, very long weekend. But before we get to all that excitement, I would like to tell you that I'm Nipasa Pradhan and I'm going to be your host for today for an hour or so from now. And I'm thrilled to have you join us, whether you're watching us on YouTube, LinkedIn, Facebook. Thank you so much for joining. And let me tell you that this is going to be a very participative session as well. So feel free to put your questions in the comments and
Oh no.
you agree and understand that the information, including comments and replies from users, is not legal advice. Use of information is at your own risk. So thank you once again, friends. Thank you for joining us. And yes, this is Immigration and Jobs Talk Show. And I think without further ado, like I was telling you, we're going to have a very intriguing session today as well. So our topic for today is curious about H1B visas. So if you have any questions about H1Bs, you are on the right path, on the right track, because we are going to have our guest join us today, none other than attorney Justin Rivera. Please help me welcome him back here. How are you doing, Justin? Thank you so much for joining us.
I'm doing all right. The weather's a little bad here, so I'm just giving you a heads up. So if there's any connectivity issues or anything like that, it's because of there's a thunderstorm rolling through right now. But hopefully that doesn't create any problems. But other than that, I'm having a great Friday.
Me too. And I'm excited for the long weekend.
Hmm. Absolutely.
All right. Yes, yes. And so, Justin, dear friends, he is an employment based immigration attorney. And, he has been working with Wasden Immigration and Litigation. So, how has it been so far, Justin, with
It's
Wasden?
It's been great. I think finally settling into the role, which is nice, and really enjoying it. Working on different cases from what I used to work on at my former employer, so it's nice to see a bit of variation, and everything's different. At least I feel like I get a lot of different kinds of cases to work on, and I'm enjoying that. And I'm enjoying the challenge.
Great, great. So good to have you here today as well. And I'm looking forward for this whole intriguing session full of exciting discussions and I'm sure questions also. So let me tell you that this is an Ask Me Anything session. So friends out there, you can ask Attorney Justin Rivera anything that you have, especially with regard to the topic, and that is H1B visas. So before we dive into the discussion, it's important to also acknowledge the latest updates in the immigration world. So, Justin, maybe if you have anything to give out before we start off with the questions.
Yeah, I mean, not a whole lot, and for me at least, I would just, I mean, just kind of speaking on what I've been working on recently. I've definitely seen quite a few issues coming up with people's STEM OPT applications, with issues with violations of their OPT status at their former employers. So, obviously you need to be cognizant of those 90 days of unemployment for your OPT status and how failing to adhere to that can render you ineligible for the STEM OPT extension. I've been seeing a couple of those cases come in. And a couple other things I've been working on, just generally speaking, and really this actually kind of ties into the H1B stuff today. So I very recently saw someone, and I think that this is important to discuss because they were actually all the way at the end of their immigration journey, where they're scheduling the I-485, where they're attending their I-485 interview, and during that interview, they actually ended up telling admitting, because it's what happened, the officer, that they had actually been working from home. And the issue with that was that home address was not covered on the labor condition application. It was not in the LCA, and it unfortunately was not in the same what's called metropolitan statistical area, meaning that it was not technically permissible employment. So this person, they didn't realize it. I mean, this person was completely guiltless. They never got a copy of their LCA from their employer. And they never realized that their end client, when authorizing them to work from home, had not talked to the employer about it. So this person had been working for years, 4 years, a full H1B and an extension, not realizing that they were completely violating the LCA. And so they go for their I-485 interview, and they ended up getting a notice of intent to deny on their I-485 based on the idea that they had violated their H-1B status for a period of more than 180 days. And it's crazy to think about. Imagine you wait all that time in that backlog to get to this point. And, the process can be messed up as a result of a mistake that you didn't even realize was a mistake. And so that was just something that really makes me think that we need to do a better job of ensuring that the non-immigrants here in the U.S. that are going to be on H-1B status, that they are aware of these pitfalls, of these issues that could occur. So, always you're entitled to a copy of your labor condition application as a right. Failure to do so is failure to comply with DOL by the employer. So always make sure that you have a copy of your LCA if you're an H-1B employee, and make sure that you are working in the area that you say you are, because it can come back to bite you. This person had no idea this was going to be a problem for them. They were just saying what they've been doing for the last few years, and now they're staring down the barrel of a notice of intent to deny that adjustment of status.
It's crazy. And you deal with all these sorts of complicated cases very regularly, Justin. So I wonder, what do you do, to keep yourself sane, mentally? Apart from your own life and everything, you also have these things to solve. So what do you do?
Just long walks with my dog.
That's lovely.
It's a way to think.
Discuss your cases with him?
Yes, we frequently discuss the cases, my dog and I.
That's sweet. That's sweet. Well, friends, this is an Ask Me Anything session, and the topic today is curious about H-1B visas. So I think, Justin, I am ready. Are you ready to take up questions?
Sure. Yeah, absolutely. I know we're on a tight schedule, so.
All right. So we have Priya with the first question on YouTube. Hi. While booking for H-1B visa stamping, I answered no for a question whether I held any previous visa other than B1 or B2, which should have been yes. For this, I was not given Dropbox option, but the portal took me to interview option and I was able to book one. I know that it's not possible to change it in the application now. Is there any way I can write to the consulate of this mistake, or will it be a problem while going for an interview for this wrong answer?
So I think if you want to be super careful, what you can do is fill out another DS-160, and just fill out and bring another DS-160 and explain that you're correcting a mistake in a prior submission. I think that's being as careful as possible. Consulates can vary based on what they want someone to do, so you can also try contacting the consulate first. But I definitely think that I think that the safest thing to do would be just go ahead and do another DS-160, correct the error, bring it with you to the interview, and admit it up front that you made a mistake on a selection of something, and then say, here, it was my fault, here's this. And then that's all. Because I really don't think it's that big of a deal, especially if you're admitting up front that there was a mistake that you made in the DS-160. I don't think it's necessary. Don't cancel the appointment and make a new one just based on that, because then you're paying the fees again and everything. So I definitely think that would be the easiest course of action. Just submit a new or take a new DS-160 to the interview, because I don't think they'll let you submit it.
Okay, but it's always important to update, it's good that you are admitting the mistake, and updating it as immediately, I think, is always good. That way you're safe no matter what.
Yeah, and it's a B1, B2 visa doesn't carry work authorization with it or anything, so I wouldn't think it's that big of a deal. But at the same time, you do want to be upfront. Consulates are different, but for the most part, the consulates I've dealt with, the officers aren't there to get you. to put you in a situation where they're going to give you a 221G or deny you.
Okay.
They're more so just looking to figure out whether or not you qualify and that you've answered truthfully. So I think it goes a long way to just admitting the mistake up front and then providing a new document to replace the old one.
Cool. So Priya, thank you for your question. I hope you got your answer. And thank you so much, Justin, for taking that out. We have short. What does the student studying on USA on F1 visa require to convert the visa from F1 to H1B visas? Is that the question?
So I think that if I could kind of generally spin this in like, what is it that you should look for if you're an F1 going to H1B? I think for the most part, that's going to be people who've been selected in the lottery. So if you're selected in the lottery and your petitioner's filing an H1B for you, they file it one of two ways. They can either do change of status or consular notification. So change of status is going to mean that you convert to that H1B status on 10/1 typically, because that's going to be the first date of eligibility for the status. When you file a change of status, that means that sorry, emails. When you file a change of status, that means that your time spent in your current non-immigrant status is going to be reviewed. And so what that means is if USCIS determines that there has been a violation of that status, then your change of status can be denied. Now, the change of status being denied means you can no longer change status to H1B. You now have to depart the United States, go abroad, attend a visa interview, and come back in with an H1B stamp. So it does mean that you need to look out for certain things. If you're on F1 and you're on OPT, you need to look at your unemployment dates to make sure that it hasn't exceeded the threshold, which I believe is 90. And then when you go into STEM OPT, it's a larger number. Don't quote me exactly. I believe it's 120. But you need to look out for those dates because if you have violated that, then you may want to consider filing consular notification rather than risking your change of status being denied and carrying with it any penalty as a result. That's usually the big hurdle that I've seen for F1 change of status. The other thing that I have definitely seen is the day one CPT issue. And just kind of generally touching on that, that's where someone will maybe have exhausted their OPT and they enroll for a second major maybe at another university. There's a lot of universities that I won't specifically name, but I feel they're definitely on a list of day one CPT schools. They're kind of, if I remember right, in Kentucky or around that area. But there are schools that kind of seem like they're day one CPT hubs. So when that comes up, if you're a day one CPT person who's at the same degree level, you might see an RFE where USCIS alleges that you violated status because you shouldn't be doing CPT after OPT at that same degree level. So those are two issues I think that you would need to look at when you're filing your change of status. Hopefully you're working with an immigration attorney that's well-versed and is able to pick up on those issues at that time so that they can maybe advise you against filing a change of status. So I know that people sometimes want to hedge and file a change of status and see if they get an RFE and then maybe try to convert to consular notification then. I've seen that work. I've seen it not work. It's really just dependent on what your risk threshold is. I would always say, the safest course of action is the one that carries with it the highest probability of a positive outcome. So I would probably lean towards just doing whatever's the safest. But each person's different and you're going to look at those factors. I think that was a very long-winded answer, but I did my best to kind of make an answer out of that.
You did cover, and I'm sure, short, that was very helpful. Please comment if you have more questions, and even if that was something you resonated, please comment. It'll be good to know. Moving on, let's go on to the next question we have. This is Akash. I have a query regarding attending H1B visa interview for the 2024-25 round. Currently, I live and work in Germany, so can I attend the interview from here and the stamping done, or shall I have to visit my home country? Also, for dependent stamping, which would which would be the preferred one, and what are the pros and cons for getting done together or separately?
Okay, so I think as a general rule of thumb, the easiest place to go for your visa interview is your home country. Almost always. It's going to be the easiest, the most simplistic course of action is going to be going through your home country. Now, is it possible to go through another country? Yeah, it typically is and they're likely going to let you schedule an appointment. Um,
Mhm.
Third party national, so someone who's not a citizen of that country, they may be kind of put at the back of the queue for scheduling purposes. So you may see an issue when you try to schedule an appointment that it's going to take you much longer than it would in your home country. But
Okay.
you can do it. Now, what is the pitfall of it? The only risk or the scary idea is if your visa gets denied, right? And if you're stuck in
Mhm.
that country and it's not your home country. I assume this individual who's living and working in Germany, they're authorized to be there. They have a German work visa or something. I don't know German immigration, so I won't speak to it. But their
Mhm.
pitfall would probably not be as big a deal. I think the people who I always recommend going to your home country for are people who are maybe like, I'm visiting country X and I'm going to go for my visa appointment. And it's like, all right, well, if you get denied, what are you going to do? Are you going to end up stuck in that country? So I would say,
Mm.
yeah, you can schedule. I always recommend doing everyone's appointments together. I don't recommend separating people's appointments. Just get it all done at the same time. I don't
Okay.
know if it's a psychological thing or what, but I just feel like when you bring your dependents with you to the appointment, you kind of show, I don't know, maybe the officer's going to be a little more like, oh, okay, inclined to approve that person. So yeah, I mean, I would do them together when you can. I just really don't see a reason not to. Um, uh,
Mhm.
if you have to do them separately, it's possible. Obviously, you've got to get your H done first before your dependents. So I would think you'd have to take that into account during scheduling. But yeah, if you can all go together, just all go together. It's much easier to do it. Now, that being said, there are some countries that actually allow people to not bring children that are a certain age, under a certain age. The children are not actually required to attend the appointment. So I would look at the instructions on your visa appointment to see if your kids might qualify for not having to actually physically appear, and you can just bring their passports with you.
So cool. So,
Mhm.
Akash, I hope you figure out, and thank you so much, Justin, for taking that up for Akash.
Mhm.
Let's move on now to this next question we have from Shruti on YouTube. She's asking for a friend. H1 was filed by current employer. A job is not directly related to the major of study. Would there be any issue during H1 transfers?
Yeah, I mean it it all depends on the officer
So,
reviewing the case. Um, but if you have a position that has not had what I like to call a nexus tied between the employment and the degree of the individual. There's no connective tissue
okay.
there. Um, when that's not apparent, then you can get what's called a beneficiary qualifications RFE. So that's going to be a
Okay.
request for evidence from the service where they're basically asking, how does this person qualify for the position based on their degree? Um,
Mm-hmm.
Hopefully you've sussed this out at the outset as a possible issue. The first thing I would recommend, if possible, is look at the actual specific courses taken by the individual and maybe try to explain how those courses give the person the qualifications for the position. Perhaps the position is a hybrid, something that
Mm-hmm.
crosses different fields, IT and accounting,
Maybe.
business and science, something like that. So that's one way you can tackle it. Another way is what's called a combo eval. So that's where you're looking at
Mm-hmm.
combining education and employment experience into an
Okay.
evaluation that shows that the person has, based on the combination of their academic experience and their real life work experience, they have the equivalency of a degree that's in a relevant field. Um,
Mm-hmm.
Usually for that, you're probably looking at it really depends on the case, not to be too specific, but you'd like to have 3 years of work experience, I think, traditionally. Sometimes you may even need as much as 6 based on what the degree is. Again, that employment's going to need to make sense too. It's going to need to be rationally related to what the person's doing. When you
Yes.
request the evaluation, you should have experience letters from an authorized representative of the company who's willing to speak to not only the position and the duration that you held the position, but also, if possible, explain maybe the job duties or projects that you worked on. Because really what you don't want to do is allow the officer who's reviewing the case to look at that
Mhm.
evidence that's supplied and be able to poke holes in it and say, well, this is, you said you worked 3 years at Google. You have a letter with a sentence that says this guy worked at Google. What was his position? How long was he there? What were his job duties? Who was his supervisor? There's all
Yeah.
these things that they could look at. And you have to understand, with the H1B, once there were the third party placement memos, once those got revoked, which, just for a quick understanding of that, is, there were memos that came out during the Trump administration saying, if you work at a third party, you got to show proof of contracts, employer, all this stuff, right? When those got revoked, it really kind of made it to where USCIS can only look at, for an H1B, the H1B position. Does it qualify as a specialty occupation? And the beneficiary's qualifications. Does the employee qualify? So they're going to look at those hard, because it's really all they can poke holes in at this point. So again, I would definitely say, look into getting an eval. Some employers like to wait and see if the case gets approved. That way they don't have to worry about getting an eval unless there's a request for evidence. That's an option. I like to present the strongest case possible up front to minimize the cost of an RFE. I think most firms probably operate in the same vein, where the filing is probably less than the RFE, because the RFE is going to be more tedious and time consuming. So I would say, look into getting that eval. I do definitely think that if you're working with an immigration attorney, that's going to be identified prior to filing. I mean, it's not likely that they're going to be surprised when they get the RFE that your degree in business management did not qualify you to be a data scientist. So that's it really. Those are really your only 2 courses of action, and then hopefully one of them works. If you don't have that requisite, I'm sorry, my nose is itching. If you don't have that requisite work experience, you're gonna have to try and tie your education. And if you have a master's and a bachelor's degree, you utilize the totality of it. Pull everything out of both of those degrees to create that nexus, and hope for the best with USCIS.
All the best, Shruti. And thank you for your question. Thank you, Justin, for taking that up.
Sure.
Now, this next one is from Mahinder, also on YouTube. I am a Canadian PR and Indian citizen, but my H1B got picked and approved. Do I need to travel to India to get it stamped from US consulate office, or can I look for an appointment in Canada's US embassy, say Toronto, Vancouver, Ottawa? Also, I have USA visitor visa. Can I travel to USA on a visitor visa next month and do a change of status to H1B after October 1st?
So I wouldn't recommend the second course of action, just generally speaking. I would, since you're outside the US, I would just go ahead and get your H1B visa stamp taken care of. The same issue I think that comes up with the individual who's in Germany, I think applies here to the Canadian as well. I would see if you can schedule a visa appointment in Canada, and if possible, see if you're able to schedule one. I think you should be able to. And then I would just go to your appointment in Canada. My one thing would be, I'm not super familiar with the wait times there, and I don't know if there's going to be a difference for you as a result between how long it takes to get an appointment in Canada versus in your home country. So I would just look at that. But I think I would just go ahead and try and schedule a visa appointment in Canada and see if you can get it done. Unfortunately, what's frustrating about scheduling your visa appointments is you can't look at the schedule until after you pay, which has always annoyed me, because it's very frustrating to be like, no, you have to put the money down and then we'll open the books and show you how long you got to wait for your appointment. I always feel like you should be able to look beforehand, but I don't think they're going to be making that. They're going to be making that change anytime soon.
Seeing is believing, they say. And
Right. Well, I mean, because you want to ideally be able to forum shop. Like, if you think about it, if you're somebody who's stuck in Canada, if you're like, oh, in Canada, it takes 5 months to do a visa appointment. In India, it's in 2 months. Then I'll just schedule it in India and pop over there. But it puts you in a situation where you have to pay the fee in Canada to see those appointments. And then you have to pay the fee in India to see those appointments, because you also have to factor in that all of these consulates in different countries are operating on different websites. Like, you're not really using the same universal system. And just to give you guys a peek behind the curtain, as someone who did a lot of visa appointment scheduling over the past year, I have no problem saying that India has the absolute worst one.
okay.
I'm sorry, you guys have the worst website for visa appointment scheduling. I have never struggled more with getting kicked out, with having things not go through, than I do with that website. It is just atrocious. It is horrible. Anyway,
I really hope
that's.
they have some good updates and upgrades. Yes, that's much
Oh, I
needed.
mean, they
But
knock it down for maintenance like every 2 weeks, or at least it used to feel like it when I was scheduling visa appointments. It felt like they kicked it for maintenance every 2 weeks. You couldn't do anything for 4 or 5 hours because they were working on it, and then you'd go in and it
that's
would be just
disappointing.
as. Yeah, it's very fresh. Like, the idea that if you're from India, you have to deal with a lackluster website just by virtue of that being your home country. It just frustrates me. I remember scheduling for people in South America, like Brazil, Argentina, Mexico, 15, 20 minutes to schedule an appointment, if that.
Okay.
Versus
How long do you take for India?
sometimes an hour and a half. Because it's just, you get kicked, your information doesn't save, and it's just so frustrating. I don't get why there's not uniformity to it, and everyone just doesn't have the exact same type of system. But anyway, that's my rant for today.
Well, we'll take that, but I do hope that, there will be good upgrades very soon. And Mahinder, I would like to say that, sorry about that, Mike. I would like to say that, you can contact Attorney Justin Rivera directly as well if you want to have a one-on-one with him. Why not
Sure.
call him instead? And you can call him on this number. You can note it down. 844-592-7336. That is his number. You can even email Justin at support@wasden.law, and definitely go visit wasden.law to get to know more about Justin Rivera and, of course, Wasden Immigration and Litigation. Well, Justin, now I think we should move on to another question from our audience. Let's take
Mhm.
up Rahul. I'm seeking clarification on H4 visa travel regulations. A family member's spouse is in India with an H1B visa, while their wife is also in India with an H4 visa. They both recently traveled to India for urgent matters, but now the wife wishes to return to the United States alone. Can she travel back to the US on her H4 visa independently without her husband's accompaniment since he remains in India?
So there's a heightened level of risk in that you typically want the primary to travel with the dependent, or the primary to already be physically present in the United States. So I definitely think that there's an added risk to that. Is it impossible? It shouldn't be, but I do think that you need to take extra steps from a documentation standpoint. So what does that mean? I would go so far as to carry a copy of the spouse's H1B approval notice, maybe even a copy of their petition, and maybe even an updated letter from their employer stating that he is coming to work imminently in the United States, but he's not able to be in the United States right now due to X, urgent family matter, business matter outside the country, something like that. So I would do that just to make absolutely sure that you're okay with coming back, especially if they've come in and out of the U.S. already a couple times, then it's easier. But if it's a first entry on a new H4, then you really should have the primary with you. And if not, take all those extra steps and hope for the best. If you want to be as conservative as possible, though, I would travel together.
Great. So, Rahul, I think definitely they should travel together. Thank you for your question. And thank you, Justin, for taking that up. I think it's time now to take a short break, Justin, if that's okay with you as well.
That'd be great. Thank you.
All right. So, friends, don't go anywhere. Today, we are discussing if you are curious to get to know more about H1B visas, drop your questions. It's an Ask Me Anything session, and we'll be right back after this short break. So, don't go anywhere. Stay with us on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone. Welcome back once again to Immigration and Jobs Talk Show. And this is the second half of the webinar we are having right now on this topic. If you're curious about H1B visas, get your questions answered by the attorney, who is none other than our guest for today, Attorney Justin Rivera. Thank you so much for joining us all the way from Wasden Immigration Litigation. And friends, it's lovely to have you here with your questions as well. It's been interactive, and you can keep commenting wherever you're watching. We are streaming live on YouTube, LinkedIn, and Facebook, and it's been great having your questions. So recently, we've seen an increase in RFEs and NOIDs or NOIDs for H1B applications, especially in the wake of the heightened scrutiny under the current administration as well. So, but then also we also have the new fiscal year that's coming up starting October 1st. So a lot of you may have questions, and before we start off, maybe Justin, do you want to say anything on that too?
Yeah, I would love to if you wouldn't mind giving me a soapbox. So yeah, a lot of you are going to be changing status on 10-1 to H1B. That carries with it different requirements and conditions than you're used to probably on your old status, which I know for a lot of you is F1. Maybe it was something else. But I would definitely say for those of you that are going to be moving over to H1B, make sure, like I said, kind of at the top of the call, that your work is in compliance with your labor condition application. Make sure you're working where you're supposed to be working. Make sure that if you move work sites, that you inform your employer, or your employer, speaks with you. You guys come to an agreement, and you make sure that you guys determine whether or not you need to file an amendment. A lot of factors go into whether or not an amendment should be filed, all the way from the work location to the wage level to the SOC code. So there's a whole bunch of new considerations that you're going to need to deal with as a result of moving to H1B. But for the most part, it's a smooth transition. You should start off right there on October 1st in H1B status. It's never too early to start thinking about perm, if that's something that you're thinking about once you max out at that 6 years. So I would definitely take that into consideration too. Once you're starting working. Another thing, just kind of generally speaking, on that kind of has come up over the past couple of years that I see in things like consultations and stuff like that. Sorry, my email is absolutely blowing up right now. I apologize. Something I do see come up, transfers, H1B, change of employers. Sometimes you join an employer and you start working with them on H1, and it's a couple weeks in and it's not what you wanted or expected, and you think, can I move employers? You can transfer, but just remember, if you're transferring and you just started an H1B, you have to show that you maintained status. And typically to do that, you have to be able to provide pay stubs. So I always recommend at least having 2 to 3 pay stubs available when you move employers. So I would definitely say be cognizant of that in the event that you start working with your H1B employer and you don't like the situation and you want to move. Is it possible to change employers sooner, than the 2 to 3 pay stubs? Maybe, but I wouldn't take the risk if you don't have to. And so that's kind of the things that I think about most often is those quick change of employers, maintaining H1B status, and then just making sure that you're in compliance with your LCA. Making sure, again, that you're working where you're supposed to be working, performing the duties that you're supposed to be performing, and being paid the correct wage. Obviously, the point of that labor condition application is to ensure that you're being paid with what you're supposed to be being paid based on the type of job you're doing and where you're working. If you're not being paid the wages you're supposed to be paid, you do have the option to report the issue to the Department of Labor, to the DOL, and the Wage and Hour Division can open an investigation as needed. Hopefully that's not the case for anybody, but it is something that can be explored, because obviously we don't want bad actors in the H-1B program. We don't want employers that are not paying people what they're supposed to be paid or trying to circumvent the rules.
So true, so true. So thank you so much, Justin, for the update. And also, like friends, I'm sure you also have questions. So, and if these changes are going to impact your H1B status or your plans to apply, you might as well ask your questions because we're going to be here for some more time. And yes, we are discussing about H1B visas. So I think quickly we will take up this next question now from Shri. Uh, Shri is asking, I'm currently in India as my H1B 6 years maxed out, term awaited. Company will be filing 7th year extension next week. Question is, can we file H4 EAD with 7th year extension from outside the United States of America?
I don't think you can file an H4 EAD without an I-140, and it doesn't sound like you have an I-140.
Okay. So do you
That's it.
have an I-140, Shri? Tell us
It doesn't
about
sound like it if his perm's pending.
it.
So no.
So does he have any options?
Not for an EAD for his spouse. He has to wait for the I-140, his I-140 to be approved.
Okay.
So I mean, it needs to be
We need
filed.
to get that done.
Mhm.
Thank you, Justin. Now this next one is from Imran, also on YouTube. I raised FOIA request. USCIS conducted search for I-129 document and didn't find it. They provided me a note saying no records found. My H-1B got approved recently on April 25th, 2024. I requested them to provide I-129 and I-797. I provided my receipt number and they replied they can't find any documents. Does it mean my employer provided me someone else's receipt number?
I have no idea, man.
Crazy,
I
right?
mean, look, what it sounds like is your employer just gave you a receipt number. There should be receipt notices. You should have received a receipt notice, and if your H-1B was approved, you should have received an approval notice. If you don't have those things and they weren't supplied to you by your employer, I don't know, man. They may have not filed an H-1B for you in the first place. Yeah, absolutely. That seems very nefarious. And especially if you're claiming that you submitted a FOIA request and the government wasn't able to turn over that information because they're saying it doesn't exist. I've gotten FOIAs back where they'll redact portions of information saying, they can't provide this for this reason, this reason, this reason. But I don't think I've ever seen somebody come back and say, we just flat out can't find this record. Yeah, man, that's a new one for me for sure. And I definitely think, sorry, I don't mean to laugh, but it's so ludicrous to me that the employer would have given you a fake receipt number or the receipt number of another person. That seems bizarre. But yeah, I would definitely say if you didn't get a copy of your receipt notice or your approval notice, I would be very worried about whether or not you have work authorization right now or whether or not you're in the correct status if you're in the country. And if you're out of the country, I would wonder whether or not your employer actually filed for you in the first place. I think I would love to know more facts about this because, if this is someone who registered in the cap, can they show that you had a registration notice that was selected? Was there, do they even have the ability to produce that to show that they even registered for you in the first place? And then I would go, if they can't even produce that, no, they never filed anything for you. So yeah, that's wild. I mean, what's crazy about that is, I guess I'm kind of just spitting like hypotheticals. I mean, why would you do this? Maybe you have this person working on F1 status on OPT or STEM OPT, and you want to keep them employed. And you're claiming you're filing for them, but then you didn't really. But to take that lie and extrapolate it out to the point where you're giving them another person's receipt notice is bizarre. That's a case of first impression for me. I have never heard of an employer doing that before.
Imran, I would say it's a little unfortunate right now, your situation, but I think you should go do a thorough investigation, find out all these things which Justin just mentioned and
It sounds like
see
he
if it's
tried.
really, yes.
I mean, if they're, just from my experience, if you're coming back saying your employer's not providing you anything and you did a FOIA request and they're claiming that there are no records available, then that's why I would say, have you tried putting the receipt number into the My USCIS case status, maybe, and seeing if that's an option? That would be my thought process. I don't know.
Okay, Imran, maybe we need more information about you. You could tell us more, or better
No,
even just contact
send an
attorney.
email.
Yes,
Yeah,
best
send an
best to
email.
send an
That's
email.
such a nuanced case that I wouldn't even want to discuss that in more detail on the call.
There you go. So please mail him at support@wasden.law. Thank you for your question, by the way. All right, let's move on now to this next one. This is from Ishwar. Okay, from Drive 10. Hi, Justin. Do you think the court ruling allowing H1B spouses to work could hurt American workers? What's your take on this concern?
I've heard that idea, that posited the idea that allowing H4 EADs can be harmful to the U.S. job market because the H1B visa has more stringent requirements. You have to go through a lottery. You have to have a specific degree type. All this stuff. But H1B, it's a different burden. And H4 EAD you can do anything with it. An H4 EAD, you can be self-employed. You can go work for a business. You can open your own company, whatever. I don't think that the H4 EAD is harmful. I actually think that, first off, you're not just entitled to an H4 EAD. The H1B holder has to get an approved I-140 first. So there's already hurdles that exist. I think I've talked about it before here, but I will once again tell the story of someone who I actually had a case for, who was Canadian, and he and his spouse were going to come to the U.S. He had been selected in the lottery and got his H1B approved. And once he found out his wife was not entitled to work just on the H4, they actually didn't come. They ended up staying in Canada and working because his spouse made more money than him. So it literally didn't make sense for them to come to the United States. They would have harmed themselves financially by coming to the U.S. So I actually think that it can be a hindrance to not permit that immediate work authorization. You look at it as opposed to the L1, the L2 dependent spouse for the spouse, the visa carries with it automatic work authorization upon entry. You're able to just begin working once you come into the country. It's incident to status. So I think that there are already kind of like hurdles in place to even get the H4 EAD in the first place. I just don't see how it can be that problematic for the U.S. economy, for American workers. I can understand some of the argument. The whole point is the H-1B is governed by a labor condition application. The LCA exists to make sure that people aren't working on low wages replacing U.S. jobs, right? And then the H-4 EAD doesn't have that on it. But I think that it's important to ensure that there's an avenue to employment for people's spouses, because if there isn't, you're going to have like situations like my case where you have people from other countries who don't come to the US because then they don't have that opportunity for their spouse to work. And so, and I think you want to keep, my opinion of immigration has always been, you want to keep people here that have utilized the institutions here. People that have come in here and gone to school here and gotten education here, I think you want to keep them here, because what's the point of educating them if you're not going to utilize what they've learned, and put them into the job market and put them into the labor force? I really don't think it should be harmful. Do I think it will limit opportunities and raise anti-immigrant sentiment? I don't. Sorry, I'm looking at his follow-up statement. I really just don't think. I really don't think that the H4 EAD is the end-all, be-all on which people are willing to die on, as to whether or not they are anti-immigrant. I think it's something people maybe can point to if that's an issue that they have with legal immigration. But overall, I don't think that somebody is. I don't think. Long story short, the H4 EAD is a good thing. I think it's a benefit. I think it's a way to keep people here in the United States while they wait in a backlog when their I-140 is approved, while they wait for the opportunity to adjust status, as an avenue for them and their partner to continue working in the United States. I don't think a country like America, that was founded on the ideals of having a competitive workforce, having a melting pot of people, I don't think that there's any problem created by that just because you're letting an H1B holder's wife work. I really don't see the drawback in it whatsoever.
Thank you so much, Drive, for your questions, and I hope you got your answers. Thank you, Justin, for elaborately taking that up as well and answering to Drive.
It's okay. I mean, I think about it because I started practicing immigration law about 2016, 2017, around that time, and I think during that time, I have almost on a yearly basis seen some sort of animus exist towards the H4 EAD. And I just don't see the logic in it. I think it's ridiculous. I think, well, what is the alternative? You would rather that person's spouse not be able to work in the United States? They're already living here. Why not give them an opportunity to contribute to the workforce? I'm sorry. I'm done with that. All right. Sorry.
That's cool. But thank you so much for your answers and for elaborately explaining every situation. So, Drive, thank you for that interesting question. Let's move on now to this next one we have. This is from Galela. ISM on L1B expiring on September 2025. I got H1B selection and opted for consular for change of status. Can I request start date on 1st January 2025?
I'm sorry. I don't think I understand that question.
I
Because
am
first
on
off,
L1B.
if your L1B is maxing, then your H1B is not going to work because, well, no, because you could have that extra 1 year. So you could have 1 year left. Okay. Change of status for same company. Okay. Yeah, sorry, I'm a little confused by this question. I'm going to take it in the way in which I think it is going to be, which is where you're trying to kind of use that extra 1 year for the H going from the L1B to the H1B. If you were selected in the lottery, your first date on H1, I believe, is 10/1. If you're changing status. I don't think you can delay the change of status, but at the same time, I could be wrong. I've never seen that happen. I don't think it will. I think if you were trying to delay your H1B time, you should have filed consular notification and then, leave the US, go get a visa stamp, and then come back in because you're trying to maximize that time in H1B status, if that's what you're saying. So yeah, I think you're going to be changing on 10/1, but you know what? I could be wrong. That's not something I've tried before. So, don't quote me on it.
Okay. Galela, all the best. And if you have more questions, I think it would be best to email Justin. You can mail him at support@wasden.law.
Yeah, please.
Right,
I mean, if I could look into it more, it'd be great. Might be able to give a better response.
Yes, for sure. And now the next question we should take up is from Anabia. What are the consequences of a layoff or job termination for an H1B visa holder? And what are the options for maintaining legal status?
Yeah, this is a great question. It comes up a lot. Unfortunately, layoffs do happen, terminations do happen. In that circumstance, with the H1B visa, you have options. It's not an immediate issue where you're immediately out of status.
Okay.
The regulations allow for 60 days to either change status, find a new employer in H1B status, or depart the United States. Now, I do want to give a caveat to that because I don't think that this is explained enough. That 60
Mhm.
days, it depends on how much time is left on what's called your I-94. It's
Okay.
either your I-94's expiration date or 60 days, whichever is longer. So what I mean by that
Okay.
is because I had a case recently that I was looking into where the person was terminated on, I believe, August 17th or 18th. And they were
Mhm.
talking about using the 60-day grace period. And I realized their I-94 was actually only good till the end of September. So
Okay.
they had less time than they realized. But traditionally, best case scenario, you get the full 60 days because you've got time left on the I-94. So that's where you have the opportunity to look for new employment, change status to another status, or depart. Best case
Mhm.
scenario typically is you find a new employer. You have them file the H-1B for you. Again, always factoring in that it takes 7 days for a labor condition application to certify. So being cognizant of that and realizing, like I tell everyone, 60 days is really 50 days because you need to bake in time to get that case
Yes.
filed and receipted by USCIS. So you have that period. Sorry, you have that grace period to use, but remember that it's shorter than you think it is. The other option, changing status. You can change maybe to a dependent status if you have a spouse that's on maybe an H1 or an L1, an F1. You have those dependent statuses as an option. The other
Mhm.
options are moving to F1 as well. You could also maybe look into, if you have to, filing a B2 extension to give you more time to maybe try and locate an employer. You will get into a messy situation where you're going to have to file,
Okay.
change your status to B2, change your status back to H1B. And you basically ask the service to adjudicate those in tandem, to approve and then approve, but it's always at the discretion of the service. You could see a situation where the service denies the adjudication of the B2 to H1 because the B2 hasn't been adjudicated yet, and maybe you end up having to go abroad to actually utilize the H1B. But
Mhm.
those are all options for you. I would, I think I've said before, if you're tiering them, I think at tier 1, you've got finding a new H1B employer. At tier 2, you've got changing status. And then at tier 3, you've got departing the United States. But at the
Mhm.
end of the day, even if you do have to depart the United States, you've already gone through the lottery and had an approved H1B. So you're
Mhm.
not having to deal with that. So you
Okay.
should have an easier time finding a new employer and coming back into the United States. The biggest thing I would say, do not violate status. Don't stay longer than you're entitled to, and don't perform unauthorized work.
Okay.
Those violations are serious violations that carry consequences, especially in the
Mhm.
future when you're applying for a visa abroad. But that's pretty much it. If you guys have more questions on that or a specific situation, please feel free to send an email. We can even go so far as to set up a consultation if needed.
Absolutely. So thank you, Anabia, and I hope that was very helpful. I like how you put it, Justin. Thank you for taking that up as well.
Mhm.
Now we have Megha. What are the implications for my immigration status and future work authorization? Okay, but she's telling us more about her. I am an H1B visa holder, and I've recently gotten married to a US citizen. Can I apply for a green card while still working on my H1B visa, or do I need to switch to a different visa category?
No, I think I don't see any problem with being on an H1B visa. That's fine. It's a dual intent visa. You can
Mhm.
you can have the intent to immigrate permanently on an H1B visa. So I don't think you have any issue whatsoever. I think it's a very common thing for people on H1Bs to get married to U.S. citizens. So yeah, I don't see any issues. If you want to file in the future. I think general with filing adjustment of status going for a green card. I try to tell people stay on your non-immigrant status, even if you get that EAD. It's just a rule of thumb. I like to think that just in case something bad happens, you don't marry yourself to the EAD. But anyway, I'm getting really into the weeds. Basically, I'm telling you, I don't think there should be any issues. I think you should be fine.
No issues, Meghna. You can go ahead. All the best. And now we'll take up, I think, Ishwar's question. We haven't taken that up. This is, I have a visa interview in Chennai in September 2024, and I will be traveling along with my 4-year-old kid. I don't have any friends or relatives in Chennai to take care of my kid. Can I take my 4-year-old who is a US citizen with me for the interview?
I mean, I think you would have to look at the rules that the consulates posited. There are definitely consulates that say they're not supposed to be kids below a certain age there. So that's all dependent on what the rules of the consulate are. I can't pretend to know the rules of every consulate. I definitely don't know Chennai's by heart. So I would just check. And I think even if there's, let's say hypothetically, there's a rule saying, you're not supposed to bring kids under a certain age, I would assume if you're able to contact the consulate, they might make an accommodation for you in the event that you have no other options. I mean, if you literally have no one else available to watch your child, then what's the alternative? You can't attend the visa interview. So I would say just talk to the consulate, try and work with them, see if there's a workaround if they say kids aren't permitted. As long as there's no rule that says kids aren't permitted, then I don't think there'd be an issue. But again, it's consulate specific. I've seen consulates say like you don't have to bring kids, and I've seen consulates where, if I remember right, the language is more akin to like don't bring people under age of whatever. You have to talk to the consulate specifically. Sorry. If I ever do learn the answer to that, I will share it on here though.
Okay.
Because
Thank you so
I
much,
might go
Justin,
look
for
at
that.
it. But yeah, just talk to the
Yeah,
consulate.
cool. Ishwar, thank you for your question. And Justin, thank you for taking that up. And we have Anavia, who you just answered, saying, thanks, Tony. Got my answer. Thank you, Anavia, once again. And Justin, I think we are coming to an end. We have taken up, I think, all the
Yeah,
questions from my audience as well. So we
I
should
think I'm
wrap up.
talked out.
Yeah, all right. But thank you so much. It's been great chatting with you and for all those. I mean, it was a great discussion. We had very interesting questions as well. And
Mhm.
what do you have to say to wrap up? Anything about H1B?
Um, that was a pleasure being on. I don't think we really talked about concurrent H1Bs at all. I mean,
Okay,
it just
so
didn't
why
come
not
up.
say a little bit?
There were no
Yes,
questions about it, but not concurrent. I'm sorry, CAP exempt employers.
cap exempt.
But
Yes.
yeah, CAP exempt employers is another avenue for H1Bs if you're not selected in the lottery. Just something I've been talking about recently. Concurrent employment H1Bs. Concurrent employment H1B, like if you're going to a cap subject. I'm sorry, I'm talked out. Long story short, look into if you did not get selected into the lottery, possibly working at a cap exempt employer. Those are typically going to be research universities, healthcare that's affiliated with schools and universities, nonprofit organizations, stuff like that. And that's pretty much all I got.
Okay. Thank you so much, Justin. I think, you totally deserve this long weekend. You seem to have worked a lot, and I'm sure, like we discussed earlier, you have these very complicated cases. You do a great job. So congratulations, and thank you for joining us once again. It was great having you here today on this discussion.
Yeah, thank you so much for having me. It's always a pleasure. You guys all have a great weekend, and I'm sure I'll be back on again in the near future.
Me too. Hoping to see you in the coming week. Bye bye,
All right.
Justin. Have a
Bye.
happy weekend. Bye
You
bye.
too.
Thank you, friends. And you feel free to contact Attorney Justin Rivera. His details are on the screen. You can call him on this number, 844-592-7336. Once again, let me repeat, 844-592-7336. You can email Justin at support@wasden.law and go check out wasden.law to get to know more about Wasden immigration litigation and also Justin Rivera. And also, don't forget to follow Wasden Immigration Litigation on LinkedIn for more immigration updates. and also us. We are Immigration and Jobs Talk Show. If you resonated and you are into immigration, an immigration enthusiast, why not subscribe to our channel, hit the bell icon, and you will always be notified when we have discussions like these. Furthermore, you can also contact me if you have any questions regarding immigration or jobs. And also remember that we also sponsor H1B visas. So feel free to contact us. My number is 408 335 6444. And my email address is neep@higherightpeople.com. And to get to know more about us, check us out on www.higherightpeople.com. This is it for now, but don't go anywhere. Stay tuned to our space because I'll be joining you again in another hour with another webinar and uh, another guest. So it's going to be very interesting. Thank you so much for joining us. Bye bye for now.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at neep@higherightpeople.com or visit our website www.
Hello, everyone. Thank you so much for joining us. This is Immigration and Jobs Talk Show, and I'm Napasa Pradhan, your host. Thank you so much for joining. This is going to be a very interesting webinar, the last for the day. But before we start off with the topic for the day, and also I introduce you to the guest, I have this important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, friends, thank you so much for joining us. Whether it is a good morning, good afternoon, or a good evening, it's a very warm welcome to all of you. Thank you. And we are streaming live right now on YouTube, LinkedIn, and Facebook. So if you have any questions, especially regarding this topic or anything related to immigration, feel free to drop them in the comments because we are going to be joined by our guest, none other than Attorney Chance Parvathaneni. Thank you so much once again from SPB Law Firm, Dallas, Texas. Thank you, Chance, for joining us. How are you doing today?
Hello, Nipasa. Pretty good, Nipasa, and thank you for inviting me over. And hopefully, we'll have a very productive and an informative session about immigration in general and employment-based immigration. And we can take up
For
any
sure.
specific questions from the audience and then take it forwards.
Of course, we will. And since we last met, a lot has happened, right? I mean, we also had the second lottery announcement for H1B cap. So, what are your views on that? And what would you like to say? Maybe you can even explain the process and criteria, for the second round of selection for fiscal year 2025 and how it's different from the initial round.
Sure. I think we had another, actually, we had a session last month about this topic, whether there would be a second lottery. We were discussing about it, and we did expect a second lottery because based on the number of filings that were happening and kind of the data that we were seeing in our law firm, talking to other attorneys and so on. So it looks like based on the number of filings, USCIS did not receive enough number of filings. They're supposed to get at least 85,000 H1B filings. And
Yes,
apparently
they've
they have
run
not
short.
received the full quota. So they were short. So they did announce publicly this week that they are going to go ahead and do a second lottery. And what that means is, in terms of process, the employers, the petitioners, the H1B, the petitioning employers, so they should be
Mm-hmm.
able to log into their portal once the selection process is done, expecting that to happen this week. They should be able to
Mm-hmm.
log in and find out who has been selected. And only the employers or their attorneys have access to the portal, to the H1B registration portals. So they can use their own company credentials, log in, and see who has been selected. And in terms of the process, the companies will have 90 days. So again, similar to what happened in the first round, uh, once the selection notice is out, they will have 90 days. So 90 days is when they can submit the actual H1B petition to USCIS. And what that means in terms of the process is, the employers and the potential employees, the beneficiaries of the H1B petitions, they should work together, and the employers should gather all the documents from the employees, the potential employees. They should get their package ready, and they should submit it to USCIS. And USCIS has e-filing. The e-filing is not as clean. Still, I think they're very new into the e-filing process, so the website is a little bit slow. It's a cumbersome process, but there is
Yes.
e-filing available. And in our law firm, we used a mix of paper filings and e-filings, but it's up to the company. And if they get started well ahead of time, they can probably use e-filing, so that way they don't have any surprises. And so the companies should probably look at their selection notices and go forwards. And H1B has a lot of compliance regulations. There are a lot of things where the companies have to comply. And what that means is, they should probably talk to their attorneys, make sure they're in compliance, whether it's wage compliance, LCA compliance, releasing the LCA back to the employees. Every employer has to give the copy of the LCA to their employees. They don't have a choice. When it comes to the LCA, the labor condition applications, the application,
Mm-hmm.
a copy has to be provided to the employee. So there are a lot of compliance related issues, and it's a good time that while they do the filings, they also ensure that they do an internal audit, make sure everything is in place, and then the main thing is ensure the deadline is met. There is only 90 days to file the case, and the deadline will be on the selection notice. The companies have to make sure that the second lottery selections, those H1Bs, are filed before the 90 days is up.
Mm-hmm. Right, right. Thank you so much, Chand, and for giving us that overview. And I'm sure folks out there are pretty ready and are excited, because this is good news for many folks out there who probably couldn't make it to the first lottery and were looking forward for a long time for the second lottery. And do you think also a third lottery may happen this year? What are your thoughts, Chand?
This year, I don't think a third lottery will happen, because I think compared to last year, I think we are seeing more filings. Last year, USCIS, they came up with this announcement where they talked about huge fraud in multiple registrations. And last year, what
Mm-hmm.
happened is, in the first round, we didn't see a lot of people file, because there was a lot of USCIS was right about the multiple registrations. And when people saw the notice from USCIS last year, a lot of
Yes.
companies stopped filing, because they did have this issue with multiple registrations. And in the second round of last year, what happened was, they actually selected a lot. In the second round last year, they did 80,000 selections. So normally there is not so much of scope, but last year, apparently, because very few people filed in the first round, second round did happen. And again, the third round, one year in the last couple of years, we did have a third round. And normally we don't have a third round. And I don't expect
Mhm.
USCIS will have a third round, because they do have enough data. They have seen how many people have applied, how many people have not applied. So they have the percentages. They know how many people
Mhm.
potentially might not apply. They also know how many cases potentially will get denied. So they will use all these numbers
Information.
while they're doing a second round. So more than likely, in the second round, they will get their numbers right, because they have enough data. And what that
Yes.
means is, a third round is potentially not required. And my guess is, there is a very, very slim chance of a third lottery. A second lottery was kind of expected, but a third lottery, I think,
Mhm.
is probably
And by
it's
when can
very
we
difficult.
expect
I
this
would
second
not
lottery?
say. So the second lottery, the selections, I think should show up this week, more than likely, because if you look at what happened last year and the year before that and the year before that, normally they make an announcement, and the next 2 3 days they kind of release all the selection notices. And once the selection notices are released, they will have 90 days. And my guess is since earlier this week they made this announcement, we can expect the selections to be completed this week, and 90 days after that, I think, is the deadline. So more than likely, last year October 30th was the deadline. So this year probably now sometime in November first week would be the deadline, and the actual
Mhm.
deadline will be a part of the selection notices.
Absolutely. And we are all looking forward for it, praying hard and hoping to get lucky. So hold on to your lucky charms, folks, and let's all pray to get luckier, okay? And also, Chand, I mean, we also have the recent political changes. I mean, many things and updates coming up, and also elections knocking
Yeah.
right under our noses. So, how have the recent political figures like maybe Kamala Harris, Donald Trump, influenced U.S. immigration policies, and what do you think are the key changes or challenges that are highlighted? Maybe like Davis, and should immigrants and employers, you think that they should be aware of? Any thoughts on what's going on around?
Yeah. So one thing we know for sure is the president is going to change. It's not going to be Biden anymore. It is either going to be Kamala Harris, or it's going to be President Trump. So we know there is a change coming about. And every time, normally, when we have elections and we have a change in the administration, whoever is the president, they want to do a good justice to their job. And immigration is a big part of every president's job, because immigration is such a hot topic in US, and immigration is a hot topic in this current elections. And people on both sides of the aisle, they're talking about making reforms in immigration to smoothen the process. We all know there are a lot of problems in immigration, which means there is always work to be done when the new president takes over. And when we have a new president, the new president always comes up with a new team. So they have a new team, they have new advisors who are taking over the charge, and so on. And what that means is changes are definitely possible, and I think they will happen. 2016 to 2020, when President Trump first came into the office, he did a lot
Mhm.
of changes, and there were a lot of, major changes in the whole H1B process. And again, 2020 to 2024, if you look at how things happened, there were major changes in the immigration process, and especially when it comes to the H1B part of immigration, there were a lot of changes. There were, and last year there were also a lot of changes proposed. So they had proposed a lot of changes in 2023. They waited for the comment period to end, and they implemented a couple of changes. So earlier this year in 2024, changes like increase in H1B fee, and
Mhm.
the
Yes.
complete revamp of how the way the lottery is done, the H1B registration process. They made a huge change in the way the lottery process is done earlier this year.
So
And
true.
they also came out with an announcement and said they have more proposals, things like specialty occupation, changing the entire definition of specialty
Yes.
occupation, changing what bona fide offer should mean. So they have these rules. The draft was out there. People made comments, and USCIS, DHS, they're already saying that more changes are possible, because they released the draft last year, and the comment period is done. So definitely changes could happen, and I think my guess is they will definitely make changes on the way specialty occupation is addressed. They will make changes in employer-employee relationship. Previously, before
Mhm.
2020, client letters were almost mandatory. Client letters, contracts, and so on.
Yes.
Last couple of years, because we had some changes with USCIS, they had some memos come out. The way they're looking at client letters and the contracts, it is a little bit different. But going forwards, again, they're going to bring some more changes, because I think the goal of every president is to do justice to their job, which means they're looking at all these inefficiencies in the process. They're trying to reform it. And I don't think either president will be against the H1B program, because if you look at President Donald Trump, his wife, Melanie Trump, she used to be on H1B a long time back. So he understand. He made a number of comments a number of times saying he respects the contributions of foreigners in the H1B field. What he wants is he wants a reform. But again, he never said anything about not wanting H1B people. And same thing with Kamala Harris from the Democratic side. They also do value the H1B program. So I think H1B program is not going to go anywhere, but definitely some of the issues that are coming up. probably they will be addressed. And we occasionally see all these news articles about H1B abuse, where some companies are abusing H1B. So every time I think there is a new administration, there's a chance to improve the program and make it better. And when all these H1B abuses are coming into light, and the officials, they see what has happened, they try to reform the process. So people can definitely expect some changes, and some of them could be major. And we have to
Sure.
wait and watch and see. But 2025, I think definitely people can expect some changes in the immigration process.
Yes, absolutely. Change is the only thing that's constant, and we should look out for better changes for us. So let's hope for the best, friends. And yes, look out for updates. Don't forget to subscribe to our channel. Our handle is Immigration and Jobs Talk Show. We keep having discussions like these and updates as well. So look out and don't forget to subscribe, because once we have the dates also for the second lottery, I'm sure we'll be the first to let you know. All right. So quickly, I'll just say hi. Akshay was asking, can we ask questions here? Of course you can. We are here. So wherever, or you're watching us on YouTube, so feel free to drop your questions in the comments. We have chance for a while now, and we'll be very happy to take them up. And also a big hello to all you friends. Just stay with us, Vishnu, Vardhan, Pavan, and yes, we will take up your questions. Stay with us, all right? And without further ado, I mean, today's topic of discussion is what we are here for, and that is what are the hidden aspects of life for Indians in America. And this is the second episode. Last week, also, we had a very interesting discussion on this very same topic, and we had a lot of questions taken up as well. So, Chand, are you ready for this? And I hope you are.
Sure, Ripasa. Yeah.
All right, so let's go on. Now, I got this first question on under this topic for you, Chand, and that is, how important is it for Indian immigrants to understand local law and regulations, and where can they find reliable information?
So the main thing is there is this concept of ignorance of law. So if somebody gets into any trouble with criminal law, they cannot go and argue and say, I was not aware of this law, even if it's a trivial law. So ignorance of law is not a defense to any criminal offense. And what that means is the government puts the burden on everybody to know the law. So one cannot say, I'm not an attorney, I don't know what the law is, so I made this accidental mistake. And things like overstaying your visa, for example. Some people accidentally forget to look at their I-94s. Not looking at the I-94s because they don't know that they're supposed to look at I-94s. Ignorance of that law. It is not going to help them if tomorrow they get in trouble. So what that means is, so the laws are very important. And in US, we have this system of federal law. Uh, we follow the concept of federalism. And in federalism, what it means is we just don't have one central government making all the rules. We have the central government, which is the federal government. They make the rules. And then the state governments can make their own rules. And then the state governments give a lot of flexibility to the local counties, local cities to make their own laws. And in general, what that means for everybody is sometimes what that means is you have to follow the state law, you have to follow the federal law, you have to follow your local laws, you have to know all the laws. And I'll give you one example where a lot of people make a mistake. Sometimes in the state, for example, state of California, they say smoking weed, taking marijuana, a drug, ganja in India. So the ganja, the marijuana, it's legal for somebody to consume it in California. The state law says it is legal. So if a US citizen takes this drug, this ganja, this marijuana in California, they're not doing anything wrong because the state law says it is completely legal and nothing can be done to that person. And now, if employee on a H1B visa, he does the same thing in California, he cannot say California law says it is legal because the federal law, the central government law says uh, these drugs are illegal. So what that means from an immigrant standpoint is you have to follow the state laws, the local laws, and the federal law. And you have to understand this concept of federalism in US, which means there are multiple pieces in the government system, and all laws have to be followed. So this is very important. And what that also means from an immigration standpoint is sometimes people uh, don't know the laws. And for example, just yesterday we had this article in Bloomberg. They were talking about rampant H1B abuse. They were talking about big companies. They were talking about big IT companies in India, the well-known names in India. They're talking about how these big companies in India, the names are there in the article. They're talking about the abuse. They're also talking about how the multiple registration lottery system was heavily abused. So, and unfortunately, a lot of times people get caught up because they didn't know the law, and they went with all these bad employers. So, overall, what it means to everybody is be aware of the laws, talk to your friends. Uh, Google is your best friend. Sometimes you have a doubt, go to Google, because you might not have access to go to a lawyer each and every time you have a small question. So if you think you have an issue about some law, the best place to start research is Google, because all the statutes and everything is online. It's available online, and you might be able to at least do your initial research. And if something is really bad, definitely I think always try to involve an attorney, because US follows this concept of due process. So everybody has this due process, and nobody can be accused and convicted of a crime without due process. So knowing the state laws, knowing at least laws relevant to what you do in real life. So suppose if somebody is on H1B, at least knowing the relevant laws about H1B, H1B compliance, how you should not move places without filing an amendment, how you cannot just go and work from anywhere, how you're supposed to get paid like you're supposed to get paid, unemployment days, etc. So at least everybody will have their own unique situation. So look at your own unique situation and try to at least educate yourself with the laws in your situation. And doing so, you'll be in compliance with the laws of not only the state, local, but also the federal laws.
Absolutely, very well put, Chand. And I would say you are very lucky if you have an attorney as your best friend, especially if that attorney is an immigration attorney, so that you can always go and find out your queries. But otherwise, like Chand has said, it's always good to read out more, do your research, or make Google your best friend sometimes, and yes, consult an attorney if your case is more complex. All right. Thank you, Chand. And also, since we're talking about the topic today, what are the hidden aspects of life for Indians in America? I have this other question for you, Chand, and I'm sure this is a question many Indian immigrants have. So, what legal rights do Indian immigrants have if they are accused of a crime, and how can they ensure these rights are protected?
Sure. This is a very good question, and I think all people, and especially the immigrants, they should know what kind of rights they have, because they can be accused of a crime at any point of time. For example, somebody is going on the road. You might have a police officer give you a speeding ticket. Speeding is a crime. So you never know. So it is always good to know your legal rights if you're ever accused of any crime. Maybe the crime is a small crime, something as simple as a speeding crime, a speeding ticket. And
Mhm.
sometimes it could be a bigger crime. Maybe you're accused of theft in a store. You never know. And so the first thing is, try not to get into any situation where you're accused of a crime. And 99% of the people that I deal with, they are very, very, especially because I deal with a lot of immigrants, and most of the immigrants, they want to follow the rules, because they understand that if they're ever accused of a crime and if they are convicted, their entire immigration career is jeopardized. So majority
Yes.
of the individuals, they do follow the laws. But unfortunately, if somebody is accused of a crime, they are
Mhm.
entitled to a lot of legal rights if they're ever accused of this crime. And understanding these legal rights is very important for their legal defense. And the first thing I would tell anybody is, there is this thing called right to remain silent. So if a police
Mhm.
officer comes to your house, for example, they accuse you of a crime and they start questioning you, there is this very, very important Fifth Amendment right, which is called right to remain silent. That is a very, very integral part of US Constitution. And that is the Fifth Amendment right to remain silent. So everybody has the right to remain silent if they have been accused of any crime. So they can simply tell the police officer, I do not want to answer. I want to remain silent. And that is their
Okay.
right. The police officer cannot pressurize them. They cannot do anything if they don't want to answer any questions from the law enforcement without having their attorney present. So that Fifth Amendment, right to remain silent, is a very, very important right. And also there is something called a Miranda right. So, and you see this quite often in the movies. So if a police officer wants to arrest anybody, the first thing the police officer has to do is, there is something called Miranda rights. So the law enforcement officer, the police officer, they will inform the accused person that they have a right to remain silent. But if they talk anything, if they speak out anything, they can use that against them in the court. So basically, they are telling them, yes, you do have the right to remain silent, but if not, you go
Yes.
and talk something, and you make some statements, they can use that in the court. So that is why the right to remain silent is very, very important. If anybody
Yes.
is accused of any crime by the police officers, or you get arrested, do not talk. Just tell them that you need an attorney, and you will talk only after you have an attorney. And no police officer will pressurize you and say, no, you have to talk. So, very important.
Mm-hmm.
Be aware of the right to remain silent. And the next biggest right that US Constitution gives, provides to everybody, is the right to an attorney. So, so this is again a part of the Sixth Amendment in U.S. Constitution. So immigrants also do have a right to legal representation if they're accused of a crime. And if somebody
Mm-hmm.
is accused of a crime and you don't have the money to afford an attorney, you don't have to
Yes.
worry. The court will provide you one. There is something called a public defender. So the court will provide you a public defender, an attorney, if you are not able to pay the money and you are accused of some crime and you are thrown in jail. So always understand that even if you don't have the money, an attorney will be provided to you if you are accused of a crime. And so that it is very important to understand that you do have a right to an attorney, and you could also get an attorney if you don't have the money to pay for your legal defense. And then a very important part of this whole criminal process is a right to a fair trial. So in US, the police cannot just accuse you of something. The prosecution cannot just accuse you of something. They actually have
Mm-hmm.
to prove it in the court. And we have this very important thing called a jury trial. This is a little different from what we have in India. In India, we don't have the jury process. In US, we have this jury process. So jury is nothing but it's just common people. So basically, it's common people who are out here in the city who can be called for a jury duty. So these people go and participate in this trial. So this right to be
Mm-hmm.
tried by an impartial jury. So jury means common people, not lawyers, not any government employees or
From
anything. It's
different
common
walks of
people.
life. They can
So this
belong to
right to a
any.
jury trial, yeah, yeah, it's random. I mean, I got called for jury
Okay.
duty in the past. My wife got called for a jury
Mm-hmm.
duty in the past, and anybody can be called. Any U.S. citizen can be called for a jury duty. And the good thing is, because these are people, just common people from the public, so they are expected to be impartial part of this whole legal process. So this right to a jury trial, this is a very, very important part of the U.S. Criminal justice system, and it really
Mm-hmm.
helps because. The jury, I mean, it is an important right. I mean, you cannot just say that you'll not be given jury trial. Everybody has a right to a public trial. It's a public process in front of the jury. So that is very, very important. And again, once for example, unfortunately somebody got involved in a huge crime, they got arrested, and the legal process starts. uh, so again, you'll have an attorney, but the right to confront witnesses and the right to getting a bail, because everybody who is accused of a crime is entitled to bail. So somebody cannot
Mm-hmm.
just be thrown in jail because they're accused of a crime and say, no, you have to stay in jail. There is something called bail. So bail in US system, it's a very important thing. And people will be eligible unless, because if somebody is arrested, all they're saying is you have been accused of a crime. You're not convicted. Until the courts actually convict you, nobody has done anything wrong. So the conviction is very important. And if somebody is not convicted, the courts will give them bail. And it will be a reasonable bail based on somebody's circumstances. So getting bail is a very important part. So even if somebody is arrested and accused of some crime, they have a right to getting a bail hearing, and they should be able to get a bail. And the right to a due process. So this entire criminal process, this whole due process, the courts have to follow a process, the defense lawyers have to follow a process, the prosecution has to follow a process. And so what this means is, it is not really easy to convict somebody who has not done anything wrong. And there are very, very important checks and balances out there in the system. So the legal system is very good, which is why US is a very, very successful democracy. Because and the beauty of this whole criminal justice system is we have a democracy out here in US, and this democracy is what drives the criminal justice system. And in general, it is rare for somebody who is innocent to get convicted, because there are so many checks and balances in play out here. And people should understand their legal rights and this due process if they're ever accused of any of the crimes.
So true. Very well put, Chand. And thank you so much, really, for highlighting all these importance of the Fifth, the Sixth Amendment, the jury trial, the bail, and you've made things so much clearer. And I'm sure folks out there, this was very helpful to you. And if you feel this resonates and if this answers your question, if you're looking for this, please let us know also that it's been good. Thank you so much. And also, like the Miranda rights, thank you so much, Chand. Yes, and absolutely. We have questions. Akshay earlier was asking if we could ask, and I think we should quickly take one so that folks out there know that
Correct.
we are here for you. And yes, we are here to take up your questions. Akshay is asking, when do you think priority dates 2017, 2018 will be current for EB2?
So right
And
now, I
another
think we'll have
question.
to do this forecasting and prediction based on the existing rules, and the
Mhm,
existing rules for employment-based immigration are extremely, extremely bad. And I'll tell you the reason for that. So right now, if you're looking at priority dates, the EB2 priority dates are in 2012. So anybody who has a priority date in 2012 from India, especially, they are eligible for getting a green card right now. So for India, the priority dates are very, very bad, and the reason for that is we have this 7% quota. So we have 40,000 green cards available under EB2 category every year. Unfortunately, the 40,000 cannot be given to Indians. Only
mhm,
7% can be given to Indians. So 7% of 40,000 is 2,800. And the 2,800, that is when you include the person who's working in the country, and then you also have to include your spouse. So if you're looking at 2,800 green cards, because every family, most of the families on an average have an husband and a wife. So we are
mhm,
looking at about 1,400 Indian families who are eligible to get a green card under EB2 based on the current rules. So the current rules are very bad, which is why, because of this country quota issue, which is why there is so much of backlog for India and China. So if you're looking at only 2,800 green cards in a year, I don't really think the dates will move from 2012 to the next couple of years that easily. And that is exactly the reason why. If you went 1 year back, if you went back to August of 2023 and you come
mhm.
to August of 2024, you will see that the dates have not really moved from 2011 and 2012. They're stuck over there. And the reason they're stuck over there is because we don't have enough numbers. And what that potentially means is I don't really see the dates going to 2017 or 18 anytime in the next couple of years. I would definitely don't anticipate that in the next couple of years unless rules get changed. And if you
Mhm.
see what happened in 2020 and 2021 and 2022, because of COVID, the family based green cards were not getting used. The consulates were closed, so they were not really using the green cards back in the embassies, in the consulates.
Yeah.
And because of that issue, they were able to use all those green cards and put it in the employment based category, and they were able to use it for the oversubscribed countries like India and China. But in the last 2 years, 2023 and even this year, because the
Yes.
consulates are again back to fully functioning, there is no spillage of green cards. So no green cards are coming and spilling over from family based to employment based. And what that means is we know that we have a lot of filings done in 2013. We know we have a lot of 485 filings done and pending for 2014 priority dates because 2014 became current a long time back. So just in
Mhm,
2013 and 14, we have so many outstanding 485s. And 2015, 16, 17, 18, they did not even start yet taking the 485s. So
yeah.
unfortunately, I don't think there is much scope. But what that potentially means is because we have a new president that will probably take up from 2025 January, once the elections are over in November, uh, we will hope for some immigration reform. And at least both sides of the aisle, both Democrats and Republicans, they have a problem with illegal immigration, but nobody says anything bad about highly qualified people coming into the country. So I think both of the sides,
Absolutely.
whether it's Republicans or Democrats, I think they'll be inclined towards EB2 and these kind of categories because these are
Mhm,
very highly specialized people bringing unique skills to US. So I think all
mhm,
we can do at this point of time is hope for some kind of an immigration reform where they will do something about this backlogs for India or China, or do something about these country quotas, or do something to reform the system and maybe recapture all the unused visas from the past. If they recapture all these unused
Yes.
visas from the past and do something, maybe the dates will go ahead. But at least looking at where rules are currently, I don't have a very good picture for 2017 and 18 priority dates, at least in the next couple of years.
Thank you. Thank you, Chand, for making that so clear. And Akshay, I hope you got your answer, but I know you have another question. Let's take that up as well. Also, do Indian people really depend on their US citizen child who turns 21 to file for their green card?
So a lot of people who are stuck in this GC backlog, because
Yeah.
they are here in this country for a long time. I mean, 10, 15 years sometimes. They have a child here. They're waiting for their green card to become current, say in EB2 or EB3 category. And so for those people, what I tell them is, if you have a child in US, and if you're filing for a green card right now in employment based category, it is definitely going to take more than 21 years. But the day your child, because he's born in US, he or she is born in US, the day they become
Mhm.
21, they can immediately sponsor for the green card and get green card for you immediately. So if somebody has a child, when that child becomes 21 years old, based on the current rules, they can be immediately be eligible for a green card and get a green card right away. So somebody who has a child from US, that child, when the child turns 21, will be able to sponsor you for a green card. And that category is a lot faster than the current EB2 or EB3 category. And that is the reason why sometimes people, because they cannot get through these backlogs, these GC backlogs. If they have a child who
Yes.
is a US citizen, they can definitely have that child sponsored for them and get a green card through them. The only rule through immigration is 18 years is not the adult age for immigration, it is 21 years old. So when the
21.
child turns 21 years old, that is the day he is considered as an adult as per immigration rules. And that is the day when they can sponsor. Not when they're 18, but they have to be 21 to sponsor for their
Mhm.
parents' green card.
Right. And what about the news of, I mean, these children getting deported because they don't have any green cards? What do you think they can best do at this moment? Because everybody seems so worried.
Yeah, so there is this other issue where somebody is in US and their child is not born in US. So when the child is not born in US, they're not US citizens, and if the parents don't get their green cards quickly, the child until 21 they can stay in the country as H4. So because 21
Yes.
years is the age when somebody becomes an adult as per immigration. So up to 21, the child also is good to stay in the country as a dependent of the parents. And a lot of times what happens is these children come to US when they're very young. And previously what used to happen is parents used to get a green card at least in 5 to 10 years. It was easy.
Mhm.
And in the recent past, the green cards, the backlog is very high. I mean, right now, expectation is it could be anywhere between 25 to 100 years to get a green card if somebody gets into EB3 or EB2 category at this point of time.
Mhm.
So the unfortunate problem is these kids are getting aged out. So when the parent does not get the green card, the child turns 21, the child cannot stay as a dependent of parents. So the child, because the child has aged out, they have to go out of the country. And that is causing a lot of anxiety to a lot of parents. And
Yes.
some parents are already in that situation because we have done a lot of such cases where the child does not have a choice. So the child is converting his status to either an F1, or in some cases they're going out of the country. So the child in US, if the child does not get a green card before 21, they have to figure out another way of changing their status to another legal status, or if not, they have to depart the country. And the other options are, some people are trying for EB1 if they're eligible. Some people are trying for EB5 if again they're eligible and they have the funds. EB5 is basically the green card where you pay approximately $1 million and you
Mhm.
generate employment, at least 10 employees, you can get a green card. So there is a way where you can invest money in US and get a green card. So we're also seeing a lot of people explore for EB5 green card
Yes.
option, especially when they have this unique situation where their child is aging out, the child is crossing 21 and the child does not have a green card. So they have to figure out a way to either get into another legal status or figure out ways to depart. At least the child has to depart and leave the country, because otherwise it will be an overstay.
Even if it is just temporarily. Yeah. Thank you.
Yeah.
Thank you, Chan, so much. And that was very heavy. I'm sure folks out there are worried, but I hope you figure out, there'll always be a way out, and it's always best to consult an attorney. They'll guide you in the best possible way. And yes, we have a lot of questions, but I think we should go for a quick break. And Chand, 1 hour is actually not enough, what I see now. But yes, folks out there, if you want to contact Attorney Chand Parvathaneni directly, why not call him in this number, 817-523-8247. You can even email him, law@spblawfirm.com, or better even just go check out his website. That's where you'll get more details about SPB Law Firm and also Attorney Chand Parvathaneni. And the website is spblawfirm.com. Thank you so much. And folks, don't go anywhere, because we are going to speak more about what are the hidden aspects of life for Indians in America. But after this short break on Immigration and Jobs Talk Show with Attorney Chand Parvathaneni, it's me, Napasa Pradhan.
An IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. This is the second half of the webinar we're having right now with none other than our guest currently, none other than Attorney Chand Parvathaneni, joining us all the way from Dallas, Texas. And today we are discussing about what are the hidden aspects of life for Indians in America. It's been really wonderful. I mean, not just this, we have discussed a lot about immigration broadly. I mean, the latest updates, the H1B second lottery, and we have questions also taken up. And I think, Chand, we should take up some more from the audience. This is from Tarun Mehra. Hi, what is expected date of second lottery date? We already discussed this, but Chand, you can quickly say it again.
Sure. And normally what happens is USCIS will announce that there is a second selection process. And immediately within a day or two, they will start releasing all the selection notices. So based on our previous experiences in the past years, I expect to see it anytime today, tomorrow, more than likely by end of this week. I expect to see the selection notices start or get completed. So definitely, I think it will be this week. And you just have to keep in touch with your employer, because your employer has access to the portal and they will see it in the portal. So just check with your employer and they should see the updates pretty soon.
Thank you, Chand. And he's also asking, what about the chances of who missed it in the first round?
Sure. So last year we had about 80,000 selections. So we had a large number of people get selected even in the second round last year. This year, I suspect the number will not be that high. And we don't have the statistics yet, but I don't really think the number will be that large like last year. Because this year, I think there were more filings than last year, until if you look at the first round of selections. But again, I think at least what USCIS also confirmed is in the master's quota, they did get enough filings, which means all the 20,000 people in master's quota, at least their filings are all complete. So definitely, it is not going to be a major number. It'll be a lot lesser than last year, for sure. So last year was huge. I mean, 77,000 was what they selected in the second round last year. And I think it was one of those extraordinary situations. This year, it will not definitely be as large as last year. That I think I know for sure. Exact numbers, I think we'll have to wait and watch for USCIS to release the numbers.
Yes, and Tarun, don't forget to subscribe to our channel because we'll be the first to update you. All right, now quickly, let's take up Vishnu's questions. He has a lot of questions. We'll take one by one. Vishnu, I hope you're here. Hello, Chand. I have the questions for DS160. While filing work experience, I can maximum only three companies to enter. What if I had four? Let me read
So,
more about his situation. He's saying, I worked for XYZ company in New York and for the same XYZ company in Pune, India, by internal transfer. So, my question, do I have to break down the XYZ company separately, specifying my work dates and salary? Okay, there's a second question as well. I took day one CPT program for one semester and went back to India. Should I mention that in DS 160 because I did not graduate from the program? And the third question is, other than LCA, I-797, I-129, what other documents do I need to carry for H1B consular interview? And which embassy do you suggest, Chennai or Hyderabad, for H1B? Okay.
sure. Um, so I think I see that you have participated in CPT. So what that means is you probably had F1 visa in the past. And if you have a visa in the past, normally you should qualify for a Dropbox. You might not even have an interview. So once you finish filling your DS160, more than likely you will get the Dropbox. So if you get the Dropbox, take the Dropbox because Dropbox is a lot easier. You have the interview waiver. So you might not even have a counselor interview in your case because looks like you have been in US in the past and you clearly had US visa in the past. So one thing is you might not even require a counselor interview. And next, coming to your DS160 questions. So DS160, fill in your job details as much as it would fit because you don't have the additional information screen. So start off with your most current job and keep going backwards until whatever it fits. I think you should put it in DS160. And normally, in terms of companies, if you worked in, say, for example, a company in India and that same company sent you to US, normally, if look at your pay statements, look at your offer letter. If you got the pay statements and offer letter and everything from the same company, you don't really have to break it up. But there are some companies, like for example, IBM. In IBM, they call that company IBM India Private Limited. And when you come to US, the company name changes. So it's actually a different entity altogether. So if your employer is a different entity, even if it's an affiliate, if it's a different entity altogether and you worked under a different role, I would say break it down. But if it's the same entity where in the same company you were deputed back to US, then technically it's the same job. So you can put it in the same one section as one employer, and you can go ahead. And regarding your education, you should put any places you have attended. I think you should put it because if the counselor officer has an issue, you can always explain that you did go for one semester and you stopped the program. And that should not be a problem as long as I think looks like you have an approval. And if you have an approval, it means that USCIS, at the time of approving your H1B, they did look at your status and they approved your case. So technically, since your H1B is good, I would, disclose all your educational part, and it should not be a problem. I mean, the fact that you have taken a CPT in the past should not cause you any problem at the consulate. But for some reason, if you don't get Dropbox, you do get called for an interview. I think definitely the first thing you should carry is the copy of the LCA. You should know where exactly you're working, how much you're making. And if you already started working and this company is already paying you, I would take all the pay statements, also any evidences of your work. And sometimes what that means is maybe print out copies of your emails where you are doing work and all those things. Take a latest employment verification letter, a letter from your employer saying that you still have the job. So the companies will typically give you that. Okay, and then I think, as you already mentioned, you're taking a copy of your 129 and your support letter, the letter with your job duties and everything. So basically, take the entire scan copy of what was sent, submitted to USCIS, and on top of it, additionally, what I would suggest is take a recent employment verification letter and any documents that explain your project. And if you have a client, maybe a client letter. It's not mandatory, but it's definitely highly advisable. maybe a simple document from your company explaining the project assignment and what your project is. And if you carry it, I think you should be fine. Okay, so I think I mean, it should be. I mean, since you have a H1B approval, and since looks like you have been in US in the past, my guess is you should have a straightforward process. And what we're seeing is even if people are getting 221Gs nowadays, what happens is once there is a 221G, very quickly the companies, their employers are getting contacted, and once their employers provide all the information back to the consulate, the 221Gs for most part are getting cleared pretty quickly. And then when it comes to the consulate, Hyderabad or Chennai, at both the locations, you will see the same US officials. They follow the same rules. So I think it's kind of a factor where some people think one consulate is easy, but to me, it's the same officer that I mean, same kind of officer where they are undergoing the same kind of training, and they adhere to the same set of rules. And we see 221Gs in Hyderabad, we see 221Gs in Chennai. We see cases getting approved easily in Chennai and also in Hyderabad. So to me, I think it is more of a preference. But if you ask me, when you look at the large numbers, is one consulate better than another consulate? I don't when you look at the large data, in terms of the percentage of approvals, there is not really much difference between Hyderabad or Chennai. It is the same officers who are required to adhere to the same set of legal standards. So it's more about you having proper documents, as in your employer documents, you having a legitimate job. Because even if somebody gets a 221G, in the end, they are clearing out 221Gs once they verify all the information. So I would not worry whether it is Chennai or Hyderabad. What I would suggest is take the one where you're able to get a slot more quickly and which is more closer to you, because that way you'll get the process done quickly and more easily.
Thank you so much, Chand, and very good advisors. I'm sure, Vishnu, that was very helpful. All the best. Okay. And let's take up this next one. This is from Sandeep, also asking on YouTube. My son is on F1 OPT EAD. 90 days ends on September 29th. He did not get the job, but he got master's admission in another college. Please advise, how does that work? Is there a simple I-20 update from college to college, or he needs to defer his admission and get new F1? Can he still stay, I think, in US if he has applied for F1 beyond his EAD 90 days after start date? Or should he go back to home country and come back again with F1?
So normally what happens is if you already on F1, so looks like your son is already on F1, his service will be active. And when the service is active, in case your son wants to go and join another university, what happens is they go to this new school, or if it's the same school, and you will get a new I-20. So anytime you get an admission into a program, you will get a new I-20. And once you get a new I-20, your son should be able to go through the school authorities, and they should be able to simply transfer the service record to this new I-20. So they should be able to do it. And since right now he's in valid status, he should be able to transfer, and it is basically just getting the I-20 updated in service. And he should be able to work with the school and get this done, and he can start the school. So he will not be out of status because he has not crossed the 90 days of unemployment. So when you talk about 90 days, probably we're talking about the 90 days of max unemployment that you're allowed. And since there is like no denial on the case, the service is still active. The transfer should be very smooth, and he doesn't have to go out of the country and then re-enter. Simply get a new admission, work with the new school DSO to get the service transferred over, and that's probably the quickest way. And not worry about it. Okay, so it's only when people cross, when they fail to maintain status, or they get a denial for their OPT extension, that is when the service will be terminated and they will have to step out of the country. But right now, looks like he's on active F1 status. So if he wants any transfer, he just works with the school DSO, where he's trying to enroll, and they should be able to do it pretty quickly.
Great. Great. Thank you. Thank you, Sandeep, for your question. And thank you, Chand, as well, for answering that and making it so clear. All right, Chand, this time I have a question for you from my end. And if you could tell us, how can have, sorry, how important is health insurance, and what should Indian Americans consider when choosing a plan?
Sure. I mean, health insurance, I think at least in US, I think every, I think family should have health insurance, especially when you're a non-immigrant on an H1B. The reason is medical expenses are very high. And the
Mm-hmm.
good thing is because most of the people who are on H1B, I mean, most of the immigrants, Indian immigrants in US, they are working on H1B. What that means is they have an employer, and majority of the employers do have some health insurance plans, and every employer will have their own set of health insurance plans, and they should be talking to their employer and try to get enrolled in this employer plans. If they go outside and get their own health insurance, it's a lot more expensive. And if they participate in the
Mm-hmm.
employer plans, it's a lot easier. So everybody who has an employer should be at least checking with their employer to see if they have a plan and get enrolled. Because every employer will have a limited set of plans and they will be able to check and see what is best for them. And for people whose employer does not offer plans, there are outside options and they should be able to get health insurance outside. And
Mm-hmm.
you're normally looking at what kind of uh, a monthly pay you're supposed to pay, what kind of deductibles you have, and so on. But the bottom line is, yes, you should have health insurance. If your employer offers it, I think that's your best case scenario. If your employer does not offer it, probably go outside and then try to at least get one.
Okay. Thank you so much. Thank you so much, Chand. And also, like, another question is, are there any cultural, of course, there are cultural misunderstandings sometimes, but some that may lead to legal issues for Indian immigrants, and how can these be prevented?
Sure. So there are like some very common cultural misunderstandings, especially when it comes to Indian immigrants in US. And
Mhm.
the first and most important thing I typically see is the domestic disciplining and the way the kids are raised. In Indian culture, physical disciplining of a child sometimes, I mean, most of the time, it is considered acceptable because it is disciplining, not really child abuse. And in US, sometimes when it comes to a point when there is physical discipline, I mean, once it crosses a certain line, it could be child abuse if the child is especially getting hurt. So this is, I think, one important thing where a lot of Indian immigrants especially who are coming into US, when they have children, they have to be very, very cautious. The
Mhm.
way children are physically disciplined in India, where things might be considered normal in India, might not be considered acceptable in US. Sometimes it could even
Mhm.
lead to criminal charges, child abuse charges. So very, very important. I mean, child disciplining, I mean, would have to kind of ensure that you are following the local rules. Another
Mhm.
common issue is domestic violence. Cultural norms and the gender roles. Sometimes we have little bit of variations, the way things are in India and things are in US. Majority of the Indian immigrants who are coming to US, they are highly educated. So again, when you're looking at this section of people, they understand domestic violence, they understand gender equality, and not, I mean, doing anything that would constitute as domestic violence. However, because there are cultural differences, what might be construed as okay in India is not construed okay. I just recently had a case 2 weeks back, and this person and his the better half, they were fighting with each other, and all of a sudden, I think there was some domestic violence, and this person slapped his other half. It was a very spur of the moment kind of a thing, but eventually they went back home and they were okay with it. However, somebody else
Mhm.
saw this happen because it was in public. They complained to the police. Police came and arrested this person. So, what is okay in India? Just because the wife does not complain and I mean, file for charges, does not mean anything. So, domestic violence is completely a big no-no. So, people have to be very, very cautious. I mean, whether it is mental abuse, whether it is physical abuse on their better halves. So be very, very cautious about domestic violence, which is issue we keep on seeing happen back and forth. So these two are the most common issues that I normally see where culture plays a very big uh, part
Yes.
because of the way these things are seen. And also another thing
Mhm.
I see, which I did see in my law firm, is the dowry issues. So dowry is not a big issue; is actually a non-issue in US, but dowry does happen in India. We all know that it does happen in India, and in US, the way it would come into the legal aspect is sometimes if somebody is being pressurized for around dowry, there is something called force and coercion and blackmailing. The concepts, these are criminally big issues. So somebody having a dowry issue might have a big case around blackmail, coercion, and so on. So dowry is also another big issue. But again, most of the people we see nowadays are highly educated people. So I don't see this often at all. But again, it's something that people have to be aware that this dowry kind of issues, this casteism kind of issues, because there were recently big news about the casteist behaviors. There was big news. I mean, if you saw the news in the last 1 year, this caste things came out. People actually had a lawsuit filed about caste discrimination because theoretically there's no caste rules around caste discrimination in US. But because I think some people were discriminated, and definitely I think there is some kind of caste discrimination that sometimes does happen, not on a wide scale, but it does happen. So people, cultural differences. When somebody is coming from India or any other country to US, you have to be very, very cautious about this discrimination rules, this domestic violence, child abuse, this gender roles where sometimes in the back in their home country, females and are looked at differently. But again,
Yes.
people have to be aware of all these things. But luckily, I think we are dealing with a lot highly educated people. So this issue is these kind of issues are really minimal. But I think everybody should be aware and never ever get into that kind of a situation where these cultural differences are causing them to get involved with the criminal justice system out here in US.
So true, so true. And Chan, that leads me to another question, and that is, are Indian immigrants more susceptible to certain types of crimes out there, and such as fraud, hate crimes, and what can they do to protect themselves if they are in the United States?
Sure. I mean, immigrants, not just Indian immigrants, I think immigrants in general are highly susceptible to crime. And the reason I see is sometimes immigrants, if somebody does something wrong against them. So, for example, say a female, for example,
Mhm.
and she gets, I mean, there is like workplace discrimination for some reason. The thing
Mhm.
is, when it's immigrants, a lot of times because of stereotypes of how you don't want to go into the public, how you don't want to file charges and get involved. So a lot of times, this misconceptions because they have experienced other cultures. I mean, they have not been here for a long time. Sometimes the way people look at from complaining and going to the police or going to the authorities, uh, sometimes they don't take a step forwards. So because of these reasons, sometimes there is a good chance that they are more susceptible to crime. I mean, I've seen cases where people were called on the phone, they were threatened, and they were blackmailed for money. And the people thought somebody, like a police officer, was calling from the other side, and they lost money. So we saw a lot of cyber crimes. So because people think that immigrants are vulnerable because they're not in this country for a long time, they don't know the criminal justice system, they don't know whom to report, and so on. They tend to. There is a good chance that sometimes people might be taken advantage of, and sometimes even hate crimes. But again, what people should do is people should know their rights, and if there is any issue, know that there is a very good criminal justice system out here. There is a good process out here. You can go to the authorities, and going to the authorities, you don't have to worry about any negative repercussions, and you have legal rights. But the thing is, you have to enforce your legal rights, and everybody should understand that enforcing legal rights will not cause them into any kind of a problem. Whether you have a problem with your employer, whether you have a problem with somebody else, uh, your legal rights are actually more protected if a crime has been committed on you and you go to the authorities. If you don't do anything about it and you sit tight, not only will it impact you, but it'll make the person who has committed this crime, it'll make him or her more bold, and they will commit that same crime with somebody else. So just be aware of your rights. Everybody has rights,
Yes.
and be aware that authorities will act if you report to them, and you will not have any negative consequences. So utilize your rights. That's all I think I should say to protect somebody.
Thank you, Chand. Thank you. And I think this brings us to the last question, and we will take this up from the audience. Chand, thank you. So far, so good. This is from Pavan Kumar asking on YouTube. As the Indian government implements new policies like the Citizenship Amendment Act, how are Indian immigrants in the US responding to these changes, and what implications do they see for their own status and identity?
Yeah. So, and again, India is a sovereign nation. So, India has complete right to make whatever laws they see fit. And India is a very, very vibrant and a successful democracy, just like US. So, when US makes laws and India makes laws, I think they're trying to do the best for their own countries. But again, when somebody is an immigrant and they're in US, so what happens is somebody comes here on a visa. So either they're on a H1B or some other visa. And again, as people like staying in US, the normal transition is people go through the process, they apply for a green card, and they get a green card, and they eventually become a US citizen. And so during this process, if India is making some rules, these
Mhm.
rules might impact people living in US, because the
Yeah.
rules could impact somebody who takes up US citizenship. For example, for somebody like me, I took up US citizenship a long time back, about probably 15 years back, and I had to surrender my Indian passport. I had to basically do something. I had to basically apply for a PIO card back then, and then rules changed. I
Mhm.
had to apply for an OCI card, and what that means is India as a country, they make their own rules, and it is for people like us to know the law and ensure that we are following the rules. So for example, so if I go to India, I cannot just buy any property. There are rules on buying agricultural land and so on. So what that means is, uh, if people are in US and Indian government is making rule changes, it is highly important that if somebody has an interest in India, they have to be aware of these rules and make sure they comply with the rules. Because if they're going to India and they have some properties in India, they have to 100% also comply with the Indian law if they're doing any business or anything in India. So what that means is, as rules keep changing, people the best way is keep yourself educated with the rule changes, because rule changes are dynamic. They keep on happening. Things keep on getting reformed. So as rule changes keep on happening, know what is the change, how things are changing, how it impacts you. Because our goal, as common people, is to ensure we follow the rules. So governments make rules. We just have to make sure we follow the rules, and then keep moving ahead.
Absolutely. And if you're belonging to two countries, India and America, or America and some other country, you have more rules to follow from both the countries. So make sure of each and every one of them, do your research properly, stay educated, have sound knowledge, especially about the rules and regulations regarding immigration and crime and everything in that country and from your home country as well. And absolutely stay safe and stay true to yourself and to everyone around you. Thank you so much, Chand, for today. It was really such a pleasure having you discuss two episodes with us. What are the hidden aspects of life for Indians in America? It was really nice, to have your thoughts, your insights, and maybe you could give us an end note to wrap up the session to all the viewers out there. Would be really nice.
Sure. I think the good thing is the immigrants. I mean, if somebody is coming out of India to become an immigrant in another country, whether it's US or another country, it's because they want to
Yes.
work hard and kind of do better and better themselves and their careers. So what that means
Yes.
is people should focus on doing the right thing, working hard, and stay away from crime as much as possible. We know that most of the people do stay away from crime, but again, I think at times like this, it is good to just kind of look around and see what kind of mistakes people are making. And if people make some mistakes, just try to make sure that it's a good lesson and one does not repeat. And
Yes.
staying abreast with all these news articles and seeing what's going on is a good way of educating ourselves and making sure we comply with the laws of the country we live in, and make sure we don't get into any of this criminal justice system mess at all. So by never even giving a chance, by getting into that kind of a system where you have to be accused of a crime, if you don't even get into that situation, you don't have to worry about anything. And again, US as a country, it encourages hard work, and if people work hard, they have numerous opportunities, and we have seen that numerous times.
Mm.
And if you see people like Kamala Harris, her mom, she was from India.
Yes.
If you see our the vice presidential candidate's spouse, Usha, her parents. So again, US, it's a great country. I mean, the government puts so many restrictions on discrimination and all these things. It makes it so clean, so people can actually flourish if they want to work hard. And there are numerous examples in US where people have risen to the top political, either it's politically or on the business side. So it's a good opportunity. US is a good opportunity for everybody. And the only thing is, you should work hard and never get involved with any kinds of crimes. That is the only thing that everybody should keep in mind.
Very well put. So I may sound like a parent right now, though I'm not one. But yes, don't get distracted, stay focused, and keep working hard, I would say. Thank you so much, Chand, for doing this. It's really good to have you once again today on our episode, this webinar. Very insightful. And folks out there, if you want to contact Attorney Chand Parvathaneni directly, why not call him in this number, 817-523-8247. And you can email him if you have any queries, want to contact directly, tell him about your case, your status. Mail him at law@spblawfirm.com, and definitely go visit his website, spblawfirm.com. Thank you, Chand, once again, and I hope to see you in the coming week once again.
Thank you, Nipasa, and thank you, everybody.
Thank you. Have a great day, Chand. You too, folks. Thank you so much for joining us. Really lovely to have your questions. And don't forget to subscribe to us. And our handle is Immigration and Jobs Talk Show. Feel free to also follow us on Facebook and on LinkedIn. The same handle, Immigration and Jobs Talk Show. Was really lovely having you, folks. Don't forget to subscribe because we keep having discussions like these and we keep having the latest updates on immigration. And thank you so much for joining us. If you have any further questions on immigration or jobs, and maybe you're looking for a project placement, green card, EAD, anything related to immigration, please feel free to contact me as well. My number, where you can also WhatsApp me or call me, is displayed on the screen. My number is 408-335-6444. And my email address is nipa@higherITpeople.com. And to get to know more about us, please visit our website, www.higherITpeople.com. And yes, thank you once again. Have a great day ahead. This is Nipasa Pradhan signing off for now from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higherit
Hello, everyone, and welcome to Immigration and Jobs Talk Show. I am your host, Nipasa Pradhan, and we have a very informative session lined up for you today. But before we get to that, I have this very important disclaimer I need to read out. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, welcome to Immigration and Jobs Talk Show. And we are thrilled to have viewers joining us, not only on YouTube right now, but also on Facebook, LinkedIn, and maybe also on Twitter. Thank you so much for joining. And I also will take this opportunity to tell you that, you can comment if you have any questions or you want to share about your experiences, especially under this critical topic that we're going to touch up today. And yes, today's topic is getting a green card approved in the new fiscal year. tactics, and hacks. And we are going to be joined by our expert guest for this discussion, and it's none other than Attorney Prashanthi Reddy, a renowned immigration attorney from the law offices of Prashanthi Reddy. Well, Prashanthi specializes in business immigration for IT, healthcare, and other industries, as well as family based immigration. And she's based out of New York. Prashanthi and her team make immigration easy for her clients. So, once again, very warm welcome to you, Prashanthi. Thank you so much for joining us today once again.
Thanks, Nipasa. It's a pleasure as always. And I would like to apologize to the viewers for the late start of the program. That is completely my fault due to technical difficulties on my side. So sorry once again.
That's okay. I'm glad you are here and we will get to you. I already see viewers joining us. So thank you so much for joining us. Akbar on Facebook, Madhu on LinkedIn. You keep commenting if you have questions, all right? And yes, today's topic, getting a green card approved in the new fiscal year. Prashanthi, what can folks out there expect from us today?
So since we're in September, I mean, almost in September, in August, and in September we expect that's the last month, right, of of this fiscal year 2024, and in October will be the start of the new fiscal year. So it's a new year for green card applications. New numbers get released. So I thought it would be a good idea to talk about, what happened this year with reference to green card filings. What to expect for the month of September visa bulletin, which should be coming out soon. Predictions for September visa bulletin. Also, just an overview of what to expect for the coming fiscal year starting in October with reference to, number of green cards available. So highlighting what happened this year will give us a perspective of what to expect next year as well, and also some recommendations for best practices to file a green card, and what kind of categories are expected to be better or have a better visa number or priority date when compared to some other categories. So I guess we'll discuss all that today, and of course take questions from the audience, which is always our priority.
Absolutely. And we're very excited to have you with us, Prashanthi, and also very excited that you viewers have joined us. And I think without further ado, let's get started by exploring some of the latest updates and strategies, for securing green card in the new fiscal year. And to start off, Prashanthi, if you could talk about the availability of visa numbers in 2024, the September visa bulletin predictions as well. What do you think is
Yes, I would
coming up?
would love to. Yeah. So in general, as I was saying, we should look at the number of visa numbers that were given in 2024. For all those viewers out there, just so that you know, the actual number of visa numbers or green card numbers that are available every year are 140,000 mandated by law. And usually there's more than 140,000 because they use the unused numbers from the family-based, or the unused numbers from one category trickles down to the other category or moves up to a category. So sometimes it's more than 140,000. So in 2024, the government estimated that 165 green card numbers will be available in the employment-based category. And let's just talk about employment-based just to keep things simple. And that is, of course, down from 197,000 that was available in 2023. So you see there were more unused numbers in 2023 and therefore more availability for employment-based cases. It was 197 in 2023. In 2024, it was only 165,000. So the 165,000 is still 25,000 higher than the minimum, which is 140, which is available. So that means 25,000 unused family based green card numbers were trickled down into the employment based. And that's why we got that number. So this will give us an idea of what to expect, I guess, for 2025. Maybe more of the same, so around 165, 170,000. I don't expect 190,000 to be available. I think the reason why almost 200,000 in 2023 and more than that, 220,000, I believe, in 2022, were available is because of the effects of COVID, because consulates were still working at a slower pace and family-based green cards were not being processed at the consulate. So I think the consulates have caught up with reference to their processing. So this is a more likely number, the 165,000, that we will see moving forward as well. So that's, something, that number is something to keep an eye on, but my prediction is it could be around that. According to the US Department of State, with reference to the September visa bulletin now, according to the Department of State, there's high demand in the employment second category. So EB2, they're saying there's a high demand and there's a likely of retrogression of EB2 in the worldwide section. So for everyone other than India and China, there will be a retrogression in the EB2 category. That's what they said in the August visa bulletin. So we can expect that that'll happen for the September visa bulletin. So also there's a high demand in employment-based category 3, EB3 for employment-based category. And this will necessitate retrogression of, again, the worldwide category, final action date, there'll be a retrogression. And also there won't be much forward movement, I think, for India and China as well. So predictions, what are our predictions? This is really a guessing game, so, don't quote me on it, and, just take it as such. So EB1, maybe there will be some forward movement in September by a few months is what I'm thinking, because there might still be some numbers available and they want to use up all the numbers before the end of their fiscal year, which they have to do next month. EB2, I don't see much forward movement, maybe a few weeks if it happens. And EB3, again, not much forward movement, maybe a month a forward movement or less than that. Hopefully there won't be any retrogression because there has been, heavy usage of EB3 in the worldwide category, more so is what they're saying. They haven't made any comment for the usage in India, for the Indian nationals. I'm hoping it'll move up by 1 or 2 months, but let's wait and see. So EB1, a few months, EB3, a few months, EB1 more so than EB3, and EB2 maybe just a few weeks because there is heavy use of EB2.
Okay.
So that's my prediction for the September visa bulletin. Let's see what happens.
Okay, Prashanthi, that's very interesting. But if you could also explain to our viewers, about this 1 week time frame the USCIS sets to link the relevant chart, after the Department of State publishes a visa bulletin.
There is no 1 week time frame. I am saying that the visa number might move forward. The visa priority date might move forward by 1 week or 2 weeks. That's what I'm saying.
Okay. All right, then let's move on now. Thank you, Prashanthi, for giving us that. I mean, your point of view of what can we expect, but let's see. Let's hope for the best. What to expect with
Yep.
green card filings in the next fiscal year? The impact of priority dates, etc. As per the cato.org, political climate and layoffs. If you could.
Right. That's just the references that we'll use to talk about, what green card filings to expect next year. So let's go to that. As I was talking about when I was mentioning it to you, Nipasa, cato.org is a good website because they've done some research on, how many green card pending cases are pending, etc., etc. So anyone out there in the audience that wants to go to the website and look at the numbers, they're welcome to do so. So as per Cato, the employment-based green cards backlog. So we are talking about a backlog with reference to cases that are pending due to unavailability of visa numbers. That's the backlog we're talking about. There's several backlogs, but let's talk about that first. We know that there's a total of 140,000 green cards issued every year. We already discussed that, right? So let's talk about the employment-based backlogs. That is, hold on to your horses. It's 1.8 million cases this year, the backlog.
Oh.
This backlog is mainly consists of immigrants who are waiting to receive their green cards, mainly because of the low green card caps for employment-based cases. right? As we know,
Yes.
more than, if there's 140,000 green card numbers available, no country can get more than 7% of that number, right?
Yes.
So out of the 1.8 million people waiting, they're all waiting. All of them are waiting because there are no numbers available. And out of that, 1.1 million are Indian nationals waiting because there are no numbers available for them. Because Indian nationals are heavily backlogged because the demand is very high for Indian nationals and they only have the 7%, like all other countries. Fortunately for other countries, their demand is not high. So you see EB2 and EB3 sometimes is current for worldwide, and so EB1 is always current. And so they don't have that much of a backlog like Indian nationals do. Indian nationals face a severe backlog, as I was saying, 1.1 million of that 1.8 backlog is Indian nationals. And it's predicted that new applicants from India will face a lifetime wait for
True.
to get a green card. And this is a gruesome number, but 400,000 will die before they receive a green card. That's the prediction, and that is the statistics that Cato.org has come up with reference to, the pending backlogs on green cards
Backlog.
because the unavailability of, visa numbers. So unless Congress does something about it, this will continue to remain, and it's very unfortunate. Also, the backlog, we can expect backlogs, other types of backlogs if there's because of politics, as I was saying. Recently, in November, recently Kamala Harris was elected as the Democratic nominee for president. And in November, the elections are going to be held. And if Republicans come into power, then we can expect that the backlogs will increase. Different types of backlogs will increase. Things will just get worse. When we're talking about backlogs, also, the Democratic government has been trying to pass bills to increase the number of green cards, or, Eagle Act has been introduced every year for many years
Yes.
in the Congress. But unfortunately, because the Democrats don't have the majority and the Republicans will not agree to any passing of any such bill. So if the Republicans come into power and if they control both the House and the Senate, we can expect the more of the same. That is, there will not be any changes with reference to increase in green card numbers. Also, in addition to backlogs due to green card numbers, there's also backlogs due to USCIS. So USCIS
Okay.
backlogs, they have 171,000 I-140 immigrant visa petitions that are not yet being processed because they are facing backlogs in processing times. We're just talking about processing times now. And 289,000 pending adjustment of status cases right now, which are not being processed simply because of USCIS not having the opportunity to process them as yet, because they don't have the staff, they don't have the funds.
Okay.
So with reference to processing times, let's see what will happen if the Republicans come into power. It'll just get worse because they will not give the necessary funds needed. They will not to the USCIS, and USCIS will not have the necessary sources, the necessary bodies to, remove the backlog. Right now, USCIS has, under the Democratic administration, has improved backlogs, has received funding, has used that funding to automate their systems, and thereby, reducing backlogs. But still, you see the backlogs are so much, it'll just get worse if,
Yes.
there's no funding available, right?
Right.
So that is something I have to say with reference to what to expect for green cards moving forward. Also, layoffs can play a role with reference to filing
They
of a
have
green
been.
card.
They have been. There have been
Yes.
major layoffs this whole year. I think we've been just hearing and hearing about lots of companies laying off especially their work from home um, employees.
Yes. So layoffs can cause a delay in perms because when you're filing a labor cert, if they are layoffs and US Department of Labor is aware of this, then they will start sending audits on your perms. The audit, receiving an audit in a perm delays the approval of your labor certification, because then they ask for proof that you have not received any applicants. They ask for proof of advertising, etc., etc. So that always delays the perm process, but the delay is not that significant compared to the delay with reference to visa number, unavailability, and processing backlog. So that's something to keep in mind
Yes,
with reference to next year.
true. And Prashanthi, you're talking about the 7% for each country. I'm sure many countries do not even use maybe 7% or not even 5%, but it's hard for, I mean, India and China especially. So what do you have to say
Yes.
about that too?
Yeah, absolutely. So while we don't want to take away the numbers that other countries have, we think that it should be a fairer system,
Right.
where there maybe my solution to that is that you don't have caps on the number of green cards that can be filed, or the other solution is to increase the caps because there's so much demand, right, on the number of green
Right.
cards that can be
Make
filed,
it
and also
proportionate, basically. Yeah.
you increase the demand, increase the numbers,
Hmm.
or another solution is to not require family members to have a number. So that way, then the numbers are saved. You have double the amount, because usually there'll be at least one family member and they use up a number. So if
Yeah.
the family members are not required to have a number, then you'll have double or three times the number of green cards available than they are now. So there are some solutions available. It's a matter of having the political will to look at these solutions and to make changes.
True. True. Thank you, Prashanthi, for giving us a sneak peek into what can be expected. And I mean, especially from the upcoming elections, if any of the parties is also being elected, everything is going to be affected, and so will the immigration part as well. Let's move on now to the next question I have for you, Prashanthi. If an H1B worker is unable to find a new job within the grace period, what options do they have for changing their visa status?
If they're not able to find it, then there's a 60 days grace period, and they can find another employer within the 60 days grace period and file a transfer.
Okay. Okay, thank you. Thank you for that. And now let's move on to this next question. What do you recommend regarding the best employment based green card category for Indian nationals, keeping in mind the ones with less delay in processing times in the new fiscal year?
So we've discussed the problem with reference to what to expect and the green card backlogs. Now, is there any solution other than, the solution that we're suggesting or everyone is suggesting is obviously not in our hands because
Mhm.
Congress has to act. But is there any solution, for the immigrants who are more affected? The only solution would be to try to file in the categories which have less backlog. But please keep in mind, not everyone will be able to file in those categories. Not everyone qualifies, and that's why there is a less of a backlog in those categories. So EB1, employment-based category 1, is a
Mhm.
category where there is a less of a wait always. Sometimes it's current. It has been current in the past. Otherwise, the wait is sometimes a year, sometimes 2 years. Definitely,
Mhm.
definitely better to be in an EB1 rather than being in EB2 or EB3 category. For EB1, you have to have either extraordinary ability in the arts, sciences, business, whichever your career is in, whichever
Yes.
path that you're taking, you have to have extraordinary ability in that path, meaning winning national, international awards. If you're a researcher, then there is EB1 is also available for researchers. And again, it's exceptional ability in research. So you have to show that you've done a lot of research and there have been a lot of citations of your research, that your research is being used for healthcare or for the betterment of the community in the United States.
Mhm.
So research is another category where you can get a green card quicker. You can also get a green card through EB1 multinational executive, which means that if you worked as a multinational executive in a company abroad and then they have a qualifying company in the US, then you can be transferred to the US to work as a multinational executive and you can get into EB1 that way. So that's another way that you could get it. So EB1 is definitely the way to go. Also, family-based categories. If you're married to a U.S. citizen, if you are a child of a U.S. citizen, if you are a parent of a U.S. citizen, that is also an immediate. There is no wait at all for that category because it's immediate relatives, and there is no cap on the number of cases that can be filed. So there's no wait from the point of view of the green card numbers. So if you are eligible to file a family-based immediate relative category, then you should do so.
Yeah, talking about it. So, what is the ideal green card route to bring spouses and parents to the US in the new fiscal year?
Yes. So the best way to do this is, and the only way I would say is to file an I-130 and 485 if the person is in the US. That's the best way to do it if you're a US citizen. And this will allow you to, while your 485 is pending, while your green card is pending, will allow your family member to work by filing the EAD, employment authorization, will allow them to travel without a visa by filing and getting an advance parole document approved. They can be paroled into the country. So this is definitely the best way to for your spouse or parent or even child, if you're a US citizen, to get a green card, filing an I-130. If they're outside the country, you'll have to file I-130 consular processing. That takes a little longer because then you have to file the immigrant visa petition. And there is a backlog in just because processing time. And they have to wait outside the country until they're able to actually come in on a green card. So, the Mumbai consulate is backlogged. So that can take a couple of years to get them in that way. But if they're already in the country or on F1 or even on a B2 in some situations, you can convert their B2 into a green card.
Okay. Thank you, Prashanthi. I mean, you're giving us so many examples and suggestions for the different routes to get a green card. And okay, my next question to you would be can immediate relatives travel on B2 and then file for a green card after entering the country? And what are the advantages and disadvantages of this process?
Yes, as I was saying just now, that that is possible. And sometimes it might make sense because, as I said, processing time outside the country, then your spouse will be outside the country for a couple of years before they're able to come in. So one way, and of course, I would caution you about using this route because if you come in on a B2 and immediately file for a green card or even file after 90 days, the USCIS can say that you had wrongful intent of immigrating to the US when you actually came in on a B2, if they're able to prove that. They can say that you should have, just filed for the green card while you were outside the country rather than coming on a visitor's visa, because you had the intention of immigrating when you came in, and you should not have that intent when you come in on a B2. So that's something to keep in mind, but it is possible to do. But something to keep in mind that if that issue does come up, then you'll have to prove to the officer that you had no intent of actually filing an immigrant visa petition when you were traveling on a B2, and you made that intent when you came into the country, and after a while you decided, why not? Hey, let me file for a green card, So it might be hard to prove though.
Right. So there's a very small line, but then you have to be careful, I think, friends, and know your intent. If you really want to immigrate, then go for an immigration, for a visa that is immigrant visa. And if you don't want to, then a non-immigrant visa route would be better for you. Otherwise, I think you would take a lot of time just proving it to the USCIS. All right, Prashanthi, thank you so much for that. And yes, there are so many questions from our viewers. I think we should quickly take a few. And the first one would be this one from RK Social. This is on YouTube. Hello, Prashanthi. This is RK. What are the timelines now to get the green card after filing AOS? Category India EB1PD November 2016 and AOS filed on uh, 30th of July 2024.
So the processing time for a 485, since your priority date is current, for a 485 would be about 12 to 14 months. So a year to a year and a half, I think 12 to 18 months maybe. And again, every case is different. So that's why I'm giving such a wide range. Some cases get approved very quickly, and I don't know why or how. But we filed some EB1 cases that got approved in a few months. But would I say that is the general processing time? I wouldn't. You should give it about 12 to 18 months.
Every case is different, and I hope that it'll work best for you and in the earliest possible way, RK. Thank you for your question. Now let's move on to Raghu. This is on Prashanthi's channel. This is also on YouTube. Will there be any spillover expected to EB1 India in coming year 2025, October onwards?
Yes, there might be. If there is a spillover, remember the spillover is from the family-based cases. It spills over to the employment-based cases. Last year, 25,000, there was a 25,000 spillover, which then gets distributed among all the employment-based categories. So that'll be, the EB1 also will get some benefit from, if there is retrogression. And also, the spillover, that the extra numbers are given to the backlogged categories, right? So the Indian nationals are backlogged, it's EB1. Indian nationals are backlogged, and EB1 worldwide is current. It will obviously first go into the backlogged categories, which happen to be EB1s for India.
Right, right. Thank you, Raghu, for your question. I hope it's pretty clear. And if you have more questions, you can keep commenting. Now let's take up this one on LinkedIn. Roger Louis, what about if I have a green card but it is expired? How can I renew it from Bolivia? And there's a follow up. It expired when I was 11 years old, and now I am 39 years old, just to give you the context. The context. Okay.
Yeah, I mean, if you are on a green card, you're expected to enter into the US. After you get the green card, you're expected to live in the US. And if you've traveled outside the country and never came back, or whatever the situation, or you never even came into the country, then when you try to use that green card and come into the country now, they might say that you have abandoned residence. And they might ask you to leave at the port of entry because they might say that you're no longer a permanent resident because you have not maintained your residence in the US. And that's a requirement for a permanent residence, that you not stay outside the country for more than a year at any given point of time. And it's been many, many years that you have not been in the country. So they will stop you for sure at the port of entry, and they will basically make a determination that you have given up or forfeited your green card. And you can either ask to continue to be allowed into the country and then say that you want to go before an immigration judge. And then if you're able to prove to an immigration judge that you have not given up your residence, which is unlikely because you were 11 years old when it first happened, and it's not likely that you've even established residence in the US, and unlikely that you filed a tax return, etc. So again, it depends on a case-by-case basis, but in your case, looks like you might be out of luck with trying to prove before a judge that you maintained your status or residence. So the best way would be to just file that green card again on whatever basis you did it last time, if you're able to.
All the best, Roger. And I'd say, why not consult an attorney, and why not Prashanthi Reddy herself? Her details are scrolling on the screen. Thank you. And moving on, Prashanthi, there is one more question. This is something we received on WhatsApp. My mom's green card application I-130 was approved. She is currently in India. So I filed an I-824 to forward the approval to the NVC for processing at the correct consulate in India for her biometrics appointment. Despite multiple follow up requests, I haven't received any updates from the USCIS. The timeline filed is 6th of December 23. Online case status shows received, but I did not get a mail confirmation. Requested status via email was directed to reach out to the lockbox email, but received no response. What steps can I take to expedite this process and get a response from the USCIS?
Now, there's several questions that we need to ask here to get a better answer. Is the I-130 based? Obviously, you're a U.S. citizen, otherwise you couldn't have filed for your mom, so that's established. If you filed I-130 consular processing, was the I-130 approved? And if it was approved, then the visa number is available. So NVC should be reaching out to you to fill out the immigrant visa petition. They should be sending you an email to fill out the immigrant visa petition and to pay the proper fees, etc. So it could be that your I-130 is not yet approved. Oh, approved, it says. Green card I-130 was approved and NVC has not contacted them so far. My suggestion is to reach out to, there should be an email or a number on the I-130 approval. I would suggest reach out to that. That's a USCIS number, reach out to them. If the I-130 was filed consular processing to start off with, why did you file an I-824? I'm just trying to figure out. So maybe the I-130 was not filed consular processing, but was filed while she was in the country, and now he's converting it to consular processing. Then if you've already filed the I-824, then did you get a receipt of the I-824? So you need to follow up on the I-824 request, which is simple. You can follow up with USCIS. If you've received a receipt, then call USCIS or chat with them, with Emma, and comment if you have any further questions. So it looks like you need to follow up on the I-824 application.
Okay. I really hope this person is able to figure out and probably get a response from the USCIS because the status still shows received. So there should be an update. All the
Yeah,
best.
I-824,
Thank you for the question.
I-824 applications can take time. So maybe it's
Okay.
just pending. As long as it shows pending on the website, when you go to the USCIS case status website, you should be fine. Just wait for a response. If it's taking a long period of time, you can call customer service as well to find out what's happening.
Okay. Thank you so much, Prashanthi, for taking that up and for your suggestions as well. Let's move on to a few more questions from the audience. And now the next one, let's take this one. Ishwar, what are the most critical factors I should consider when strategizing a green card application for the new fiscal year? And how can I optimize my petition for success?
Well, it is a very broad-based question, but I will answer it, and it won't be a complete answer because it'll take me a long time to answer this completely. Maybe several episodes, but what should you strategize? You should make sure you file in the correct category, which will give you the best possible, fastest possible chance of success. Meaning, if you qualify EB1, do EB1. If not EB2, otherwise EB3. Make sure you file your, find a proper attorney to file your case properly, right? You don't want it to get denied, then there's no purpose in filing it. They will follow the processes that are required, or have your employer find a competent attorney to do so. They have to start off with the labor cert process if you're doing it in EB2 or EB3. So they have to do it properly, and they have to file the I-140 properly, meaning signed, fill out the forms properly, follow all the requirements, send it to the right USCIS office, send the correct amount in the checks for the fees, and generally know what the criteria is to file so that they don't make a mistake when filing. So, everything considered, I think using an attorney would, to a great extent help you. Also, when you're deciding on your employer, when you're deciding on a job, you should ask them right in the beginning whether they're going to file a green card for you. Otherwise, you end up joining them, and they may delay filing the green card, or they may not have experience filing it. So they may not want to file it. So that's obviously, the first question that you ask when you take up a job, whether they're willing to file the green card for you. So I think those are some of the pointers that can help.
But Prashanthi, that means there is no other proper way or a tip to really tweak or make the process a little fast, right? Apart from really following everything, the rules
That you need to
basically,
do.
and
Correct.
yeah.
There's premium processing for I-140 cases. You can choose to file in premium by paying the extra amount of money, and that will help you speed up at least one part of the green card
Hmm.
application. There's no premium processing for the labor cert or for the 485. So, you just have to follow the rules and do it properly so that there's no further delay.
Okay. Thank you. Thank you, Ishwar, for your question. I can see another, but I think let's take this one from Devakar first. I am an Indian doctor without license to practice in USA. I recently did my MBBS. Is there any way I can qualify for EB3 or EB2? Currently, I'm in USA. Your suggestions will be appreciated.
Yes, you can, but not as a doctor. Perhaps in another position that requires a bachelor's degree in medicine, and you can show if that's equivalent to, a life sciences degree or a biology degree in the US. And if you have an employer that's willing to file for you, yes, you can. But there is no immediate benefit of filing an EB2 or EB3 without first filing a non-immigrant petition that will allow you to stay in the US, right? Because EB2 or an EB3 doesn't allow you to remain in the US because the visa number is not available for both categories.
Right. Thank you, Devakar, for your question, and thank you, Prashanthi, for taking that up. Now, I think we'll move on to the last question for the day, and this is also from Ishwar. Let's take up the second one. This is what are some innovate what are some innovative tactics or hacks to expedite green card processing, such as using premium this is yeah or concurrent filing, and when would you recommend I employ these strategies?
I think we
We
already discussed this, to a great extent
Yes.
in the beginning of the show. And
Maybe
when do
just
you
the
record?
second part of the question.
Yeah,
When do
when
you
do you
recommend I employ?
premium processing? A lot of people worry about premium processing. They think that if they file under premium processing, the case will get denied, or that there'll be
Mhm.
more scrutiny. I don't think that is so. It's just that the premium processing team is a group of officers that are very experienced in their job. So they will look at it, and if you qualify, they will approve it. It's not that they're going to send RFE needlessly. I don't think they do that just to buy time.
Mhm.
So I would, if you have the money to do it, and if you have the requirement for speed, then you would do it.
Mm. Okay. All the best, Ishwar. I hope you figure out. But yes, I mean, if you have more money, then why not speed up the process as much as you can? All the
Right.
best. Let's take this last one from Venkata. This is when I was about 15 years old, I was hospitalized for depression, but it was only a 72-hour hold. I was not a danger to myself or anyone, and they determined I was perfectly fine, so they let me go home. I took antidepressants for about 2 months, but the medication was stopped because I did not need it. Can I get denied the green card because of this?
No, that shouldn't be a reason for denial. Your past medical history, and a brief incident should not be shouldn't be a cause for concern.
All right. Plus, like, you already were determined that you're perfectly fine and they let you go home. So I'm sure you are perfectly fine. Thank you, Venkata, for your question and also all the very best for your green card. Hope you make it. Thank you so much, Prashanthi. I think we will have to wind up the show. And though we couldn't start on the dot, but I'm sure we really covered up what we were here for today, and that is getting a green card approved in the new fiscal year, tactics and hacks. Thank you so much. And let's, yes, Prashanthi, you were going to say something.
Oh, I was just saying that there's one last question from Ravi Kumar. Should we take that before we leave?
Okay, sure, we can. I am currently living in Europe and I plan to move to USA. My origin is India. I have a B1, B2 visa. So how long the process will take for EB3 skilled and unskilled category?
Yeah, I mean, so as I was saying, you shouldn't, unfortunately for Indian nationals, unlike worldwide, where, they can plan on getting the green card directly and they don't have to think about, the H1 and then coming on a H1 and then filing for a green card because, the visa numbers are available, especially for EB1 and EB2 worldwide. But for Indian nationals, Ravi, like you are, you will not be able to get your green card for the next 20 plus years or God knows how many years. So filing a green card for EB3 is not useful.
Mhm.
It is better way is to file for a non-immigrant petition, come here, and then start your life and then file for the green card because you need to keep extending your H1 if you're filing for a H1, and that's a way of getting unlimited extensions on H1. So
Mhm.
that is why a lot of people file green cards, and also to keep the window, to keep your place in line. That's another reason why they file. But I think, should first focus on getting to the US if you want to migrate, because it's better to migrate on a non-immigrant petition rather than on a green card. And then, getting a place in the line for your green card will follow after you come into the US. I think that's a better strategy.
Thank you. Thank you so much, Prashanthi. And I'm sure that was very helpful, Ravi. What do you have to say? If you have any questions, further questions, you can keep commenting, even if you are watching this after the stream has ended, because we can definitely forward these questions to our experts and even Attorney Prashanthi herself. So thank you so much. And I think with this, we have covered all the questions from our audience as well. Thank you so much, you lovely audience, for those questions, and you've made this session an even more interesting one. And Prashanti, maybe you could give us an end note on the topic we have today. Getting a green card approved in this new fiscal year, so that folks out there have something to hold on to. Maybe.
So yeah, as I was just to summarize what we were talking about,
Yeah.
we talked a little bit about what happened this year with reference to green cards. We said that 165,000 green cards were available for employment-based category. So they increased that uh, the fallover from the family-based cases was 25,000. So they increased that to 165 from the baseline, which is 140. We have to wait and see what the unused numbers will be for worldwide categories, for all categories for next year, to see what that number will be. That really has an impact. That number of 165 or 140, whatever it is, has an impact on the priority dates. Because if there are more numbers
Okay.
available, the priority dates will move faster for all the categories. So we have to really see what those numbers
True.
look like for the following fiscal year, and that will give us an idea as to what to expect with reference to priority dates as well. But in
Mhm.
general, I think EB1 may not be current. I don't know, it's difficult to say for Indian nationals,
Mhm.
but will be close to current. And EB2 and EB3 will not be current. Unless something happens, um, like some law is passed or something happens where the consulates shut down, which we don't want that to happen because we don't want another
Mhm.
epidemic. But for some reason, if the great numbers are not being used by the consulates, then those numbers will actually flood down to the categories for India. And that's what happened during COVID. But other than that, we can, I think, expect more of the same, unless again there's some kind of legislation that happens. And I'm
Mhm.
hoping that something like that will happen and there will be more availability of numbers.
Me too. And I'm sure that the election is definitely going to make a big impact. So let's look out for that as well. That is happening this November. Of course, there is some more time, but until then, of course, folks out there, I would say let's stay hopeful. And since every case is different, you may also want to discuss it personally with the attorneys. So why not contact Attorney Prashanthi Reddy directly? Her number is 212-354-1010. It's there on the screen. You can note it down. You can even call her on the number. Email her prashanthi@reddyesq.com, and definitely go visit their website, reddyesq.com. Thank you so much, Prashanthi, for doing this today. It was really lovely having you here, and it was indeed a very interesting and very informative session. So thank you so much.
Thank you, Nipasa, and look forward to doing another show next Wednesday.
Me too, me too. Yes, folks, Prashanthi is very regular with us. We try and meet every Wednesday at 12. So don't forget to subscribe to our channel. Our handle is Immigration and Jobs Talk Show. Hit the bell icon so that whenever we have discussions like this, you are updated. And thank you, Prashanthi. Have a great day ahead.
Thank you.
So, folks, once again, thank you so much. And you can even contact me. My number is 408-335-6444, and my email address is nipa@higheritpeople.com. And to get to know more about us, definitely visit us at www.higheritpeople.com. If you're looking for project placements, H4 EADs, green cards, anything related to immigration, feel free to contact me, and also check us out. Once again, I would say don't forget to subscribe, because we have another interesting webinar coming up, which is going to happen at 2 p.m. EDT, less than an hour left. So stay tuned and watch our space. Thank you so much for today. Have a great day ahead. See you.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hi everyone, welcome back to Immigration and Jobs Talk Show. I am Rajni Bharana, your host, and let me read out this very important disclaimer here. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone. I'm Rajni Bharana and you're watching Immigration and Jobs Talk Show. And yes, we again have a very interesting and exciting episode lined up just for you. We are thrilled to welcome back the esteemed Dr. Deepika Gupta, who will be sharing her insights on a very intriguing topic. And the topic is what is the future of the US job market. And yes, esteemed astrologer is going to predict for foreign students. And you know what? This topic was actually recommended by one of our viewers in the comments. So, and I shared this with Dr. Deepika, and we thought it was a fantastic idea to dive into. So actually, if we talk about it, so the US job market is a key of concern for many foreign students, especially. So yes, we are going to discuss the many aspects of it, what is going to be good, and how astrology can help these foreign students with getting better jobs. So, without further ado, let's quickly welcome Dr. Deepika on Immigration and Jobs Talk Show once again. Deepika ji, once again, very warm welcome.
Thank you. Thank you, Rajni ji. Thank you
How
so
are you?
much. I'm doing good. Thank you. How are you?
I'm also doing fine, and it's India's Independence Day. So I would also like to wish all the Indians, all over the world, a very, very happy 78th Independence Day. And yes, would you like to say something on this, Dr.
Yes, sure. Yes, we are very proud to be Indians. And see, one of the most oldest civilization and at the same time most learned ones too. So I'm very proud to be Indian, proud to be Indian American, and I again wish each and everyone here a very happy Independence Day.
Thank you so much for that lovely wish. So, guys, a very happy Independence Day to all the Indians, residing all over the world. And yes, with that, we are live on YouTube, LinkedIn, Facebook, and Twitter. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any question that you would like to know from Dr. Deepika about whether it is about US job market or anything related to astrology, and if you also would like your horoscope to be read by Dr. Deepika, so you can also drop down your date of birth and time of birth in the comment section. And yes, keep questioning, keep commenting, and keep asking those questions. And now, without any further ado, Deepika ji, let me ask my very first question for today's show. So the first question that I have is actually a very interesting one. So if you can please tell our lovely viewers how can foreign students use astrology to guide their career choices and job searches in the US?
See, by the horoscope, we can easily analyze what the person will pick up as their career or in which field he or she will be most successful. Years back, one lady came to me from Bay Area and she told me that the son is. I asked her that is your son is into something related to banking or marketing? So she said, no, 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 he's a doctor. I said, oh, he's a doctor. I don't know, but the horoscope does not say that he will be practicing the medicines. So she says, no. I say, okay, study wise he can go into the medicines, but I don't see him practicing medicines. Then after few months she called me and she said, I always wanted my son to be a doctor. He became doctor because he wants to see me happy, but he shifted to the east coast in the New York, and there he's not working as a doctor. He hided that thing from me, and he's working in the hospital and taking care of the marketing stuff of the hospital.
Wow.
He's
Okay.
looking into the, yes, he's looking into the sales and marketing of the hospital, and he's not working. So she says that whenever I call him or if we do a video call, so he's in the hospital. So I never knew. And then he told me that, mom, I never wanted to be a doctor. I became a doctor just to make you happy. I'm always interested in numbers, and I'm more interested into banking, marketing, finance kind of a thing. So he was actually being a doctor, he was looking after the finance thing. So through the horoscope, we can easily analyze what the person is doing, or what the person will be most successful in. So I have shared one chart with you guys. If you can show that on the screen.
Sure. So if you can please show that on the screen, I'm sure that my team is working to display that chart on the screen. Meanwhile, let me ask you one more question, Dr. Deepika. So, Dr. Deepika, is there a particular planet that has to be more prominent in your astrology, which can tell that this is the field you will go into and this is the field you will get success in?
Yes, the
Okay.
10th house and the 10th lord actually tells that what the karma, because 10th house is karma. So, what the karma, what the profession the person is going to follow. See,
Right.
5th house is the house of education. 5th house is your higher education. So, the planets sitting over there, if they don't have the connection with the planets in the 10th house or the 10th lord, if they don't make the connection, then usually, the person studies one field but practices something other. Like you might have seen that people have done, like my father, he's mechanical engineer but he's doing business. so he has never done the job. So
Right.
that way you can check that if the fifth and the 10th lord are making any sense with each other, any connection with each other, so then only the person is going to pursue what he has learned as the higher studies, right? But the 10th house actually tells what field the person will go in. See, if so we can show the chart, right?
Yes, yes, please. Let's please display the chart. Okay, the
So
chart is
see,
here. Mhm.
yeah. So I'm just sharing this
Before,
chart
I'm so
because
sorry. Before you talk about the chart, actually Bhaskar is here and he has posted 1991 in LinkedIn. Bhaskar, I'm sure he's following the show and he wants his horoscope to be read. Maybe he wrote his year. So Bhaskar, if you can also write the exact date, the 1991, but what date were you born in, and also your time of birth also, so that Dr. Deepika can help you with your astrology chart. All
and
right.
the
Thank you
place
so
of
much,
birth,
Bhaskar. Please, and you said
place of birth.
place of birth also. Time
Yeah,
of
that
birth,
is
date
also
of
very
birth, and
important.
place of birth. That is also very
Yeah,
important. Please
yeah.
mention all these three things, Bhaskar, and we'll be happy to help you with your astrology. Um, okay, so please
Okay.
go ahead, Dr. Deepika.
Okay, so now see where I have written 10. So that means the 10th house in the astrology. So just check what planets are here or where the 10th lord is. Let's say if the 10th lord is in the Aries sign. So Aries is the signs of technology. So something related to the technical field, right?
Okay.
Or something related to the central government or the federal government. If the 10th lord has any connection with the Taurus sign, it means something related to, banking, marketing, finance. Then it can be something related to perfumes, jewelry, or something which is very artistic in nature, something which is very expensive. Something which is related to family also. It can be, or something related to the food industry. If the 10th house has any connection or with the Gemini sign, so it means something related to the communication, something related to education, again something related to banking, marketing, or finance. If the 10th house has connection with the Cancer sign, then it means that something related to chemicals, milk products, something which is white in nature. Again, here, see, we have to see, like if the, let's say, 10th lord is sitting in the Cancer sign, right? And the moon is also there. And let's say the Ketu is also there. Then it can also indicate, export import. So
Mm-hmm.
we have to see the permutation combination of all the planets. This is, I'm giving something very, very general. Okay.
Mm-hmm.
So again, the fourth means also moon sign. So anything which is related to the water. Again, if this sign has, some other planets also, it can also say aviation industry,
Mm-hmm.
right? Then if we go to the Leo, so Leo, again, Leo is like, see, it is the king. So anything which is related to the government, anything, again, we have to see the combinations over there. And see, the life on the earth is possible because of the appropriate distance with the sun, right? So
Yeah.
something related to the medicines also can be here. And then in the medicines also, again, the sun governs the bones, so it can be some orthopedic. So then again, we make the more combinations, that what the combinations are actually saying.
Mm-hmm.
Again, if it's the Virgo sign, it strongly says, again, something related to the healthcare industry, something related to the competition kind of a thing. It can be like into the law, because there you are competing with the other person, right? So you both put your things in front of the judge, and then he selects, okay, who is saying right and wrong.
Right.
So something related to the competition, something related to where you facing the enemies, something where into the healthcare industry. If it is in the Libra sign, then Libra, again, banking, marketing, finance. It can be again something related to marriage thing, like marriage counseling or marriage making, or like this food industry, whatever you use in the marriage concept. And see, today there are a lot of options. People have also created different kind of business, right? So now, if we go to the Scorpio, see Scorpio again a hidden thing, right? So something which is hidden. So usually I've seen the people who are into if I say like detectives, so that
Oh,
is the Scorpio, which is hidden, right?
right.
Again, the internal body parts are hidden. Scorpio is again a very, very strong, sign for medicines, because in medicines, things are hidden. You don't see what the organs are there, right? You
Right.
need some machine to look into the, if you have to check whether kidney, liver, anything. So everything is hidden in medicines. So this also, the Scorpio sign is actually a very important sign for people related to medicines, then detectives, then again it's water, so something which is water, related to water. Again it shows oceans, so anything which is related to export import, anything which is related to the trades which needs water, right? And it can be also the factories, that is also from the Scorpio. Then if we go to the Sagittarius, Sagittarius is a very, very pious sign. Usually you will see the 10th house is connected in some or the other way into the Sagittarius. The person is usually into, their professors, teachers, judges, IS officers, IPS officers, all that, the first degree of first class officers, or something highly, highly educated people. And then if it has connection with the sun also, or the fifth house also, they can go into the, again, central government or the state government. Then if it is Capricorn sign, the Capricorn sign, it is again it's kind of a crocodile. So crocodiles are, good on both water and earth. So something which involves both water and earth. And again, the sign of banking, marketing, finance, usually very good businessmen, very, very good businessmen. Again, what planets are making combination, we have to check to see what business is good for them, right? Aquarius is again a sign of communications. Aquarius is again, because it's sixth from sixth, so Bhavat Bhavam concept. So it's again a good sign for the people related to healthcare. And
Right.
then factories, yeah, then factories, then also people related to anything which is, slow but hidden also. Like, have you listened the story of Draupadi, no, Gandhari in Mahabharat? She
Yeah.
delivered 100 babies, right? So,
Mhm.
uh, Kaurav were 100. So, no
Mhm.
lady can deliver 100, right?
Of
It
course.
was actually test tube baby in that time. So,
Right.
Kumbh in Hindi, or I should say actually in Sanskrit, Aquarius is Kumbh. So, if even you have seen the sign, it's like a picture, right? So,
Mhm.
के अंदर बेबीज को बॉर्न किया गया था. इट वॉज नॉट दैट शी डिलीवर्ड 100 बेबीज. तो ये जो कॉन्सेप्ट है टेस्ट ट्यूब बेबीज का, ये उस टाइम पे भी एक्टिव था.
Hmm.
And she delivered 100 babies in that way. So anything again which is hidden and in the dark,
Mhm.
right? So whatever profession you can carry which is hidden and dark, it does
Mhm.
not in the negative aspect, but also the positive aspect. Like again, so medicines, right? So the inside body parts are all hidden and in dark, right? So
Right.
some which is like that. So and then scientists, right? So they just decode the things. So which is hidden, they take it out, right? So scientist, that is over there. Now the Pisces, see, the Pisces is like highly, highly spiritual. So people who are spiritual are highly intelligent also, knowledgeable also. So again, the sign of knowledge, intelligence. Then it represents ocean. So anything related to export import, anything related to water, anything which relate to knowledge, education. So professors, IS officers,
Mm.
um, congressmen, so all they are connected to the Pisces sign. So
Right.
just check through your own horoscope where the 10th lord is sitting, what with what planets it's making, and especially in which sign it is. So that also describes the profession of a person.
Okay, wow, that's really, really interesting and also amazing. I'll ask more question about this, but before I ask about this, Krishna Manohar is here, and he actually has, posted his date of birth, time of birth, and also place of birth. So Bhaskar is there on LinkedIn. Bhaskar, see, as Krishna ji has posted his date of birth, time of birth, and place of birth, you also have to post all the three things. You just have posted 8 June 1990 in India, but where in India? And also, please mention time also, your time of birth. So, Deepika ji, if you can please look into the horoscope of Krishna Manohar.
Okay, so the date of birth is, can you please?
13 February 1984.
Time?
Time is somewhere around 5:30 a.m. to 6 a.m.
I need the exact time, but still, let me see. 5:30 a.m. Let me put 5:30 a.m. only.
Sure.
And
Place of birth is Gangavati, Karnataka, India.
okay. Okay, so this person must be into something related to IT. And
Krishna,
then, yeah,
yeah, if you
can
can
you
please
confirm with
confirm.
the person?
Yeah, if you can please confirm if you are in IT sector, please let us know. And yeah, please,
Engineering, IT.
engineering, IT, and
Yeah. These are the, like, yeah, into engineering and then IT. And then this person will definitely start his own business. And then that timing will be, yeah, in 2029 30, this person is going to start his own business. This is a very, very good chart. Very good chart, very lucky person. But at the same time, has seen his share of problems. But yes, this person is going to start up his own business and will be highly, highly successful. But yeah, it will be started in 2029 30, not before that. So till 2027 end, or I would say till 2028 mid, I see that the person will be
said
struggling.
yes. He says
Yes.
yes, he is into IT. Yeah.
Yeah. Yeah. So yeah, you should start your own, you should start thinking
Think
about
about
your,
at least starting your own business.
yeah, yeah, think about your own business, but at the same time just wait for some more time, at least 2 years, till 2020 6 end. Yeah, you should wait till that. Engineering, IT, yeah, yeah, that's what it says, that this person might be into engineering and IT. Wait till 2026 December, start planning about your own business in 2027 onwards. And then
Mhm.
I see that in 2020, somewhere in 2028, you will start your own venture and you will be highly successful. Very, very good chart.
Wow.
Very good chart. Yeah.
That's a great thing. So, but like, can you see? Is there a possibility to also see what kind of business is he going to be in?
Into IT, something related to
Something
IT.
related to IT only.
Yeah, IT, and then not now, but later in the life, once he will be turning 50 plus, then he will start something. See, there are two combination in this chart. One might be after 10 years, he can get into, like, he will start his own business in IT only, initial stages, and then he'll get into something related to education. He will be opening up his own school, something, or some consultancy where he will be giving some education to the people after 10 years. But once he turns 50, he might be opening some big college or something also.
Okay, okay. All right. So, great. So, Krishna Manohar ji, congratulations. You have a great chart. And yes, please, you are into IT and you already have confirmed that and you are going to start your business soon, but you will have to at least wait for until 2026. After 20, you should at least, start thinking about your business. But after that, you should get into your business because you have great chances of being successful in your business. So,
Yeah, yeah.
congratulations. Yes. And let's take Bhaskar's now. So
Hmm.
Bhaskar has written 8th June 1990, somewhere
Hmm.
around 12 to 12:30 p.m. Telangana in
Okay.
India.
So I'm taking 12:30 p.m. Though I need a perfect timing, but okay, 12:30 p.m. and then uh, Telangana. Okay. Okay, so year 2015 to 19 was very tough with you, Bhaskar ji. And especially 2015 till 2017, it was really tough for you. And then also in the past you might have seen a lot of politics against you. I would say that wait at least till April 2027, and after that this chart is going to start working. But wait till that time, because I see like a lot of confusion happening. And then be very very cautious in 2025 and 2026. Like it will be tough to achieve the goals, and there can be some kind of politics against you. And be very very cautious, very very cautious in 2025 and 26. Be very very cautious. Yeah.
So Bhaskar, I think you have to be really cautious because you have been through a lot, and as Deepika ji said, you will have to be very careful because there have been um,
You
politics
will
has
get
happened in
trapped into
India.
something. Like there will be a trap. So be very careful, very very careful.
There
And
are high
don't
chances
get
of
into
these things
anything.
again happening.
Yeah, and don't get into anything which is against law. Don't get into anything.
That is
Like
against law.
even if people show you a lot of green grass on the other side, please don't get into anything which is against the law.
Don't fall into any trap, because people may try to tempt you or entice you, but you will have to be very careful. You will have to see through those plans and those traps. So just be
Hmm.
very careful.
Yeah.
And yes, one more is here. And so we are getting a lot of horoscopes today, Dr. Deepika. So let me quickly take another one. So I saw one more here from one of our viewers. Um, Krishna
Hmm.
Ji's we have already taken.
Hmm.
Bhanu, Bhaskar we just took. And then Shrikant Hani is also here. And he says 20th November
Hmm.
1999 at 12:30 p.m. Telangana. I see most of the people are born at 12:30. I think
Hmm.
is there a reason behind that?
No, 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 no,
Yeah.
no.
Because today I think we got two or three, and most of them
Yeah,
are
all
born
of them. Yeah.
at 12:30. So that's interesting.
So the person whose chart we just saw, I
Was
think Bhaskar ji,
Bhaskar.
if
Yeah.
he can confirm that was 2015 to 18, was in that time period, was that time period tough for him or not? Yeah.
From 2015 to 2018.
Yes.
So Bhaskar ji is again back, and he says, "Hi, madam. Please tell me again." So Bhaskar ji, please, if you can please confirm whether the time from 2015 to 2019, right, or 2018.
2018.
2018, was it really tough for you? Did you face any difficulties? Please let us know if any such situation, or if any trap that you fell into, or maybe if you were affected by some kind of politics. Please let us know. And okay, meanwhile, let's
Let's
quickly
go
take,
with this.
yeah,
Yeah, November
Srikant Hari,
20. Yeah, 1999, 12:30,
PM
Telangana,
Telangana.
right?
Yeah.
Okay. Very, very good chart. Very, very good chart. This person
Wow.
is going to rise a lot. But wait, once you turn 30 years old, no looking back for you. Very good chart. Start your own venture. But again, as I said, that wait, in the coming 2 to 3 years will be little bit emotionally, only emotionally tough for you. Work wise it's going to be okay, but once you enter 2027, then after May June you can start your own venture. You won't be doing the job. This is a chart of a businessman, and
Wow.
again a very very good chart. 99 born, so I don't think so married. And though we talk here only about the profession, but still I'm just guiding you. You just 99 born. So while getting married, check the horoscope of the spouse, because this chart has the yoga of getting separation, but legally separation, right? And that legal separation can affect you a lot. So can will be
Be
a lot
very
of challenge of money also. So before getting married, check the horoscope
with your
अच्छे से,
partner,
okay?
supposed to be
Yeah.
partner.
Yeah. And then again, a good chart, start something which is related to technology, IT sector. It can be in
So,
future.
what profession is he currently into?
Something related to see, this chart is again very good for the this also. Real estate also very very good chart for real estate. So
Real estate.
sometimes what happens, yeah, sometimes what happens that
I mean, I
the
think
parents
whichever
are.
whatever field that makes money is good for this person, right? It's good for Shrikant.
No, I would say something related to IT sector, technology, then like AI is coming into, so
Right.
something related to that. Then robotics is very good in this chart,
Mhm.
something related to robotics, and then real estate is very, very good in this chart, like very good.
Wow. So congratulations, Shrikant. You have a great chart, and you should, of course, think about starting your own business. But please be very careful regarding your marriage. Like Dr. Deepika said, be very careful while you will be choosing a partner. So you should look into the person's horoscope and everything. Because, of course, when we get in a marriage, so of course, that person's chart and all those things do also affect us, right? So that's why I think in Vedic astrology we have the tradition of looking into the person's chart and kundali, right? And matching the kundalis, right, Dr. Deepika?
Yeah. Though he will not get marriage, I can say after 32, 33rd year only, not
After
before.
30, okay. Then it's a long time, but still, just be very careful.
Yeah.
Okay, so ZQ is also here and he has written, hello Deepika ji, just being curious, 25th November 1981, 7
Okay.
p.m., Dhanmondi,
Just give me
Dhaka,
20,
Bangladesh.
25th November
1981,
1981. Yeah.
7 p.m.,
7 p.m. And
Dhaka,
then,
Bangladesh.
okay.
Okay, so ZQ, I think your horoscope is being read. So please wait for a while. And I can see a lot of people have sent their, I can see more date of birth, time of birth. So people are really waiting in line to get their horoscope read. So anything for ZQ, Dr. Deepika?
Okay. So, ZQ, can you confirm me? Are you something into the healthcare? This chart is good for healthcare. First thing. The second thing is, if you are not into the healthcare, then again, anything which is related to banking, marketing, finance, just wait till again the 30th year. Once, okay, you 81 born. So after the 30th year, you might have done good, and then again, I'm seeing that after this October, you might change your job. Okay, not into that. Okay, you into IT. Acha, so but you might be changing your job and then going something into the healthcare. Again, IT related to the healthcare, because this chart is good. And are you planning to change your job? Because I'm seeing that there will be some, any kind of professional changes after October this year. So if you're planning, then just please confirm.
Okay, so is this change going to be good for him if he does?
Yes, 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 this
Okay.
change is going to be good. So if you're planning, so you can definitely.
Okay.
Yeah, you have
Any
changes.
any
Huh.
advice for him, or anything that he has to be maybe careful about, or
I would say that just, just try to go something related to IT, but into the healthcare, something into the healthcare, because this chart is good and you will be able to get to secure some permanent job. As you saying that you have changed job many times. So that's why I'm saying just try to get into healthcare. Have you done your master's?
please, Ziki, if you can please let us know if you have done your masters or not. Yes, he has done his masters.
Yeah. And the master's in what? Like something related to banking, marketing, finance?
Ziki, if you can please quickly reply. What field did you do your
Yeah.
masters in? No, media communication.
Media communication. Okay. I would say that please try something into the healthcare industry, because this chart is good. Once you go into the healthcare, you will be able to, secure a permanent and a good job. Because healthcare is really good in this chart. So try to get a job into the healthcare system. Okay.
Healthcare sector.
Yeah.
Right, right. Then he's going to have a permanent job and a more secured, and then
Yeah.
he might finally feel happy about, his profession,
Yes.
right?
Yeah.
Okay.
Yeah.
So ZQ, that's the advice for you. Please follow that. Yes, he says, thank you, madam.
Thank you.
And yes, let's quickly come to another viewer, and his name is Atota Paul Moses. And he says, born on July 28th, 1999.
July 28,
99.
1999.
Yeah.
Okay,
At
time.
8:30 p.m. in Guntur, Andhra Pradesh, India.
Andhra Pradesh, right?
Bhaskar is actually back, and he says, my father passed away in 2018 and I struggled a lot from 2018 to 2019. And I
Yeah.
think this is what you said, no? He went through a lot during
Yeah,
that.
because the time is not fixed ना, so I just put 2030, अभी 12-15 भी रह सकता है, तो उस हिसाब से तो मैंने एक time period दिया था कि 15 to 18 का time period comes out to be tough, and he says the father passed away in 2018, right?
Okay, so we were looking into the chart of Atota Paul Moses. So if you can please tell about him.
See, the last 1 or 2 years must be emotionally tough for you, but I'm seeing that the coming time period will be really good for you.
Okay.
Again, till August, September 2026, don't do any major changes in your profession. Don't try to, switch jobs or something. You can land up into a bad situation. After October 2026, there will be a change, some big changes in the professional life, and which will be very, very good for you. You might be even investing in some real estate at that time period, but wait till October, August, I would say September, October 2026. After that, the time is very, very good for you.
Okay, so maybe Paul, if you can please also let us know if you went through anything bad, in the last past through 2 years, like Dr. Deepika said, right, Dr. Deepika? Yes.
Yeah, in especially August, September 2021 to 2022, those years might have been tough with you.
21, 22. Emotionally
Yeah.
draining, right?
Yeah, emotionally draining. Yeah.
If you can please confirm. And yes, after 2026 is what you said, he should think about changing his profession and
Yeah.
also investing in real estate, right?
Yeah,
And
no, he will be investing. Like he
he
will
will
earn
be
that much
investing.
money that he will be
Oh,
investing. See, this chart is something, the person is highly spiritual. Like the last 2-3 years might have taught him some big lessons of life. So the chart is very, very good spiritually. So he will rise a lot spiritually. Like as the time will pass, he will become more and more spiritual.
wow, that's really beautiful. Because
Yeah,
spirituality is something that I think one should incline towards, right?
yeah,
Because
yeah,
that's the if you lead your life with the path of spirituality, life becomes beautiful and also easy for you to live, right?
Yeah.
um and then okay, so
Oh, I think he says yes,
yeah,
exactly.
he says yes, exactly.
Yeah.
So
Yeah.
he went through a lot, it seems, from 2021 to 22.
Your chart is really good. You will rise a lot, but wait till August, September 2026. After that, this chart will open and you will have a lot of material success. But keep doing meditation. I'm not saying be religious, I'm saying be spiritual, because this chart is a very promising chart. And spiritually also you will start getting some messages, and if you will listen to your those
Divine
spiritual,
interventions will happen. Yeah.
yes, you will get the guidance from the god automatically. This chart is that good. Yeah.
That's so beautiful. I wish you
Yeah.
all the best, Paul. So many, many congratulations, and that you're going to have a good future, bright future. But yes, just wait for 2026. And yes, okay, again, let's take Tarun Kumar. So Tarun is also here.
Hmm.
Okay, Mahidhar Reddy is also here, but Mahidhar Reddy, I would like to tell you that if you can also please, you just have posted or commented your date of birth, but we also need time of birth and place of birth. So if you can please also comment those two things. So meanwhile, let's take Tarun Kumar. So Tarun Kumar has written, okay, he has not written about his place, time of birth. He's written 17/5/1990, Sai Santosh, born Telangana, marriage. But I do not see the time of birth. Will it be possible for you to
No,
do his
no.
horoscope reading? Okay.
No, no, no. See, in Bhaskar G's chart, you have seen, like, half an hour makes a lot of difference, because the Navamsha chart, a lot of things change. And here I'm just looking at the chart and predicting, right? Like, you need to sit with the chart, you need to have some background of the person. I don't know anything. I'm just so वो time थोड़ा भी change होगा तो बहुत change हो जाता है. I need exact time of birth. Yeah.
Okay, so yes, if you can please share your exact time of birth. Okay, here it is. We have got it.
Hmm.
17 5 1990. Time is 1:30 a.m.
17 May 1990, and time is 1:30.
1:30 a.m. I think his
1:30.
name is Sai Santosh, actual like the astrology name that we get, right? And he's born in Telangana.
Telangana. Okay, so May 17th, 1990, right? 1:30 a.m. Hyderabad. Oh, sorry, Telangana.
Yeah.
Okay, so the time for you again, 2021, 2021, 2022, this those time period was really tough for you, very, very tough. And you might have taken some decision in life which you are regretting till date. Um, like if this chart has come to me earlier, I would have said कि कोई professional changes मत करना, job change अभी बिल्कुल भी मत करना, not the right time for you to do that thing. So right now, just wait till August, like August, it's already running. So August, September, 2024, and after that, I'm seeing some better prospects for you. First thing. The second thing is that you keep on thinking a lot. So don't do that. Don't, just don't keep on analyzing things on your own. um उसको थोड़ा सा कम करो, then you will be able to think positive and then taking the actions positive, right? So just try to control that. And the chart also says ke, must not be having a very cordial relation with the father, or I would say that there must be some difference of opinion. तो उसको भी try to control, right? Just try to listen what he's saying, right?
Okay. Okay.
Let's go to next chart.
Yes, because I'm continuously getting a lot of them. And Bhaskar is again back and he says, still now I'm having a lot of trouble with my career. When will my good days come? When will I be good to when will it be good for me I think he wants to say when will it be good for his career, the time.
I don't know what I predicted because I'm not
Yeah, we'll
keeping
have
the
to
check.
again go back. So maybe let's take others and then
Yeah.
later we can come back to Bhaskar's.
Yeah.
Okay. um
Next chart.
Rita is saying, is this recorded? No, Rita, this is a live show. It's going live. And Rita is again back and she says, I just joined. So, what is the future of US job market? Did I miss too much? Dr. Deepika, what
Okay, so
do you have to
see, the
say?
US job market will always be good, though I'm seeing that again, the coming 2.5 years going to be tough throughout the world. So obviously, US will also suffer. But again, the horoscope of US is so strong that in future it's going to be good, very good, in fact.
Okay, okay. So, Rita, you don't have to worry because the future is going to be good. And congratulations. So, you just joined. Oh, you said you just joined the stream. So, congratulations for that as well. I hope you're enjoying this webinar. And if you would like your horoscope to be read by Dr. Deepika, please post your date of birth, time of birth, and place of birth. And meanwhile, Dr. Deepika, Mahidha Reddy, he actually is back and he has posted all his details and his time of birth is 8:30 a.m.
Okay, date of birth first.
Date of birth is 2 August 1981
Hmm. Time.
and time is 8:30 a.m.
8:30 a.m. Place of
and
birth.
place of birth is Andhra Pradesh.
Okay.
And he's saying, I'm doing business from past 4 years. I'm in a bad situation.
Hmm. Okay, just give me a second. Let me see.
Rita, you also have to tell us your time of birth. You just have posted your date of birth and place of birth.
Okay. Again, see, going through Mars Venus Dasha, Mars Mahadasha. Obviously, see, you are a lucky guy, no doubt in that. But at the same time, the last 3-4 years, actually, from 2020 onwards, in fact, May, June 2019, the time period change. And then I would suggest that, don't try to keep putting more and more money into this business. Just go with the flow. Wait till February 2025. After that, I'm seeing a little bit better time period for you. But at the same time, see, the best will come in. mm, 2029 onwards. The best will come at that time period. Though from next year onwards, after February, I'm seeing a good growth for you. But the best will come in 2029.
Okay, so Mahidar, the good time is going to come, but you will have to wait for a bit, like how we say it in Hindi, अच्छे के लिए हमेशा थोड़ा सा इंतजार करना पड़ता है. So you will have to do a little bit of wait. So keep waiting. After 2029, the situation is going to be good for you. All right, and now let's quickly go to our next viewer. So the next viewer is, okay, let's quickly take Rita's also. So Rita says, Doha, Qatar, January 2020 to 1996,
First date of birth, please. So
22
January
January 1996,
22 January 1996 and
8,
time.
8 a.m.
Hmm.
and place of birth is Doha, Qatar.
Okay. Very good, chart. Okay. So again, Rita ji, wait till November 2026. After that, slowly and slowly, things will change for you, and it's going to be really, really good at that time period. Go into something related to like banking, marketing, finance, in case like, because this chart is very, very good. In case you are planning to do your own business, then go into something related to beauty, um, mm, something into the healthcare, again in healthcare, again related to beauty, diamonds, jewelry, something related to antiques, something related to which is very, very high end, very, very high end, because very high end people will be your client. So something which is related to water, something which is related to chemicals. So you can just figure it out. I have given you the hints that whatever is related to like, because if you go into something related to beauty products, then again the chemicals are there, beauty,
Right.
and then you can go into something which is high end. A very good chart. This is
Yeah.
not a chart of a someone who is going to do the job. This is a chart of a businesswoman.
Wow. That makes me really happy. So, Rita, I'm so happy for you. Congratulations. And you're going to be a businesswoman. And don't forget that it was the Dr. Deepika who predicted it first. So, so
Thank you.
congratulations. And yes, just from what time did you say? What year is she going to have her business started from?
She will be having from after October, November 2026, she can start.
After October, November. And she says, wow. So,
Yeah, very
congratulations.
good chart.
Very good
Very
job.
lucky. And yeah, you very lucky. Like she can
Are
confirm
you?
that.
Are you? I mean, you can speak. I mean, you can tell that, right? So, are you
Yeah.
really lucky, Rita? If you can please tell us. And congratulations, you have a great future.
Yeah. Yeah.
So, again, let's quickly take. We have just 5 minutes, so let's quickly again take Chethi Reddy. Maybe he
Hmm.
Chethi Reddy says born on November 10, 2000 at 3. Okay, 10 November 2000.
Hmm. Time.
Time is 3 a.m. Telangana, India.
Okay.
And Rita says, ah, yes, I am.
Yeah. That
We can
the
see that
chart
in your
says.
chart, right?
Yeah, the chart says that very lucky, very, very lucky girl. वो जो चाहती होगी उसको मिलता होगा.
So happy for you. So you maybe if you can manifest, world peace, so the world
Yeah.
might also get that.
एंड सी हम बोल देते हैं कि वेरी लकी चार्ट, लाइक जैसे अभी हमने इनके लिए, रीटा के लिए कहा, बट कुछ पास्ट बर्थ के कर्मास है ना कि इस बर्थ में यू एंजॉयिंग दैट थिंग, तो दैट्स व्हाई इट इज सेड दैट कीप ऑन डूइंग गुड कर्मास, राइट?
Right,
अच्छा,
absolutely.
लेट्स टॉक अबाउट दिस नवंबर 10 पर्सन. सो वेरी इमोशनल, वेरी वेरी इमोशनल, लाइफ में अप एंड डाउन हमेशा ही लगा रहता है. रिलेशनशिप्स तो मेटीरियलाइज बहुत मुश्किल से होते होंगे, अगर डेट भी करते होंगे किसी को तो बहुत नहीं चलता होगा. बट प्रोफेशनली द चार्ट इज वेरी वेरी गुड, वेरी वेरी गुड चार्ट प्रोफेशनली. तो यू कैन डू समथिंग विच इज रिलेटेड टू कंसल्टेंसी, एजुकेशन, anything which is related to again banking, marketing, finance, again anything which is related to IT, but more of consultancy, more of something which is related to giving some kind of education, and then you can open up your own IT company also, right? So a very very good chart.
So
Relationship, huh?
if he's lucky in one part, then he's if he's unlucky in one part, then he's also lucky in the other one, right? Professionally, he's really
Yeah,
really lucky, but as you said, the dating and all that, it doesn't go really well. But then, of course, professionally, it's
very
really
good
good for
chart.
him.
बट अगेन ऐसा नहीं है कि मतलब मेटीरियलाइज नहीं होंगे, ऑब्वियसली कुछ रेमेडीज करी जाएंगी, तो ये चार्ट ऐसा है कि रेमेडीज के थ्रू उसको मेटीरियलाइज किया जा सकता है. बट प्रॉब्लम इमोशंस को लेकर के होती होगी. लाइक द पर्सन इज अ मेल और फीमेल, दिस पर्सन November 10. रजनी जी, द पर्सन इज मेल और
November
फीमेल?
10, Chethi Reddy Raju. So So yeah, I think a male, right?
A male. So
So Chethi Reddy Raju.
yeah,
Yeah.
if a male, then must be tall, good looking, and very emotional, or emotions की वजह से problem ज़्यादा आती होगी. Must be a food lover, or must be like good cook even. Yeah.
Wow, that's really great. Okay, so guys, we don't have much time, Chethi Reddy. I am again happy for you. You know, maybe it's your indication from the universe. You are getting a sign that rather than focusing on love and all that, you should focus on your profession, on your career. You know, because that is something which is what you're very, very
But
lucky
at
in.
the same
So
time,
right now,
ऐसे
focus
लोग
on
रह
that
नहीं
and
पाते
wait to
हैं
of
relations
course.
के बिना. मतलब they are so
That is also
emotional
true.
कि they need someone with them. So ऐसे लोग रह नहीं पाते हैं. Yeah,
Of course.
मतलब उनके लिए बड़ा tough होता है without emotions. मतलब without partner. So they love to have
Of
someone
course, of course.
around.
Because emotional
Yeah,
attachment and all that. If emotions come into
yeah,
play, so it's
yeah.
really
Very
hard
hard
for
for them.
a person to, of course, live life. But okay, let's quickly take one last. Okay, because I know Dr. Deepika has one more show,
Yeah,
so let's quickly take
yeah.
one last. So Nitin wants to get married, so let's
Hmm.
take Nitin's maybe. So Nitin Reddy is here. He says
Hmm.
Hyderabad and Telangana.
Date of birth.
Okay, what is the date of birth, Nitin? Okay,
Hmm.
15/7,
Okay,
1991.
July 15th, 1991. Time.
Time is, I think, 1:40 p.m.
Hmm. And place is Telangana.
Is Hyderabad, Telangana. And Chaiti Reddy says, exactly, I'm very emotional. Dr. Deepika can see it in your chart. So don't worry. You're lucky in your
Yeah.
career. So maybe right now, maybe you can focus on that, because that is something, like there is a quote, no, the love can leave you,
Yeah.
but your career will never wake up and tell you
Yeah.
I'm not there. So let's just focus on that. Okay, coming to Nitin Reddy. Just want to know, when can I get married? What do you
I
have to
would
say, Dr.
say
Deepika?
I'm seeing a late marriage in this chart, right? Because see, to calculate the age, exact age, it will take some time. Though the exact age can be predicted, but again, it will take some time, and it's already the time is up. But I will guide you. Like first of all, जल्दबाजी बिल्कुल भी मत करना marriage में. You will get a good partner, but आराम से like देखो पहले समझो इंसान को and then get into the marriage, because you can get जल्दबाजी will bring a partner which will be very very strong headed, and then you also strong headed as a person. तो वो फिर थोड़ा सा प्रॉब्लम रहेगी. एक वाइब्रेशंस नहीं मैच हो पाएंगी, बिकॉज द पर्सन कैन बी स्ट्रॉन्ग हेडेड, द पर्सन विल बी वेरी मच इन्फ्लुएंस्ड बाय हर ओन फैमिली. तो आराम से पहले आप समझो एंड देन गेट इनटू द मैरिज थिंग, राइट?
Of course, of course. All right, so Nitin, don't rush. There's no rush. You're just 1991 born, so that's okay. Even if your marriage is delayed, that's all right. The only point is of having the right and correct partner, because if you just rush into getting married and then you get a partner which is opposite to your thinking, and then so it will create another problem for you. So I think your wait should be worth. So just like Dr. Deepika said, you
Yes.
should wait. Well, we still have a lot of, what we say, these charts here. But Dr. Deepika, I don't have enough. We don't have enough time, unfortunately, because
Yeah.
you have a show and then we have another webinar coming up. So, guys, I'm really sorry about that, but don't worry. We do these shows every Thursday at 1 p.m. EDT. So you can always tune in on Thursdays to Immigration and Jobs Talk Show, and please keep posting your charts, and we'll be more than happy to take your charts, and we'll be more than happy to Dr. Deepika will be more than happy to read your
Yeah,
horoscopes,
yeah,
right,
yeah.
Dr.
I'll be
Deepika?
happy in doing that, because see, I enjoy see how much astrology work. You can see I don't even know any one of them, and then And then just in a blink of an eye, I'm telling like at least 2 to 3 things, right? And when I take full time, then I deeply study the horoscope, that what I'm seeing in the past, what the person has done, his karma, why he's facing the thing, what remedies he or she can do to get rid of those karmas, right?
Mhm. Of course, and if you want to get a detailed consultation, so you can always get in touch with Dr. Deepika. Her details are scrolling below. You can give her a call on a number which is 732-979-2080. I would like to repeat the number, and I would also like to display it here for you all to see. Okay, so Dr. Deepika, 732-979-2080. You can also email her at ohmhhllc@gmail.com. You can also visit her website, which is www.ohmhh.com. And for that detailed consultation, of course, you will have to pay. So it is going to be a paid consultation, and but it's going to be worth it. So, you can get in touch with Dr. Deepika, and you can ask her to read your horoscope in detail. And you can also ask for the remedies, right? So, Dr. Deepika, it was again great having you. We couldn't, because we got so many horoscope, we didn't get a chance to actually ask our questions. But no worries. Hopefully, in our next session. So next Thursday we will have the same topic, and we will dig deep and dive deep into the topic. And of course, the pending horoscope we will be taking
Yes,
in that
definitely.
episode.
I'm going to do that, and I can see Bhaskar ji is writing, okay, ma'am, it will take 5 minutes. So definitely, I'm going to read your horoscope. Just be active on this show, and we will meet again next Thursday, right?
Bhaskar ji, don't worry. Next Thursday, 1 p.m. EDT and 10:30 p.m. IST. Just note it down. Make a reminder for yourself, so that you can get a reminder, or just subscribe to Immigration and Jobs Talk Show. You will see the flyers, see the details all over there, and yes, you will get all the details about the show. So
Yeah.
join us next time. Thank you so much, Dr. Deepika, once again. It was a pleasure having you. Already looking forward
Yes.
to another
Thank you.
episode.
Thank you. Bye.
Bye. Guys, and if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is 732-707-9151. My email is rajni@higheritpeople.com, and our website is www.higheritpeople.com. We have another webinar coming up with Parvathaneni, so don't forget to watch that. So just be here. Don't go anywhere. I'll be going, but you stay here. Only on Immigration and Jobs Talk Show. Bye, everyone.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website.
Good morning, good afternoon, good evening, everyone. Welcome to Immigration and Jobs Talk Show. I'm your host, Prashant, and I'm really very thrilled to have you join us today across YouTube, LinkedIn, Facebook. And thank you for tuning in, by the way, folks. So, Totally encourage you to participate. But before we start off today's session, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, definitely, I encourage you to participate in the conversation, friends, wherever you're watching us from. Join us by commenting in the comments as comment section, and feel free to ask your questions or share your thoughts throughout the webinar. And if you have any questions or experience to share, even, you may feel free. So, we love to hear from our audience. That's what I need you to know. And thank you once again for joining. And today on Immigration and Jobs Talk Show, on this very webinar, we have a very special guest once again. This is Justin Rivera joining us. I think this will be the third time joining us for another webinar. Well, thank you so much, Justin, for joining us once again. It's really such a pleasure to have you here.
Mm-hmm. Thank you so much for having me. It's always nice to be on.
Thank you, thank you. And for folks out there who are maybe seeing Justin for the first time here on Immigration and Jobs Talk Show, let me tell you that Justin Rivera is an esteemed employment-based immigration law attorney with Wasden Law. And Justin is not only a defender of H1B visa applicants, but is also dedicated community advocate. So it's really such a pleasure to have you once again with us, Justin.
Thanks.
And once again, we are going to be speaking about the H1B cap lottery. I mean, last session we spoke about the second lottery, the announcements, and some of you got selected. But today's session, I think, is going to be more for those of you all who couldn't get selected in this second lottery. And what next then? Not just in the second lottery, but in this whole lottery. So thank you so much, Justin. What can folks out there expect from us this session?
Yeah, I think we'll touch a little bit on the issues. Sorry, wife calling. I think we'll touch a little bit on, what do you do if you've been selected from an employer and employee perspective, and then what to do in circumstances where you weren't selected, kind of what your options are. And then I think maybe some more general topics of just kind of discussing a little bit more regarding some of the recent FAQs that have come out for the H1B visa.
True. Absolutely. So we'll dive into what options are available if you were not selected in the lottery, and probably how to navigate your career and your immigration journey to the United States. So without
Mhm.
further ado, I think we'll just dive into our questions directly, since Justin is here for a short while only. So Justin, can you elaborate on the recent USCIS announcement regarding the second H1B lottery for the fiscal year 2025 cap, and what are the key details that petitioners should be aware of?
Yeah, so it's closed. That second lottery has been run. Everyone who's been selected, the petitioner, which is going to be your employer, has been notified. So at this point, more likely than not, if you haven't heard from your employer, then your case was likely not selected. What this means is that selected individuals, they have 90 days to file their H1Bs with USCIS. You need to file within that window. Like the last lottery, there's kind of a general statement that USCIS is not going to provide any exceptions for people who file late. So you do want to get that filing in. Now, that being said, last lottery, they did provide a small extension for filings based on some technical difficulties that had occurred. So they did give a little bit longer window, but I would not bank on that this time. Definitely try and file your cases early. The reason why you really want to file early or well before that deadline is cases can be rejected, and there have been instances of proper rejection and improper rejection. There's a litany of reasons why a case could be rejected, maybe a lack of signatures in specific areas, lack of correct fees, maybe somehow the case was sent to the wrong location, and then worst of all, an improper rejection by the by USCIS. So in that circumstance, you're probably not going to see that packet that's been rejected for probably a week, maybe longer, depending on mailing, where you are, where it was sent. So that's why I would definitely say, be aware of your deadline, but I would say try to make sure that your case is submitted at least 2 weeks before that deadline if you're able to do so.
There you go, friends. You know what to do. And 2 weeks, I mean, try to have some time in hand so that at least if you have to rework on something, you still have some time and not
Right.
going to submit at the nick of time. And even if you have to make any changes, you just don't have time anymore for that.
Mhm.
So thank you, Justin, for taking that up. Moving on now, I think I got the second question. So next is, what specific criteria must registrations meet to qualify for selection in the second lottery? But since it's already done, it's closed. Are there any
Mhm.
particular factors that could influence a registration's eligibility?
So for this round, we were looking at regular cap only. So everybody that that's been selected was out of that grouping, that regular cap. So you weren't in a situation where having an advanced degree, U.S. master's degree or higher, is going to put you at an advantage. So kind of
Hmm.
a quick understanding of how the normal lottery works is the normal lottery, you have the initial lottery run, and then you have the advanced degree lottery run. And the reason why that's so advantageous for people with advanced degrees is you basically get a second lottery run that's going to be just for you and other people with the US master's degree criteria met. And it's
Hmm.
run after the first. So you've already had people taken out of the pot that have master's degrees. So it gives you an advantage when you're being selected. That wasn't the case here. So in this circumstance, you're looking at everyone in that regular cap being um, sorry about that. You have
It's all right.
everyone coming in at an equal playing field. Everyone's coming in at the same level. Now, that being said, I do want to point something out that's kind of nice to have this time around. There's only a regular cap. You have to select
Hmm.
which cap you are filing under at the time that you file. A pitfall that I definitely advise making sure is taken care of is making sure that you select the right cap. That's kind of a point of no return. If you select the wrong cap when you file, you're going to be in trouble. You're going to have issues where you're going to see an RFE asking for justification why you filed in the wrong cap. This
Yes.
time, it's all regular cap. Everybody's selecting the same box. You don't have to look at the selection notice to make a determination. It's already said
Hmm.
right there for you. It's just going to be regular cap across the board.
Thank you. Thank you. I'm sure, Justin, I think you're in a hurry, right?
Yeah,
Is there an
I'm
emergency?
not too much of a hurry. I'm okay. I just my wife's asking me stuff.
Okay, that's fine then. All right. Thank you. Thank you for being patient. And folks out there, we are here. So thank you, Nishant, for your questions. Stay with us. We will take them up. For now, Justin, if you could just tell us, what steps should applicants take immediately after learning that they have been or not been selected in the second lottery, in the second H1B lottery? So first, let's go with if they have been selected.
So people who have been selected, I think what you're looking at here is you need to move forward in tandem with your employer to make sure that you're filing as quickly as possible while ensuring that the proper documentation is included in your petition. So obviously you need that certified LCA. That takes 7 days to certify. Your employer needs to comply with the posting and notice requirements in that time frame. You're going to need to file with the I-129 form with the correct requisite signatures. Big thing
Hmm.
to remember on signatures. I know it's a small thing to think about, but you are now allowed to use a copy of a handwritten signature. So if time is
Okay.
of the essence and you're in a circumstance where you don't want to mail forms back and forth, the client is completely capable of printing, signing, scanning, and returning a copy of the document signed. And you can use that as an alternative. Now, I will say, it's a preference of a law firm. Maybe some law firms like to use the more traditional paper route because they have a system in place. But
Hmm.
I'm more of the belief that if you're given an easier way to do something, you should do that. So the signatures, the offer letter, you need the description of employment. Maybe if you're working at a third party, you might need evidence of that consulting engagement. via, contracts with the vendor, client letters, maybe, if those are available. I think the biggest focus is going to be, what does USCIS have the ability to look at? And that's going to be, does the position qualify as a specialty occupation? Has the position been placed in the right SOC code, the right occupational category? An example of that would be, let's say someone's a software developer and you're filing an H1B for a software developer, and for whatever reason, they use the SOC code for a computer systems analyst. You have to really get down to what the person's doing, the job duties that are being performed, to make the determination of where the position qualifies. An attorney is going to be able to take care of that for you. But in order to do that, you have to give the attorney as detailed a description as possible of what the position is. You're going to be including that in a support letter, a document that's going to be signed by the client explaining the position. And the other big thing to remember is the beneficiary's qualifications. Obviously, you have to show how you're qualified for the specialty occupation position. To do that, if you have a non-US degree, a foreign degree, you must submit an evaluation. Not an evaluation, a translation, a certified English translation. I think an evaluation should also be done as well. Just knock it out. Do the eval with the translation, show that it's consummate to a US degree, makes everything a lot easier for you. The other thing is looking at the type of degree that's being used to qualify someone for the position and making sure that there is that nexus. There needs to be a connectivity between what the person's doing and their field of study. If there is not a nexus that's clearly identifiable, then you're getting into, do we need to do, there's different phrases for this, combo eval, an education plus experience eval. That's where you're going to be looking at taking work experience, professional work experience, combining it with the education to show that the person has a hybrid of the two that's equivalent to a degree in an applicable field. So again, those are really kind of the big issues to look at if whether or not that's going to line up. You can always file and see if the case gets an RFE to kind of save money if you don't want to do the evals. But I think that you should definitely just go ahead and present the strongest case you have up front, especially for this one. This is the first H1B. This is going to be giving someone cap exempt status moving forward. So that would be my general recommendation. And then I believe you had asked kind of on the flip side of that about people who were not selected.
Yes, that's my second part. I mean, what if people were not selected in this lottery? What do they do? What's their next step?
So I think John and I had talked about this a little bit on Wednesday, if I remember right. Gosh, the week goes by fast.
I know, right?
We had spoken about this a little bit previously, and we had talked about going to and looking for H1B cap exempt employers. So there are entities that are able to file H1Bs without an individual that has gone through the lottery. So an example of that's going to be nonprofit higher institutions, nonprofits that are working in tandem with a higher institution, and then nonprofits or U.S. government research organizations. So these are all different employers that they don't have to have the employee have gone through the lottery in order to hire them on an H1B. So I would definitely look at that. Another option that I think is often talked about is if you're on an F1 and you're running out of time. I think the most common issue is your STEM OPT, or maybe you're on OPT and your degree didn't qualify for STEM. The issue of maxing out on that time for work authorization. I think you have the option of moving up a degree level. So if maybe you have a bachelor's degree and you haven't pursued that master's, moving up to a master's. If you're from a master's, moving up to a PhD. So moving up a degree level and then maybe thinking about pursuing CPT. I definitely would generally advise trying, if possible, to stay away from doing CPT at the same degree level that you've already completed OPT at. Those second master's ideals where people, they already have a degree from school X and they go to school Y. And they're at the same degree level. I definitely in the past have seen pushback from USCIS regarding maintenance of F1 status when someone does that. So I would be careful for that. But if you are able to move up a degree level, I think that that's a good option. You have the spouse option, which we've talked about before, which is not applicable to everyone, but If you have a partner that's on H1B, perhaps you move over to H4. You have an L1 partner, you move over to L2, you get that employment incident to status, and you're authorized to work. Other options that I kind of just had thought about, because we had talked about this a bit on Wednesday, the L1.
Mhm.
So the L1 would definitely be something to consider if you are someone who's been registered in the lottery outside the United States and you haven't been selected. Now, you have to have that full year working abroad with a foreign employer, and the foreign employer has to have a qualifying relationship with the U.S. entity in order for you to be sponsored. Now, there's other qualifications. An L1A is for a manager, and L1B is for specialized knowledge. But at the outset, I look at first, is there a qualifying relationship between your current foreign employer and maybe the U.S. company that tried to sponsor you for that H1B that you weren't selected on? Right.
Mhm.
So if that's the case, and you've got that 1 year of continuous employment within the past 3 years, I would try to explore the option of looking for an L1. The specialized knowledge route, that's going to be, based on what kind of intimate understanding you have of your organization and how it's applicable to moving over to work in the U.S. The manager is a little bit, L1A manager is a little, I don't want to say more hardline. Basically, my way to say it for this is the L1A manager is pretty like clear cut. Are you managing people? Like, are you managing individuals? Are you managing professional employees? There's also the option of a functional manager, which I'm not going to get into detail about. If you think about that as an option, schedule a consultation with an attorney so that you can really get into the nitty gritty of that. But that's an option too. And then I also would say the TN visa for people who
Mhm.
have Canadian or Mexican nationality or passports. That's another option that you can explore too for work authorization. For
Mhm.
the teams, for the Canadians, it's actually a pretty clear cut deal. They can actually apply right at the port of entry for TN status. They actually don't even have to go through the consulate. Whereas, unfortunately, if Mexico is the route you're going by, you are going to have to at least first schedule that appointment at the consulate. But that's another option based on your country of origin or your nationality. And that's pretty much all I can think of off the top of my head. We can get into details more later if we want about the E1 and E2, but I think those are even more nuanced options that
For sure.
require further analysis.
So true. And thank you so much, Justin, really for touching up again. And folks out there, I would really like to tell you at this moment that you should definitely check out our channel, Immigration and Jobs Talk Show, because we've had Justin and also Jonathan Wasden join us earlier, and we've discussed about the second lottery, what are the options, and even actually, Justin, we had an episode earlier, though it wasn't so clear because of our internet issues, technical issues, but we did discuss, and definitely check them out as well. These webinars are very, very informative, and you might not want to miss out on them. All right.
Yeah.
So, right, Justin, we spoke about very important things last time. Yeah. So now my next question for you is like, how critical is it for selected applicants to file their H1B petitions promptly? And what are the potential risks or delays or inaccuracies in the filing process? Are there any common pitfalls that they should avoid or can avoid?
Huh. Yeah. I mean, obviously, kind of as we touched on, it's very important that you file as expeditiously as quickly as possible to make sure that you're filing within that window and that your case is received by USCIS properly.
Mhm.
The things to look out for are going to be rejections, obviously. So that's an instance where, for whatever reason, the case is rejected by USCIS. That's why I advise you try to file early. I know you have that 90-day window, but I would really say cut 2 weeks off that window and say this is your definitive deadline for filing, just in the event that you deal with a rejection. Other things that I would probably look to avoid, your LCA needs to be correct. And what I mean by that is your LCA should properly reflect the actual work locations where you're going to be performing services. So if you are someone who is working at a client location, then that address
Mhm.
needs to be included on your LCA. If you're working at home, that address needs to be included on the LCA. It is important to make sure that your labor condition application is accurate, not only for when your case is being processed by USCIS, but later on down the road when you're looking into potential compliance issues with FD&S.
Mm-hmm.
So for those who don't know, FD&S has the ability to investigate any petitions that have been approved by USCIS. This means that at any point they could visit a work site and request information on what the employee's been doing, call a supervisor, things of that nature. So you want to make sure all of that information is accurately reflected. The last two would definitely be, make sure that it's actually great to go back and kind of talk on this for a second. When you are selecting the SOC code, making sure that the person's the right position type, another important thing to consider is the wage. How much you're paying the individual and whether or not that wage is compliant. So if you're paying, somebody to do work where they're managing a large group of people or maybe a large number of projects, and you say that it's an entry-level position because you want to pay the level 1 wage, that's probably a red flag to USCIS because they're looking at the nature of what the person's doing and they're saying, how is this an entry-level position? If this person is, a large-scale manager, they should probably be at a higher wage level based on that, maybe a level 3 or a level 4. So that's another thing to consider because that's definitely something that USCIS can come back on. I remember specifically I believe it was the first year of the Trump administration, there was just a colossal influx of RFEs and related to the level 1 wage. Specifically that basically, all of these companies were just saying all these positions were entry level and then not bothering to do a real detailed analysis of what the people were doing in these positions. So you have to be able to defend that, you have to be able to defend what it is that you're putting in the petition. So the way that I like to look at it is this. Every petition that I'm reviewing and submitting to USCIS, my thought process is always, what can the officer attack? What is it that's missing or deficient from this petition that would give them a justification to issue an RFE? And what can I do to make sure that that's not the case? I mean, the simple matter is sometimes there's not document X available. It's not there. Or, you've already filed the LCA and you're kind of, you need to get the case done because you're running out of time and you do a second look and you think, oh, maybe the wage level's online. You still have to put the case out and get it filed. But I would definitely say make sure you do your due diligence. And that really comes back to starting early. I mean, we know now who's been selected. You have plenty of time. You have about 3 months to get these
3
cases
months,
in.
90 days, right?
Right. So you really need to make sure that what you're doing is presenting the strongest petition possible.
So it's the correct time, friends, to go out there. If you don't have an attorney yet, go get one and do everything right. And just like Justin has mentioned, how can you be attacked and make sure that you will not be attacked. So make sure that you don't get an RFE also for that matter.
Yeah, and I mean these are
All right.
incredibly important filings. I mean, as we've learned from looking at the data from this year's lottery, it looks like there's a negative trend towards selection rate, meaning that the probability of you being selected in the lottery is trending downward right now. It's becoming more difficult for people to be selected based on the changes that have been made over the last couple of years, combined probably with the negative impacts of the economy that are creating a less willingness for people to file. John and I had talked about this last week. These increased fees. What is the impact of these increased fees on the probability of companies continuing to want to file for new H1Bs? I'm not professing that I know the future, but it's logical to conclude that, like John said, as the amount something costs goes up, the demand for it is going to go down. So
go down, right.
Those of you who have been selected this year, this is incredibly pivotal for you. You really, really, really need to do everything possible to ensure that you're able to get that case approved this year.
Yes. Make it count, friends. I mean, nobody just gets lucky in a lottery, so make it count. And also another thing is, if you should definitely go follow Wasden Immigration Litigation on LinkedIn for more updates on anything related to immigration. All right. So thank you so much, Justin, for taking that up. And yes, I think we should definitely move on to our audience out there. So Sam Dilton says, hi, Justin. And he has a question. Is it possible to apply for an O1 visa if I have extraordinary abilities in my field? Or if I have STEM education, wanted to check the options after being not selected in the lottery?
Okay. Yeah, so I think we've seen this question come up a couple times in regards to the O1. So the O1 can be a viable option for someone that is able to show extraordinary ability. It's a high bar, okay? That's a higher bar than there is for an H1B. It's a higher bar than there is for an L1. It's simply a much higher bar. Extraordinary ability is things like, you know, international acclaim, awards, research papers. You've judged competitions. You've worked with distinguished companies. It's a very, very high bar. The factors are available on USCIS's website if you want to look at them. I will say that people in AI, because of recent changes made in the Biden administration, people who are working in AI now have a better chance filing for an O1 because the Biden administration has made it known this is something that they want. They want to retain international talent that is proficient at AI. So I would definitely say if that's the specific field that you're in, you might want to look into speaking with an attorney about whether or not you qualify. Maybe you need to strategize. You need to look in and say, what actually am I missing and what do I need to do in order to eventually qualify for an O1 and begin taking those steps. I definitely think that it's not easy to be a kid that goes straight out of college to an O1. I don't think that it's easy because you have to produce a lot of justified documentation to show that you qualify. Now, that being said, I've seen it happen. I've actually seen a case recently where someone got an O1 for their interactive work with artificial intelligence, and they had just come out of school. They had judged competitions while they were in school. They were very distinguished in their field. They had, written papers. They had worked for big, cutting-edge AI company, and they were moving over to work for a new startup company that was going to be sponsoring them. And they were able to get an O1 approved. So it can be done, but you have to work with an attorney. It's nothing short of insane to try to file an O1 on your own. They are so document intensive, and they have to comply so specifically with the rigorous requirements of USCIS that I would definitely say, make sure you do that. Make sure you work with an attorney that has good experience doing O1s as well.
That's great. That's great. Thank you so much, Justin. But just in case, Sam, not to, discourage you or anything, but just in case if Sam doesn't qualify for an O1, what other option does he have?
Well, if he's on the F1 and he's hopefully taken advantage, obviously, of his OPT and that STEM OPT. We've talked about a little bit about the options that people have moving up a degree level if they have the ability to do so. Moving up from that bachelor's to master's, that master's to a PhD if they have the ability to do so. And then you're probably looking at maybe working with a cap exempt employer as well. That could even be twofold if you're trying to build your docket up for an O1. Maybe you can go work with a research, a government research organization that is going to allow you to produce work product that can later be used to justify the qualifications for an O1. So I would probably explore those options and see if there's anything that's available to you.
I was thinking you'll say P3 or something because when I think about O1, it's mostly like artists and extraordinary people who are really world famous and stuff like that. So, but yeah.
It's surprising, but that is true. The O1 is that very high threshold, but I've definitely seen people get O1s that no one has heard of unless they're working within that industry. My favorite case that I've done for an O1 was someone who extraordinary ability in marketing. Someone that had worked on a bunch of very interesting campaigns for some big clients.
Wow.
Can't say their names, obviously, but really big. And it was actually very cool to work on because in the moment I actually learned, oh, well, that's who made that commercial. That's the commercial for, company A that you see on TV all the time or on the internet all the time. This person's the one who put everything in place. They came up with the idea.
Wow.
They helped hire. Yeah. So what I mean by that to say is that, yes, the O1 is for distinguished and talented individuals, but it's really going to be in the field that you're looking at. So just because you're someone that doesn't have a Nobel Prize, that's I think the easiest go-to. You have a Nobel Prize, or you're an O1 because you won an Olympic medal. Like, yeah, those are going to be pretty clear-cut O1s. But there are ways to qualify for an O1 outside of those kind of clear-cut options.
Okay, thank you. Thank you so much. That was very well explained, and I'm sure, Sam, you have more clarity on how to go about this now. Moving on, let's take up this next one. This is from Nishant asking, my OPT STEM is expiring December 21st, 2024. I am on a full-time with a banking client. They
Mhm.
have confirmed that I was not shortlisted. What are my options? And I don't want to move to CPT.
I mean, you're kind of putting yourself in a situation if you're taking CPT off the table, but it's understandable. I would say you have to. My first thing would be going up a degree level if you can. Would be the first thought process if you're trying to maintain work authorization, because that's probably going to be the easiest option for you. Outside of that, you kind of have to look at what's this person's nationality. Do they have the opportunity to maybe try for a TN as opposed to an H1B? Since they're not going to be able to qualify for that. You're not going to be able to stay with that banking client if you're trying to move to a cap exempt H, because they're not going to qualify, I'm guessing. So really, I think what you're looking at is going up a degree level. And even if you don't want to do CPT, that's probably how you're going to maintain your work authorization. Because the only other real option for you is maybe seeing if you are qualifying for a TN. Maybe explore the E1 or E2 options. But if you're a student just coming out of school, I don't know if you're going to be able to meet those thresholds. So yeah, I'm sorry. I know you probably don't want to do CPT, but that might be your best pick if you're trying to stay with that client. The only other option, like just spitballing off the top of my head, would maybe be, are you open to working outside of the US for a year? And maybe, if the company has a foreign affiliate, can you go to Canada and work in Canada for a year? You're still staying in North America. You can work with that foreign affiliate for a year, and then maybe they can explore the option of doing an L1 for you. Or maybe you're working at a company in Mexico. So that's it. That's kind of all I got for you. Sorry you weren't picked, and it's probably not the answer you want, but it's the answer I have.
Thank you, and all the best, Nishant. Look for it and try and maybe give CPT a chance as well. Moving on, this is Pedo Drew. Hi, my H1B has not picked in the second lottery. Can we expect the lottery this year? And what is the current job market in the US? Can we expect any changes in the next year?
Okay, so first off, we've disclaimered this already about legal advice, but to further disclaimer, I'm not like a CNN analyst or something that has the ability to predict the economy. All I really know about is what happens with my retirement at this point. So yeah, I think it's very hard to be predictive of the job market. I mean, international things are going to impact that. As you can see, there's turmoil overseas in multiple areas where there's active conflict.
Right.
We don't know what's going to happen with that. We have no idea who's going to win the election. That's going to be another thing that could be outcome determinative for the economy and the job market. Can we expect a third lottery this year, though? I think we may have touched on this a little bit previously. The problem with a third lottery is time. I just feel it's very difficult to think that USCIS is going to have time. This current filing window runs all the way up until November. I would assume they wait until it's pretty close to closing, if not closing, if they were going to make any sort of determination. And at that point, what do you do with a third lottery? I mean, are you picking people and telling them that they can file from November to March? Because then you're literally running into registration for next year. So you
Right.
do have
And
to, yeah,
it's like we'll have
USCIS.
the holiday period in between, like December,
Right.
January. I don't think people will work
Right.
at
You're
all.
dealing with office closures. This is a government entity. To think that they're going to be putting in overtime for this is ridiculous.
Yes.
So no, I cannot realistically see there being a third lottery, but I will say the exact same thing I said last time. I hope I'm wrong. I would love to be incorrect and for there to be a third lottery, but I just, looking at the factors, don't think that that's going to happen. So
Right.
that's my input on that. And then about the job market, I have no idea, guys. I don't know. I have no idea. I mean, you've seen recent layoffs in the tech industry. We actually just saw layoffs in healthcare to an extent. There's some
Yeah.
hospitals down here in Texas that actually cut 5% of their staffs. I'm hoping there's not a recession because that never benefits anybody. I mean, that just makes everything more difficult for everyone. But we'll have to see what happens. We'll have to keep our fingers crossed and hope that things
Yes.
trend upwards.
True, true. And Peruju, I think, can we expect changes? Yes, we can always expect changes because that's the only thing that's constant. And
It's
let's hope for the
change.
best,
Yeah.
Peruju. Yes. All right, let's move on now to the next question we have. Let's take up Madhu. Nishant is continuing to say, my job
Yeah. So
required
that,
to stay in the
yeah,
US.
which I understand that takes off the L option for you. So it's just not, available to you. I'm sorry. So even though you're adverse to the idea of CPT, I do think if you're moving up a degree level that you're going to be in better shape. I would try not to engage in like a second master's or something like that.
Mhm. All right, I think we'll just take a quick break now, if that's fine, folks out there. You keep commenting, we'll take up your questions. And once again, I would like to say that please follow Wasden Immigration Litigation on LinkedIn for more immigration updates. And also don't forget to subscribe to Immigration and Jobs Talk Show on YouTube, Facebook, LinkedIn, and we would be happy to take up your questions as well. So also feel free to contact Justin, and his details are on the screen. All right, so you can contact Justin and definitely check out their website as well, wasden.law. And you can note down his phone number. His phone number is 844-592-7336. And you can mail him at support@wasden.law. Thank you so much. Let's go for a short break.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hey, sorry guys, I don't have any audio, so I'm not able to hear the
Control stepping
question.
in. You have no audio.
Very good.
Control stepping in. You have no audio.
All right, I hope you can
Now
hear
you
me,
are.
folks. Can you hear me?
Now good.
Now we
Okay.
now we got you.
So, yes, I think it's not a smooth webinar.
Control
We
out.
don't have any technical difficulties, but thank you so much letting me know. I hope I'm audible. And I'm very happy to welcome all you folks back to Immigration and Jobs Talk Show. We are streaming live on YouTube, LinkedIn, and Facebook. And thank you so much for all your questions so far. And wherever you're watching us, you can keep commenting because Justin is here to take up your answers. And today we're discussing of if you didn't get selected in the H1B cap lottery, what's next? What can you do? So I think let's take up more questions from the audience. If that's fine. Let's take up Madhu. This is on YouTube. Madhu is asking, my application was shortlisted in the second lottery, but my L1B max out period is August 18, 2024. What are my options if I don't want to travel out of the country? That's like 9 days from now.
Yeah, I mean, file a change of status as quickly as possible. Just file a change of status to H1B, but the problem is your age can't take effect until 10/1. So even if you file prior to that timeline, you're going to have a dead period from when current your current L1 maxes until the start date on that H1B. You will be in POSA bag, a period of stay authorized by the Attorney General. What that basically means is you've timely filed a valid change of status petition that gives you authorization to remain legally in the United States during its adjudication, but you're not going to be able to begin working until 10/1 because that's the threshold. That's the first date that you can actually be on H1B status for the fiscal year.
Okay. All the best, Madhu, and I'm sure, I hope you are able to make it on time.
Yeah, I
All
mean,
right.
the
So,
alternative to that is you consular process, and I know you don't want to leave, but you leave the United States, you wait till the H gets approved, you file for, you schedule a visa appointment abroad, and you go attend the visa interview, get your visa stamp, and come in. You should be able to, top of my head, I think it's like 90 days before the H kicks in that you can schedule a visa appointment. Please don't quote me on that. It could be 60. But you can go to the visa appointment before the start date on the H, and then I believe you can enter the United States up to 10 days prior to the start date of that validity period. So I know you don't want to leave, but you could leave for maybe a month and then come back in right before your H kicks and start working. So I don't think it'd be that big of a deal. The alternative is you hang out here for a little bit, and then you kind of wait and see what happens.
okay. Thank you. Thank you for taking that up for Madhu, Justin.
Mm-hmm.
Now, this next question on the screen is from RK on YouTube. Are J visa options for tech workers, and are the impact on future H1B and green card?
Okay, so yeah, I don't want to get too into the weeds with this. To be honest, if you're using a J visa, or you've used, if you're on a J visa and you're looking at H1B, going into the lottery change status H1B, there are additional extra considerations that come in. There actually are even specific questions about the J visa contained within the I-129, because there are special requirements associated with that visa. But the thing about those requirements is they actually can even be tied to the country that the person comes from and or the work that the person is doing. So I would definitely say if you are using a J, you're going to need a little bit more extra work on your case than somebody who's moving from like an F, or maybe an H4, where it's going to be more straightforward. So yeah, it plays a role definitely in the process. And so I would definitely make sure that you're working with an experienced attorney on that to make sure that they're able to properly determine your eligibility prior to filing.
Okay. Thank you so much for that, Justin. And well, there you go, RK. I hope you got your answer. Okay, moving on now. This one is from Rish. Since I wasn't selected in the lottery, I'm considering enrolling in another degree program to maintain my F1 status. Are there any risks of this strategy?
So
That's it.
the problem with this for me becomes enrolling for another degree program at the same degree level after you have utilized 12 months of OPT. The reason for that is USCIS seems to have taken the holding that if you utilize those 12 months of OPT at, let's say, the master's degree level, and then you go and apply for a second master's because you've maxed out your time and you want to engage in CPT, USCIS seems to have taken the holding that you're not supposed to be allowed to do that, or that it's a violation of F1 status to do that. So I would definitely say that in that situation, where you're making that determination, always try to go up a degree level, because if you don't go up a degree level, then you're going to be in a circumstance where if you end up getting to change status, where you get to go from file a change status from F1 to H1B, you could end up with a request for evidence showing that you have failed to maintain status. And that means that you could end up in a situation where your case gets approved without an I-94. And so in that circumstance where your case gets approved without an I-94, you are forced to go abroad, meaning you're not able to remain in the United States in order to activate that H1B. It's not going to change status for you on 10-1, and it's going to require you to go to the consulate for a visa interview. Now, where things get even more problematic in that circumstance is if you're attending a visa interview and you're found to have had a violation of your F1 status, that's possibly a question that's going to come up at the consulate. If that question comes up at the consulate and you don't answer truthfully, then you could be found inadmissible, meaning that they won't give you the visa stamp. They won't allow you to come into the United States. So all of that can be a direct effect of choosing to remain at the same degree level or go up a degree level. So basically, I would definitely say that's the risk associated. I would probably stay away from the second masters. I'm sorry, I'm starting to get close to wrap up time.
Sure.
So I would definitely say when you're looking at a second master's, just make sure that you realize that there is a possible penalty if you've utilized all that OPT time already at the same degree level.
Thank you. Thank you for taking that up. And I think this will give us to this last question, all right, from Drive. Hey, Justin, love your energy. I have a question actually. My current visa status allows me to stay in the US, but not to work. What are my legal options if I want to continue working without violating my status?
It's an interesting question. I mean, I think that'd be status, based. I mean, for example, what's the underlying non-immigrant status that you're currently on? So, if you're on an H4, you have the option of acquiring an EAD in the event that your spouse has that approved I-140. But if you're on, maybe say like a B2, a visitor visa or something like that, that doesn't permit work authorization, you have to change status to another non-immigrant status that carries with it work authorization. Yeah, I mean, don't ever perform unauthorized work. That would be the best advice I can give anyone. Don't perform unauthorized work because you may think that you're getting away with it and not realize that the government is going to look at your entire record when you go to adjust status, if that's something you plan on doing in the future. And I cannot tell you, unfortunately, how many pitfalls I have seen where you're in a circumstance where, gosh forbid, you're adjusting status, you file the 485, and you get hit with, an accusation of a status violation or some sort of issue. Now, there are obviously ways you can overcome those certain issues. I'm not going to go into the nuances of that specifically, but the best thing you can do is present, a squeaky clean immigration record when you're going to file. So yeah, I mean, you have to move to another non-immigrant status. That's going to permit you work authorization. And if not, you have to continue to just live in the United States and not work. But again, it really does kind of depend on what your underlying status is.
All right. All right. So thank you so much, Justin. Is that it? Should we wrap up, or do you still have time for one more question, maybe?
I do apologize, but I'm pretty short on time. I did, if you guys wanted to, I did want to maybe see if we could touch on the updates that had gone on with USCIS just real quick, because I thought it was very interesting that they had actually, for the whole time I've been practicing, H1B ownership of a business has been something that people wonder about. It's tough when you're tied to, just one employer, and you can only work for that employer, and you're not capable, you're not able to start your own business.
Right. I had a question, so it's there on the screen. I couldn't reach up to there, but there you go.
No worries.
Go on.
So I just wanted to touch base on that because it was something I had been looking at over the past couple of days that I thought was really interesting. Before, passive investment in ownership was basically the only route that you could go. So what that means is you could have ownership in a business, but you couldn't actively work in the business. It had to be passive investment only.
Yes.
Now it looks like you can have a controlling interest and potentially qualify for an H1B with the employer that you own. They're calling this beneficiary owner, which I think is an interesting
Interesting.
phrase, something I've never heard
Very
before.
interesting.
But yeah, beneficiary
Yeah.
owner. The idea that you are the owner, basically your company sponsors you for an H1B. So
Yeah.
I thought
How
that's
cool is that?
interesting. It's in its infancy. It's new. There right now there is regulation pending on the performance of non-specialty occupation work. So because I think you're going to get into a lot of weeds here with beneficiary owner, are you performing specialty occupation work? How are you qualifying? What's the SOC code you're using? What wage are you being paid? I don't think you can be an entry level owner, or can you? I don't
Mhm.
know. So these are all like new and exciting things that I think are awesome. We love to hammer the agency when they do stuff wrong. So I do want to at least give them credit when they do something right. And I think that this is an awesome idea that's going to help innovation, and it's going to give H1B workers, particularly the people that are stuck in this backlog, it's going to
Yes.
give them opportunities to hopefully, explore their entrepreneurial abilities. Because I definitely think the best entrepreneurs in the world are typically immigrants. So giving them this
Okay.
opportunity is going to be colossal. I think it's great. We'll learn more about it, and maybe I can tell you guys updates as I learn them.
Sure, me too, me too. I'm looking for more updates, and maybe when we meet up next time, Justin will sure catch up more on this and
Yeah.
maybe have our folks more clarified with this new thing that's there now.
Hmm.
Um, yeah. Thank you so much, Justin. I won't hold you up much, but thank you so much for
No worries.
doing this. It was really lovely having you. I mean, for all your actionable advice as well, for all these folks who joined us with their questions and all these insights you had for us, these alternative visa options also, and the deep understanding we got today. So thank you so much once again on behalf of Immigration and Jobs Talk Show, and looking forward for another webinar maybe in the coming week.
Yeah, absolutely. Looking forward to speaking to you again. Thank you very much for your time.
Thank you, Justin. You too. Bye bye. Have a
Bye.
great day. Have a happy weekend. Yeah.
You too.
Thank you, friends. You too, for joining us. It was really lovely having you join us with your questions. And as we wrap up today's session, really thank you all for your active participation and for making this a vibrant discussion. So, a huge thank you once again to none other than Justin Rivera for sharing such invaluable insights with us. And remember, even if the H1B lottery didn't work out this time, there's always paths forward, friends. So don't lose hope. Always stay positive and keep working hard. And we're here to guide you in every step of the way. So anything immigration related, feel free to contact us as well. And my details are on the screen. You can call me or WhatsApp me on this number, 408-335-6444. You can even email me, nipa@higheritpeople.com. And definitely to get to know more about us, check out our website, www.higheritpeople.com. Also, you can contact me if you're looking for project placements, H4, EADs, green cards, anything related to immigration. If you have any questions, feel free to drop me a mail or a message. Thank you so much, friends, for joining us today. And in case you're watching this webinar after the stream has ended, you can keep commenting your questions because we have our experts who will be more than happy to reach out to you with answers. So thank you. This is Napasa Pradhan signing off for now from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone. Thank you so much for joining us. It is another beautiful day, and definitely we are coming towards the end of August. Very exciting. But thank you so much for joining us. This is Immigration and Jobs Talk Show, and I am Napasa Pradhan, going to be a host for an hour or so. Thank you so much for joining us. Before we start off with today's program, I wanted to read out this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, a very good morning, good afternoon, good evening, whatever time zone you've joined us from. Thank you so much. And let me tell you that this is going to be a very participative and interactive session. So, wherever you're watching, whether on Facebook, LinkedIn, Twitter, or YouTube, please drop your comments and we'll be very happy to take them up today. So, without further ado, please help me welcome today's guest and a very familiar face, a regular face. We have her every Wednesday. Thank you so much for joining us once again, Attorney Prashanthi Reddy. How are you doing today?
I'm great, Nipasa. How are you doing?
I'm also doing great. I'm excited. I mean, August is coming to an end, though, like the year is also coming to an end, but I'm excited for new beginnings, I guess. Whenever it's new, we always have some things in mind to try out new things. So, I'm looking forward for all of that.
That's great.
Yes, and well, friends, like you can see, today's topic is on the screen. Is it easier to get advanced parole in 2024? That's a question many people have. And today we're going to dive deep into this topic and also get to know about the I-131 application process. So be with us. And if you are going through phases or maybe facing difficulty around this status, please drop your comments. We'll be very happy to get to know your side of the story as well. So, Prashanthi, maybe folks out there who have joined us for the first time, would you like to tell them a little bit about yourself before we can start today's session?
Oh, yeah, okay. I'm an immigration attorney with over 25 years of experience, close to 30 actually. And I specialize in, family as well as employment-based law. My offices
Mhm.
are in New York City, and I wanted to share with you, Nipasa, that I've been voted as the best immigration attorney by Forbes
Yes,
magazine.
I
So
remember.
that
Congratulations.
was exciting. So yeah, looking forward, as you said, to well, actually, I'm enjoying the summer, so and in New York City, it gets quite cold in the winter. But still looking forward to, back to school and, going back full time to work. We've been, kind of taking it easy and things have been slow. So back to the
Yes,
fast pace again, I guess, in September. But yeah, looking forward to it and a little bit of cold weather as well. I love the fall,
me
so
too.
looking forward to the fall. So
Yes,
let's see what
yes,
the rest of the year has to offer.
absolutely. I'm excited. I mean, right now we're in between summer and fall, so we're just enjoying it. And then when winters come, we are all in the holiday mood. We won't feel like working much, I guess, but everything, well, we all have good things to look forward to, friends. I hope it's the same for you. And without further ado, then let's go head on to our topic today. So, Prashanthi, do you have to say what can folks expect from today's episode?
Well, you said that you had a lot of questions on the I-131, that a lot of viewers were asking questions on it. So we decided to do that topic today. It's advanced parole. So anybody has questions on advanced parole, what is advanced parole? We'll discuss, of course, what is advanced parole, who gets it, how to get it, what are the common mistakes made and what you should take care of if you're using your advanced parole.
Hmm.
Stuff like that. Advanced parole for DACA, a little bit about parole in place, PIP, that's a new thing. And then there's new developments on that also that we can briefly discuss. So that's what we have in our agenda today. And of course, most important, we'll be answering your questions. So please put your questions out there.
Thank you so much for saying that, Prashanthi. So, you heard it, friends. We are ready for your questions as well. Keep commenting. So, I have my first question for you, Prashanthi, and that is what is the primary purpose of advanced parole and who is eligible to apply it? apply for it in this year, 2024?
So advance parole is like a travel document. If you wish to return to the US after traveling outside, and you generally must have either a valid entry document such as a green card, or you have to have a visa, or you can have a valid and unexpired travel document. So it's a travel document used often in place of a visa. If you don't have a visa in the passport, um, you're allowed to temporarily travel and come back. It's a temporary travel permit. So you generally need to apply for and obtain a travel permit, or an advance parole, as you call it, before you leave the United States. So before traveling, please consider the processing times. If you have an urgent need to travel, you could do an expedited request, or by going to the local USCIS office and informing them what the urgency is. They might issue you an emergency advance parole. A form I-131 is used for advance parole, and advance parole is usually granted to those non-citizens in the US seeking to return after temporary travel abroad. And people who usually are given advance parole are people who have an adjustment of status filing pending. It could be employment-based or it could be family-based. It can be used, an I-131 also can be used as a refugee travel document. An I-131 can be used as a re-entry permit and also as for TPS, for people who have temporary protected status. It can be used as a travel document for them as well. But when it's used as advance parole document, like I said, if it's used in place of a visa, then that is usually used by people who have adjustment of status pending, or DACA recipients use it as well, the dreamers. And as I said, people who have TPS, temporary protected status, use it as well. For Indian nationals, I would say the most often used document, if you have a 485 pending, most of you might know advance parole that way. So that's who generally uses it, Nipasa. Hello? Um,
So my next question to you would be, can you explain the key updates to I-131 form and process for 2024? And how have these changes impacted the processing times for advanced parole applications?
well, the key changes were not so much to the form, but as of April 1, 2024, there is a new form. But there are not many changes in the form, at least nothing that matters. But the big change was that there is a fee now of $630 if you're filing an advance parole. You earlier, before April 1, 2024, if you were filing the advance parole along with your adjustment application, which is along with your 485 application, then there would be no fee. Now, as of April 1, 2024, any applications filed after that, there is a fee of $630. So it's no longer free, right? So that's the biggest change, I think, with reference to the I-131 applications. Has there been any change in processing time? I haven't really seen a change in processing time. It's really about the same, 4 to 6 months. Sometimes advanced parole cases get processed in 2 months as well. Difficult to say why, but I just give people a long range of 2 to 7 or 8 months because sometimes it takes longer as well. So I would say that if you need to travel, don't wait until the last moment. Please always keep your advance parole updated. So always make sure that you have an unexpired advance parole so that, whenever you need to travel, you can use it because you never know when you'll have an emergency.
So true. It's always good to play safe, friends. So remember that. And thank you, Prashanthi, for taking that up. My next question for you is, what are some of the common mistakes, applicants make when filing their I-131, and how can they avoid all these mistakes?
I think the common mistakes made is, of course, mistakes that people made with every type of form: incomplete or incorrect information, failing to fill out sections accurately, omitting, omitting the sections completely, not filling it out at all, not providing proper supporting documents. For an advance parole, you need to provide proof of ID, you need to provide proof of your status. If you're a DACA recipient or TPS, you need to show why you need to travel and that it's an emergency. For adjustment of status, you don't really need to show any emergency. You just have to, give them a reason for travel, but you don't really have to provide any supporting documents for that. Of course, you need to provide a copy of your passport. And last but not the least, you have to provide the correct fee and send it to the right address. The fee, as I just said, is now 630. So a lot of people after April 1 were sending out the package, the 485 package, without a fee for the advance parole, and those cases came back and had to be resent again. So
Yes.
that could be one reason. Also, not notifying USCIS of changes in address or circumstances that might have changed with reference to your application. Also, the form keeps changing, so you have to make sure you use the current form and not
The
use
latest.
an old form. Yeah, so that could be a reason for your case coming back as well.
Mhm.
Excuse me. How to avoid mistakes? Double check your application. Make sure you're sending out the right USCIS fee. Go to the website and check what the fee currently is, because that keeps changing as well. Make sure you have all your documentation in place. Keep your records updated. Don't send like an old driver's license, an expired passport, etc. So these are some of the ways that you can avoid, your application coming back and avoid mistakes in your application.
Thank you so much. And it's always good to stay updated, friends. Look out for, do proper research before you fill out your forms and see that you really can avoid these mistakes, because they could fall heavy later, while on the process of recorrecting them. I mean, correcting the mistakes. All right. So my next question to you would be, Prashanthi, for DACA and TPS holders, what specific factors should they consider when applying for advanced parole this year? And are there any special requirements or challenges?
So yes, that's a good question, because for DACA and TPS, rules keep changing. Presently for DACA, so the dreamers, uh, everyone, whoever is a DACA recipient or wants to be, so this is basically for children who came here. I mean, people who came here as children, went to high school here and were out of status for no fault of their own. Uh, for those people, they've been given deferred action. They are also called dreamers. So those young people are given deferred action, meaning that no action is taken against them even though they're out of status. And they are
Mhm.
given advance parole and they are given employment authorization. So it's a temporary status. It doesn't really allow you to, it stops you from being removed from the country and gives you some temporary relief. So you also have advance parole when you have DACA. But for those of you who don't know, the DACA applications have now been stopped because of a court ruling. The court has said that if you have already received approval for DACA, then you may continue using advance parole and you may continue using your EAD, but new applications are being accepted, but they're not being processed by USCIS. So please be careful. Don't travel unless your advance parole is actually approved. I would say the same thing for TPS as well. TPS rules keep changing. The countries that are allowed to get temporary protected status keeps changing. During Trump's administration, they had stopped TPS completely. So something to keep in mind, always make sure you know what the rules are before you travel on advance parole. And also, most importantly, for DACA and TPS, you can't just travel because you're going on vacation. You have to have a reason to travel, and only then will the advance parole be granted, otherwise it will be denied.
Oh,
The advance parole may only be granted for humanitarian purposes, meaning if there's some emergency, if you are going back to complete your education, or if you are working for a US company and you have to go back for employment reasons. So there are some specific reasons that you can apply for advance parole for DACA and TPS. So make sure you know what those reasons are and make sure that you provide supporting documents to show that you qualify when your AP application.
all right. Thank you so much, Prashanthi, for taking that up as well. And at this moment, I'll just take this moment to say hi to all our viewers who've commented and are watching us right now. So, hi to Akbar, Chandrakala, Shaukat, Chivangani, Reena. Thank you for your questions. Please stay with us. Oh, Chandralekha has many questions. I think we should take this one if you don't mind. And also Isha. Hi, Isha. Thank you for joining us. First question Chandrakala has is will USCIS conduct the third round lottery for H1B?
Good question. And I don't think so, really, because there were very few numbers that were opened up even for the second lottery. So I doubt that there'll be any numbers remaining for a third lottery. That's at least my guess, but no one knows until they actually announce that all the numbers have been used up.
Right. So we still don't know, but let's not let our hopes down. Who knows? We may. More questions from Chandrakala. Advanced parole can be used. Is that a question? Let's see the follow-up also. Can be used by day one CPT students. So can advanced parole be used by day one CPT students?
No, advance parole is only for specific people. If you have an adjustment of status pending, if you're in refugee status, if you're DACA or TPS, advance parole is for them. Indian nationals often will use advance parole because they have a 485 family-based or employment-based case pending. And it's really nifty because you don't need to go outside the country and get a visa. You can get advance parole while you're in the US. In fact, you have to get advance parole while you're in the US.
Okay. Thank you, Chandrakala. I hope that answers your question. And if you have more questions, we're here for some more time. You can keep asking. And thank you, Prashanthi. Well, we'll get back to all your questions, folks. You keep commenting. But for now, I have some more questions for Prashanthi. So I'll quickly ask, what risk should applicants be aware of when using advanced parole, for international travel especially? And how can they mitigate these risks, especially in the current political climate?
So USCIS also advises caution when using advanced parole. Simply because advanced parole is approved doesn't mean that you'll be allowed into the country, or even if you're allowed into the country, it doesn't mean that you will not have any negative consequences to your travel abroad. So you have to speak to an immigration attorney or do your research and make sure that you are okay to leave the country and that does not affect your status in any way. So travel outside the country may have severe consequences to your immigration related cases. It's not guaranteed, even if you have the appropriate documents, that you will be allowed back into the country. Even with AP, you are subject to, the usual scrutiny at the port of entry to determine whether they should allow you in to the country back or not. And that's the case with every kind of everything, right? Even if you have a visa, you may not be allowed back into the country. So, especially if you are a non-immigrant, for example, and if you travel outside the country and you have a change of status pending, even though you can come back into the country, your change of status application will get denied if you leave. So you'll be allowed back on advance parole, but your change of status application will get delayed. Then you'll have to again, you'll be in the status which you were previously in, and you'll have to file an application again. If you're if you have a pending, yeah, it's quite risky. If you have a pending adjustment of status application, if you're applying for, you may not be allowed to re-enter in the United States when you return. Even if you're allowed to re-enter, you may be found to have abandoned your pending application for adjustment of status. So just be careful when you're traveling. Everybody has different circumstances. On that note, if you have a family-based immigration status, meaning you filed an I-130 and 485 based on your spouse or parent, or child for that matter, you actually cannot leave the country until your advance parole is approved. So be careful filing an advance parole and leaving, then it will be abandonment of your advance parole application. They will not process the application, so you'll have to figure out another way to come back into the country. Once your application is approved, only then you should travel, especially if you have a family-based case. Only travel on your with your advance parole. If you have an employment-based case, it's possible that you can travel with advance parole, or you can travel on your visa as well. And you're allowed to come back on your non-immigrant visa and then continue to process your adjustment application. It's a little tricky, but for family-based cases, definitely if you travel, then it'll be considered that your 485 is abandoned. Employment-based cases, not so. You can travel back on your H1B visa, for example. If you have unlawful presence, if you have accrued unlawful presence, or you have a removal order against you, if you leave the country, you will not be allowed to come back, even if you have advance parole approved. So people think that if you have advance parole approved, that means 100% you'll be allowed back. When they're approving your advance parole, they are not looking at your status. They're not looking at other issues that you might have. They're only looking at the advance parole application. So don't think that that mitigates the other problems that you have. So if you've been unlawfully present in the US for more than 6 months, if you leave, you will not be able to come back under the unlawful presence law for a period of 10 years, maybe, right? Or 1 year to 10 years, depending on, or 5 years, depending on how long you've been unlawfully present in the US. If you have a removal order against you, of course, then again, it triggers again the 10-year bar as well. So you will not be allowed back into the country. So please be careful when traveling in advance parole. Do not travel while advance parole is still pending. Even on an approved advance parole, please be careful when you're traveling, because there might be other underlying circumstances based on which you will be not allowed to enter, or even if you're allowed to enter, you will there will be some consequences to your pending applications or your pending status or your status on the whole.
Right. So it's pretty risky, and I think it's best to stay in the United States.
I think
And
it's best, Nipasa, to speak to an attorney before you travel on advance parole. I think that would be my piece of
that is
advice.
true. Yes, very well said. So it's always best to consult your attorney, and if you don't have one, consult one for sure. And talking about the political climate as well around the world, there are many, I mean, disturbances in many countries. So that also impacts this, right? Do you have to say anything about
Yes.
that?
Yes, political climate in the US is also important. So, as I was saying
Yes.
earlier, under Trump's administration, they completely stopped DACA and TPS as well. So, if you travel thinking, tomorrow, if you have elections and the government changes and they make some changes to the policies with reference to TPS or even advance parole, and if you have an old advance parole already approved, which is unexpired, and you think it's fine, you can travel, think again, because you may not be able to come back. So you have to always keep in mind what the laws are at present, what the political climate is at present, how much scrutiny there is at CBP when you're at the port of entries, when you're planning to come back. Make yourself aware of all those situations, and then travel after that.
All right. Thank you so much. That's a good advice. So friends, take it. And it's an expert saying that. So definitely listen to Attorney Prashanthi Reddy. All right. So I'll also say hi again to friends who have joined us. Mahinder, thank you for joining us. Radhika, please stay with us. I will take up your questions for sure. Also, RK, hi to you. Thank you for your question. And now I have another question. Prashanthi, in the event that an advance parole application is denied or revoked while the applicant is abroad, what steps should they take and how can they handle re-entry into the US? Like you said earlier, they may not be allowed to re-enter. So what can they do if there's such a case like that?
So the first advice is USCIS has changed its policy with reference to advance parole. We were discussing about how policy changes and how we need to keep abreast of what the policies are. Even on the USCIS website, it says that if you have an advance parole application pending, and if you leave, that advance parole application will be treated as abandoned. Previously, it was not so. As long as you completed your fingerprints and biometrics, you could apply for advance parole and then leave the country. And then the advance parole would still be processed. But that's not the case anymore. So if you leave while it's pending, it will get denied. It's not a matter of if, I think, unless they don't notice that you traveled. So in order to re-enter, then you would have to depend on the non-immigrant visa that you might have stamped in your passport. If you don't have one, then you might want to apply for a non-immigrant visa before you come in. And that's the only way to come in. You have to have a visa. Or if you have a green card pending, you might want to apply for a green card outside the country because you may not be allowed then. And your adjustment of status application will then be denied because you are or treated as abandoned because you are not residing in the US anymore. They will not keep processing your 485. So you'd have an active and approved I-130 or I-140 maybe. So you might be able to apply then for consular processing for a green card through the National Visa Center. And that would be maybe your best bet, or applying for a non-immigrant visa, like such as a H1 could be another option. Applying for a B2 may not be a good option, especially if you have a 485 pending. But if you've applied based on some other status and you are not based on the pending green card, then you might be able to apply for a visitor's visa as well.
There you go. Thank you so much, Prashanthi, for taking that up. I'm sure that was very beneficial. Thank you, folks. And also, I think I should take up RK's question at this moment. So let's do that. On YouTube, RK is asking, DOS announced that they have DOS announced that they have EB1 green card today. And last week, a similar announcement for EB2 3x5. Is the a bittersweet in that no wastage, but the backlog is that big given
I think you should paraphrase
the
it.
current date.
You should
Yes,
paraphrase it.
I'm
It is
thinking
this
how.
simple.
I'm thinking how. So,
Basically, what the question he's asking is DOS announced that they have issued all the green cards for EB1 through EB5, so basically everything.
right.
And he's saying it's bittersweet because it's good while there's no
No
wastage of
wastage.
the green cards, but there continues to be backlog for Indian nationals and some other nationalities. So that's what he's saying. But what is the question? No wastage backlog is that given the so I guess he's talking about the
I think
backlog.
he's asking about the backlog. Why is
Yeah,
there no
well, we
changes in the
continue to have
backlog?
a backlog. We know that because the demand is much more than the supply for Indian nationals RK. So we have only 7% of the 140,000 employment-based numbers, and 7% is nothing compared to the population that we have and the number of I-140s that are currently pending and 485s that are pending. So because of that, we have a backlog of several years. They're working in 2012, basically. So 12 years backlog, 10 plus years for
That's a lot.
EB2, EB3, EB4. But it's good news, as you mentioned, that they have said that they used up all the green card numbers. Of course, we don't know whether they have or not. It could be they haven't, because there's not much transparency. We have to take their word for it. But hopefully they have. They've used up all the numbers, and which is good, because in the previous years they've not been able to process cases fast enough, and a lot of numbers went got wasted. And there is a request, or one of the advice to USCIS is to increase the numbers by making use of the unused numbers over the previous years, rather than just letting them go to waste. So thank you for your comment, and hopefully something will happen in the following year if there is the Democratic Party comes in and they have the ability to make laws. If they have majority in the House and in the Senate, then there might be some change. So we have to wait and see if there is. I hope there is.
Yes, me too. Well, RK, I definitely hope we answered your question, though we just assumed that was your question, but I still hope. And if you have your more questions, I mean, keep commenting. But also, I mean, we have the new fiscal year coming up, October, and then also the election in November. So hopefully there will be a lot more changes, especially regarding the backlog. But yes, it's time for a short break now. And before I go for the break, if you have further questions for Prashanthi, Attorney Prashanthi Reddy, or if you want to contact her for your personal cases, why not give her a call? Give her a call on this number, 212-354-1010. You can even email her about your status or about your case. Prashanthi, please note down the spelling, Prashanthi at reddyesq.com, and definitely go visit the website reddyesq.com to get to know more about Prashanthi and the law offices of Prashanthi Reddy. Thank you so much, and don't go anywhere because we'll just go for a short break now, but we'll be right back on Immigration and Jobs Talk Show.
IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and this is the second half of the webinar we're having right now with none other than our guest for today, Attorney Prashanthi Reddy. Yes, today we are discussing about, is it easier to get advanced parole in 2024? And definitely diving deep into the I-131 application process. I'm loving answering the questions from the audience, and I hope that they have a lot more questions. I already see so many more, but Prashanthi, I hope you're having a good time as well.
I am, and so let's try and answer as many questions as possible from the audience.
All right, so I think we should take up questions from our audience now. Let's take this first one from Radhika. I am a Venezuelan citizen currently in the United States on a valid F1 student visa, and I've filed an application for a green card through my US citizen spouse. I need to travel to Venezuela for a family emergency, but my advanced parole application has been pending for over 6 months. What are my options to expedite the process or ensure that I can re-enter the United States without jeopardizing my immigration status?
Good question, Radhika, and you are right to be concerned, because you should not travel if you have adjustment of status family-based application pending without an advance parole approval. If you have an emergency, what you need to do is get an appointment via InfoPass at your local USCIS office and apply for an emergency advance parole. Take the receipt of the advance parole to show that proof that you've paid the fees. They might ask you to pay the fees again. You have to take proof that there is an emergency and inform them. Usually emergency is in the form of a medical emergency, life and death kind of situation, because they look at this very seriously. They don't give emergency advance paroles to everyone unless it's a true emergency. So if it is something of that nature where you have to go because someone is in bad health, then that's definitely a good reason to go get a doctor's letter or a letter from the hospital, something like that, to show proof that there is a true emergency, and you should be able to get an emergency advance parole which will allow you to travel. That will only be for maybe 30 days. They'll give it for a short period of time. They won't give it for a year. But that should be hopefully sufficient for you to travel and come back before the AP expires.
Thank you so much, Prashanthi. And Radhika, I hope that was very helpful. All the best. Before we move on with all the other questions from the audience, Prashanthi, I had this one question because that's what many people were asking in our WhatsApp, and they were mailing me as well. So if you could just update us, what's happening with parole in place or PIP?
Right, that's a parole in place, and that's a good kind of segue because from that question, it's related to it. So for people who are US citizens, spouses, but cannot file for their I-130 and 485 because maybe they entered without inspection, they are forced to leave the country and stay and be separated from their family, from their children, spouses, etc. So the present administration has issued a PIP rule, parole in place rule, where they can receive advance parole while they're still in the US and not be removed from the country. And they can also travel, they can work, etc., while they are in this kind of PIP status. It was issued through an executive order, however, there was a challenge to it in court, and the court has decided, I think in Texas, judge decided that the government was exceeding its power by issuing their power on advance parole by issuing an executive order on this. It should be actually a law, and they're not allowed to give parole in place. So now they just opened it and then it closed. So we don't have any parole in place as of now because the judge has decided, unless there's an appeal, etc., we have to wait and see what happens.
That's a big update because I think folks out there were still thinking this existed and we had many questions. So this is kind of a big news, folks. I hope you note it down. All right, I think now we should take up Jessie G's question. We have on YouTube. I submitted my parole in place on Monday, the 26th. I checked my case status and it says case was received, receipt, notice not sent. What does this mean? Thank you.
As I said, parole PIP is most probably won't be issued because of the judge's order. USCIS cannot proceed with their PIP program. So I'm presuming either your case will be on hold or they will send it back saying that it cannot be issued. I think most probably they'll just keep it until there's a final decision on PIP.
All right. So, Jesse, let's hope for the best. Let's keep our fingers crossed. But that's the update. It kind of doesn't exist, I mean, as a law. So we just have to wait. All right. Let's move on now. Let's take up questions from our folks out there. RK has another question. Why don't they issue a combo card to everyone? Why a selected few?
I have no idea.
This
The
is
workings of USCIS are often mysterious, and no one can say why. They should issue a combo card in every instance when you apply for both both EAD and advanced parole. Of course, in instances where you're only applied for one and the not the other, or you don't apply at the same time, it makes sense for them to issue separate documents. But otherwise, if you apply on time, they should, issue for both. I don't know why they're not doing that.
Yes, we all have good ideas, but I do hope that USCIS also gets those ideas and they implement it very soon. RK, well, that's a good idea. Moving on now, let's go on to this next question. Ishwar on YouTube is asking, hello, I'm waiting on my AOS to get approved. I have I-765 and I-130 and I-131 approved. My wife is a green card holder. We would love to go to a 3-day cruise to Bahamas.
So your question is,
Do you think it would be possible to travel or immigration will make problems?
you should not travel unless your advance parole is approved. They will not make problems. They will just deny your I-130, and not your I-130. They will deny your 485 application, and then you'll have to come back and refile for the 485. I know you're saying that. Are you saying Bahamas? I think, yeah. I suggest you don't, because it's not part of the U.S. So anything that's, any place that's not part of the United States, outside of the United States, you shouldn't travel. Even if it's a cruise, right? So wait for advance parole to come and then plan your, I would say, plan your cruise.
Ishwar,
And
for
if you're
now, you
lucky,
might as well choose.
and if you're lucky, maybe you'll get your green card, and then you can travel directly on your green card.
Yeah, absolutely. All the best, Ishwar. But like I was saying, I mean, your 3-day vacation can be somewhere in the United States, if not the Bahamas for now. All right. So moving on, we have this next question. Let's take up Reena. If I-765 is approved, does it also mean I-131 is approved and we would get a combo card? Or is it that the I-131 will have to be approved separately and it will be a separate card?
Uh, no, I-765 approval does not mean that I-131 is approved.
Okay.
It will, if you're getting a combo card which clearly states that it covers both, then obviously both are approved. But if you're getting one saying an I-765, doesn't mean that that's the I-131. That's a separate application. So you have to wait for, to get an approval on the I-131 as well.
All right. And there's another question from Reena. I heard if I left the States before I-131 is approved, all my applications that I filed will be abandoned.
Yes, that's what I've been saying when we've been talking. That's what we've been discussing, Nipasa and I, that if you
Yes.
leave, your I-131 will get approved. If you are a family-based adjustment status, adjustment of status applicant, then your family-based 485 will also will be considered to be abandoned.
I think many people are facing this issue. Everybody's concerned with their travel plans, and can you
Yeah,
just
because it's a
maybe give
summer.
us an yes?
Everyone is traveling, there's vacation, so that's why.
Can you just maybe give us an idea of how long can you not leave, or it's just all about approval?
Well, we don't, the approval processing time is could be 2 to 6 months. So we just have to wait until, your case is approved.
Okay.
Uh,
Okay. Okay. Thank you, Prashanthi. Thank you. Let's take up Isha's questions. There are two questions. Number one is, what are the possible reasons for the significant disparity in USCIS processing times? And is there a way to appeal or expedite my delayed case? And the second question is, can I request an explanation or review of my case from USCIS? And what are my options if I believe my application was unfairly delayed or mishandled?
so
Let's go with the
it's
first
you.
one.
Um, Yeah, there could be many reasons for delay. It could be that they are investigating something further. It could be that it fell through a black hole. It could be that there is some security clearance that is required, and that is taking time because they have to get it from FBI. They do a name check. Maybe that's stuck. There could be various reasons why your case is delayed, and so you have to wait and see what it is. Hopefully, it's not that USCIS has lost your file, but and it's so there is no doubt about the fact that there is disparity in processing times, especially for adjustment of status cases. Some cases I see get approved very quickly, and some are taking longer. I think it depends on where the case is sent and who's working on it and what the kind of workforce there is at that particular service center. So these reasons might cause some delay. And if there is an unusual amount of delay, like for example, you have an AOS case and the priority date is current and it has been 2 years since you filed it and still there is no update, then you can file a mandamus case in federal court asking USCIS, forcing USCIS to respond and give a decision on your case. So there are some options available, and you should talk to an attorney to find out, how whether you qualify for a mandamus case or not.
Absolutely. And Isha, you can always contact Attorney Prashanthi. Her details are scrolling down the screen. And the next question from Isha. Do you have anything to say about it, Prashanthi?
Yeah, so she was asking if I can request an explanation or review. What are my options? So as I said, you can file mandamus. You can also complain to the ombudsman's office, and they might follow up with USCIS. You can open a service request with USCIS, asking them to update you on your case. You can also approach your local congressman and ask them to send out a status request to USCIS, and they will do that as well, as they have a different line connection to USCIS, so they can do that easily as well.
Okay. Thank you, Prashanthi, for taking that up for Isha and for the detailed explanation. I'm sure Isha has no more questions regarding that. Moving on, let's take Mahinder's question. I am the petitioner for my wife. I was wondering if these two forms, I-765 and I-131, are mandatory or required on adjustment of status. She's not going to be working soon because she needs to learn English, and we don't see a useful purpose for I-765. However, we may travel within 5 to 6 months after we start our process, so I-131 would be useful. Does it affect if I don't submit I-765? Are these optional?
Absolutely, it is optional. If you have no need for to work, you have no need for an EAD, then you should not apply for it, because now it costs money. The earlier 765 also was free along with the I-131 if you filed it with the adjustment of status. But otherwise, if you don't need to now, it's depending on what kind of case that you file, it's from $200 to $600. So you should not file it if you don't need to. You can always file it when you have a need, and there is no issue with not filing it.
Great. Mahinder, I'm sure that clarifies your doubt. Thank you for your question, and thank you, Prashanthi, for taking it up. Let's go on to Devanshi. I am an Indian national with a pending I-485 application, and I've applied for advance parole to visit my ailing mother in India. However, my H1B visa stamp has expired, and I'm concerned that if I leave the United States, I won't be able to re enter on my H1B status. Can I re enter on advance parole? And what documents or evidence should I carry to ensure smooth re entry and avoid any immigration issues?
What did she say about her H1B status?
that the stamp has
Stamp has
expired.
expired, right? So you can leave the country, and you have two options. First thing is, if you've applied for advance parole and if you filed your 485 based on employment based, and you do not wish to use advance parole because it will get denied if you leave, you can leave and apply for a H1 visa at the consulate. Of course, you're taking your chances at the consulate. We don't know whether it'll get approved or not, but that is a possibility. And you can, if it gets approved, you can come back on your H1 visa, even though you have AOS pending. But if you're a family-based AOS, then you cannot leave and should not leave unless your advance parole is actually approved. So if you have a family emergency, which looks like you do, as I said earlier, you can apply for emergency advance parole by taking going to the USCIS website, taking an appointment for InfoPass, and then applying for an in-person emergency advance parole by submitting the proper documentation showing the emergency.
Okay. Okay, thank you so much, Prashanthi, for taking that up. And Devanshi, I hope you got your answer to your questions. All the best. Now, Prashanthi, I have another question for you. And that is, if someone had a prior order of deportation that was reopened and dismissed, should they still answer yes to the question? Have you ever been in removal proceedings? I mean, if so, how can they best clarify the circumstances surrounding the dismissal?
So have you ever been in proceedings? It doesn't ask if you've been actually removed or deported. It's asking whether you've ever been in proceedings. So you have to answer yes and then explain, because there is a place to explain. You can there's addendums that can be added to the form, and you can just write the question number and the page and explain in detail as to what happened with the proceedings and why it was closed.
Okay. Okay. All right. Thank you so much for that. And I think we have more questions from the audience, but I have one more question, Prashanthi. And this one is like I received in my WhatsApp. It says, my wife has been in the United States since 2016, arriving at age 14 with her mother. Could this affect her eligibility for any immigration relief, such as asylum? Is there a possibility of consideration given her young age at the time of entry?
Oh, well, this person is then a DACA, ideal for DACA, but unfortunately they're not processing any new DACA cases. So my at this point, unless she entered legally and you're a US citizen and can sponsor her, asylum may not be a possibility because she entered so many years ago. They're going to ask why she didn't apply for asylum within a year of arrival, because that is a requirement for asylum. So I can't think of anything right now to help her unless she has an immediate relative who can sponsor her.
Okay. Okay. It's a very tough situation, but I hope they figure out. All the best. And thank you for your question. Thank you, Prashanthi, for taking this up. There's another question I have. This is I think I received on my mail. As a United States citizen married to my husband since 2008, he has no criminal record or deportations, but he faced multiple stops by immigration officers inside Mexico before successfully entering the United States on his fourth attempt. Does he still qualify for immigration relief considering there were no deportations?
Well, if he's married to a US citizen and if he entered into the country legally after being inspected, then he's allowed to file for a green card based on the fact that he's married to a US citizen. I don't know why he was stopped, what the issues were, but that might come up when you're filing for adjustment of status. So need to consult an immigration attorney to figure out what caused the multiple stops. But you're saying there's no criminal record, and hopefully there's no immigration fraud or immigration record against him. So
Mhm.
if there isn't, then there shouldn't be an issue.
Okay. It's always best to consult an expert immigration attorney. So, all the best. And all right. So, we have another question on YouTube. This is from Madhu. My dad filed for my brother, but my dad is now deceased. I understand that there is the option of humanitarian reinstatement. I can stand in as substitute sponsor, but I don't know how to go about it. Do I contact USCIS to let them know that my dad is deceased, or just wait until they send out correspondent for interview date, etc.?
You should contact USCIS and you should send in. There is a process in place for if the sponsor is deceased, and you have to send the death certificate and you have to send a letter stating what the facts are to USCIS wherever your adjustment status application is pending, and the new affidavit of support as well. So don't wait for USCIS to contact you. I suggest that you, um, inform USCIS proactively that what has happened and submit documentation um, to, fall within the exception of getting a green card even after the death of the sponsor.
Mhm. Okay. Thank you. Thank you for your question, Madhu. And thank you, Prashanthi, for taking it up. Let's take up this last question we just received just now. This is Zaheen. Thank you for joining us, by the way, and for your question as well. How long it may take for the approval of I-130 F4 sibling petition from Philippines? It's been almost 12 years and just saw also from USCIS website that my application was moved to Ellis, ELIS.
It can take a long time because sibling applications are the most backlogged um, applications in the family-based category, and so you've seen yourself now that it's been uh,
12
the
years.
priority date is over 12 years. And so we wait and see in October what happens. That's when the new visa bulletin for the new fiscal year, when new numbers become available for the next year. Wait and see what your priority date is then you'll have a better idea as to how long it'll take. But it'll take a long
Absolutely.
time.
Thank you. Thank you for that, Prashanthi. And thank you, Zaheen, for your question as well. So I think we are all excited. I know we still have one more month to go for the new fiscal year to come up, but we are all excited for changes. So, yes. And Prashanthi, thank you so much for covering this topic today. And maybe to summarize what we discussed about advanced parole, if you have any end note for all the folks out there who watched us, would be great.
Well, advanced parole is a great tool that you can use, great application if you have to leave the country for a short period of time. But keep in mind the other considerations as well when you're traveling on advanced parole. It might cause problems to your immigration status or to your immigration application that is presently pending. So always consult an attorney before you travel on advance parole. If there are no issues, then there's no problem traveling. I'm just saying that you never know, so always make sure that you're aware of who can travel and who cannot. Even if the advance parole is granted, doesn't mean that you won't have any immigration consequences traveling on advance parole.
It's always good to be very, very careful. So consult an attorney before you make any move or before you at least book your tickets. And all the best. Thank you so much, Prashanthi, for doing this today. I had a great time learning from this very informative session as well. And I hope so did the folks. Thank you so much for joining us today as well, Prashanthi.
Thanks for having me, Nipasa. And as usual, we had so many nice questions on topic. Very happy, and hopefully, we gave out a lot of useful information to those people who didn't ask questions also.
Yes, absolutely. We did. Thank you. And you have a great day, Prashanthi. I'm hoping to see you again next week. And until then,
See you next week.
you take care. Yeah, it'll be September by next week. So let's say a goodbye to August nicely in the next few days. Bye bye. Thank you,
Bye.
folks, for joining us today. And it was lovely having all your questions. Thank you so much for being so participative, so sportive, and really nice questions, as Prashanthi has also said. So thank you. You can always contact Attorney Prashanthi Reddy. Her details are on the screen. Her number is 212-354-1010. And her email address is prashanthi@reddyesq.com. Please note down the spelling from the screen. And also, you can visit our website, reddyesq.com, to get to know more about Prashanthi Reddy and the law offices of Prashanthi Reddy. Also, friends, you can also contact us. You can call me on my number. My number is 408-335-6444. This is also my number for my WhatsApp. So you can message me there if you have any questions regarding immigration, because we have our experts who'll be more than happy to answer. So feel free to contact me, and you can also email me. My email address is nipa@higheritpeople.com. And to get to know more about us, visit our website, www.higheritpeople.com. Thank you so much for joining us. You all out there have a wonderful day ahead. And don't forget to subscribe to our channel, Immigration and Jobs Talk Show, for more updates and exciting discussions like these. Thank you for joining.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com. Good morning, good afternoon, good evening, everyone. Thank you so much for joining me wherever you're joining me from, whichever time zone. And welcome to Immigration and Jobs Talk Show. I'm Napasa Pradhan. I'll be your host for you today for an hour from now. And I have a very important disclaimer before we move on with today's topic of discussion and our whole webinar. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, welcome back to Immigration and Jobs Talk Show. And today we are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. Very happy to have you all join us. And remember that this is also going to be a very participative webinar. So whatever thoughts you have or comments you have, questions maybe, you are free to definitely ask your questions in the comments. We'll be very happy to answer them, because we'll also have our expert, our guest for today, who's going to join us, and definitely he's going to make this session a very interesting one. So stay with us, all right? None other than attorney Chand Parvathaneni, managing attorney at the law firm of Sim Parvathaneni and Brown, based in Dallas, Texas, with extensive expertise in immigration law. Attorney Chand Parvathaneni is here to share his expertise on a crucial topic for many international students and professionals. And so you can see today's topic is here on screen. But without further ado, please help me welcome back Chand. How are you doing, Chand? Thank you so much for joining us today as well. And we're very happy to have you back.
Hello, Nipasa. Thank you for inviting me. And yeah, hopefully we'll have a very productive discussion today. And then we'll take up audience questions and then see what are the new changes in H1Bs and compliance issues and everything surrounding immigration.
For sure, for sure. We are definitely going to do that. But before we move into the topic, friends, we also have what is happening recently. Chand, we were talking just before we started this discussion. So, in light of the recent news involving the arrest of Indian students in a major prostitution racket in Denton, Texas, what are the potential immigration consequences for those individuals who are facing charges such as solicitation of prostitution and even and evading arrest? Could you provide insight into how such legal issues might impact their visa status or future immigration prospects as well? Because since we are always
Yeah.
talking about immigration, could you please shed some light into this very recent case as well, and also maybe give out some tips to immigrants out there how to be careful?
Sure. And I think so. A lot of students, they are coming here to study, and one of the requirements is they go to school and they follow the law 100%. I mean, there is no lenience, there is no leeway, and majority of the people do it. But unfortunately, once in a while, we do see the students. They get involved. They have brushes with the law, and they get in trouble. And so lately, I mean, in the last 1 year, 2 years, I have seen an uptick in RFEs. Somebody applies for their OPT, STEM OPT, or they apply from F1 to H1. And then we see an RFE saying, you have been arrested in the past because of this so and so reasons. So the bottom line is any kind of an arrest could cause a major impact to your immigration process, even if it's a small arrest. And so, from that viewpoint, I think what has happened in the last 2 days in the news that has come out is there were a bunch of people arrested in Texas, in Denton County, and this is for solicitation of people for sexual work. So it is not. I mean, these students, they were not really doing any human trafficking. They were not involved in any sex racket. They were not really like
Okay.
doing all those things. All they did is solicit a prostitute. So basically, what they did is they solicited somebody and thought they can get some sexual work out of them. Even solicitation is a crime. It doesn't have to be uh, human trafficking. It does not have to be sex racketing, all those kinds of stuff. In Texas, what has happened is until 2021,
Mhm.
if somebody goes and tries to meet up with a prostitute, just a solicitation, it used to be a misdemeanor B. So it was not really a felony. It used to be a misdemeanor. And what that meant is solicitation, which is not the actual prostitution, but just going and asking somebody for some sexual favors for money. Money is involved. It was not that big of a crime. But starting 2021, there was a new law passed in Texas, and this is specific to Texas. So even
Okay.
something simple like solicitation is considered a huge crime. It's actually a felony now. And when we talk about felonies, felonies have a huge immigration impact. If somebody has a felony on the record, they
Mhm.
probably will not be able to get through anything with immigration. They will not get probably get green cards. They might not get visas. Misdemeanors, one-time misdemeanor, if it's a small crime, depending on the crime, maybe. But if it's a felony, it's always a given that they probably will never have an approval from USCIS. They probably will not get visas, and so on. And what that means for all of us, normally, why do people get arrested? If somebody gets drunk and drives, the police catches them, it's an immediate arrest. So DUI is a
Yes.
very serious offense. They get arrested. If somebody goes to Walmart and steals something, maybe even something as cheap as $5, it's an immediate arrest. And we had
Mhm.
this happen. And I personally dealt with a lot of cases in Denton County where people got arrested stealing in Walmart. people got arrested for DUI. And just like
Okay.
a month back, I had a case where the wife called the cops and said the husband physically abused her. And and she just called the cops, and she was actually stating that she was not physically abused, but she was in a fear that her husband might abuse her. Even for
Okay.
that, the husband got arrested. So anytime you have an arrest, and then I also had a case in Denton County where this boyfriend girlfriend, they ran into an argument, and somebody saw this argument. They called the cops. The cops came and arrested this person because according to the eyewitness, there was some altercation and probably even some physical abuse happening. So
Mhm.
we are seeing more and more cases where people are getting arrested, and any arrest will flag up. I mean, so all these cases that I've been talking about where somebody got arrested, we immediately in a month we saw Department of State contact these people and say your visa got cancelled. So even a small arrest for something like a DUI, something like a husband and a wife fight where it rose to the level of physical abuse, which is like a big no-no. You can't abuse your spouse. So anytime there is an arrest, your visa more than likely will get cancelled. And not only that, depending on the nature of the crime, you might not even be eligible for getting a future visa. So the bottom line is any arrest is bad. And out of all these arrests, if something is a misdemeanor, maybe you will have a chance to argue. But if it is a felony, for sure, your immigration is going to be jeopardized. And the message for all is be cautious. Do not get involved with anything that is illegal. And again, if you have any arrest, 99% of the time, you will see that raised in an RFE in your future filings. Okay. So just
Okay.
be aware. And a lot of people got arrested, and it was a whole bunch of people. I was actually surprised because we do know that in Dallas County, in Denton County, in Texas, these kind of
Mhm.
raids are happening all the time. So I do see people get arrested, but I've never seen so many. I mean, out of the people that the information that they released, I mean,
Mhm.
almost majority were Indians and Indian students. So it was kind of surprising. And what that means is this is a lesson for everybody who's complying with the laws. It's a message that you have to be more cautious. Don't think anything is a simple crime. Crime is a crime. It'll impact your immigration process. So always follow the law.
Yes. Very, very well put. Thank you so much, Chand. And definitely, friends, I hope you noted that down. And also, Chand, if you could maybe just give us the real difference between a felony and a misdemeanor, so that folks out there could also be more clear about it.
Sure. And so the way the criminal law works in the United States is it's a state law. So the criminal law that we have in Texas, it is probably different from what they have in New Jersey. Every crime
Yes.
will have like a penalty, whether it's a jail time or whether it is a monetary penalty and so on. And
Mhm.
every state has different laws. For example, in Texas, solicitation of prostitution is a felony. And what that means is you can be put in jail for as long as 2 years. You can be penalized $10,000. That is pretty much what is the current statute in Texas. For the same
Mhm.
crime in New Jersey, for example, the penalties are different. For example, consuming marijuana, weed in California is completely legal. You cannot be arrested for that. Whereas in
Yes.
Texas, it is illegal. So the state law is pretty important. And from an immigration standpoint, people definitely have to understand what is a misdemeanor and what's a felony. A felony, so normally in Texas, the lowest crime is a misdemeanor C. Then it is misdemeanor B. Then it is misdemeanor A. Then it becomes felony. And the highest class of felony is capital murder, where in Texas, you can get a death sentence, a death penalty. So, from
Okay.
an immigration standpoint, any crime that has a jail sentence of more than 1 year is typically a crime where you more than likely will have a problem with immigration. And felonies are typically crimes that typically more than likely will have a jail sentence of more than 1 year. But again, misdemeanors are the lower level crimes. The felonies are higher level crimes. And even in felonies, normally we have a distinction. The highest felony, and then the highest felony in Texas is basically 99 years of jail sentence or death penalty if it's a murder case. So
Mhm.
anytime you hear the word felony, it typically means it's a crime that is like a little bit severe, something like assault, where there is violence involved, or something bigger. If you just go and steal something in Walmart for $5, it's still a crime, but it is not a felony. But if it is something like where you go and beat somebody and that person is like almost battling for his life, more than likely a felony, more than likely a high degree of felony.
Yes. Thank you so much for making that clear for us in such simple language, Chand. And I'm sure folks out there, this was beneficial. And thank you for, making it clear like we should really stay away from all sorts of fraudulent activities, harmful, I mean, things which are not ethical for that matter. So let's definitely stay safe with that. And thank you so much, Chant, for shedding some light on this recent case that is going on. So, folks, at this moment, I'll also want to say that please don't forget to subscribe to our channel, Immigration and Jobs Talk Show, to get to know more about this case, because we'll definitely be covering as it unfolds. All right. So, uh, by the way, does that fall under a category of attempt to murder?
Yeah. So anytime you have attempt to murder, or even sometimes people solicit somebody to murder somebody else, criminal solicitation for murder. So these are typically always felony crimes, because murder is like the highest crime. And whenever you have murder and attempt to murder, or solicitation to murder somebody, they always are felonies, and they're highest level of crimes. And the police typically, they give very high priority to those kind of crimes, to solve those crimes, to put people
Yes.
behind the bars.
Yes.
So anytime you hear the word murder, attempt to murder, sometimes it is even manslaughter. So manslaughter is lower than murder, but still it is like somebody is dying. So these are all typically felony crimes. And what exactly the kind of a jail sentence you can get for that kind of a felony? It completely changes from one state to another state in US, because criminal
Okay.
law is typically under the state law.
State
So you'll
laws.
so you might see some minor variations. Like in Texas, death penalty is valid. In some other states,
Mhm.
death penalty is probably not legal.
Mhm. Right.
And in Texas, typically, if it is a capital murder, they give death sentence. Anything that is not capital murder typically will not go to that level, and it's probably a high jail sentence.
Right, right. And what about sorry, solication? Also fall under category of attempt to murder case?
Solicitation. Yeah,
Solicitation,
I
yes.
mean, solicitation is like going and approaching somebody, uh, to basically say, hey, will you go and murder somebody if I give you some money? That is solicitation. So basically, you are
Okay.
soliciting somebody, you are approaching somebody with an intent to do something criminal. So
Mm-hmm.
solicitation, like what happened in Denton in the last 2 days, was solicitation for prostitution. So they were approaching somebody for the crime of prostitution. So you can see
Yes.
the same kind of solicitation for murder, where somebody goes and approaches somebody and says, hey, I'm going to pay you some money to murder somebody. That is a different kind of solicitation.
Mm-hmm. Okay, okay. Thank you so much, Chan, for making this very much clear. And at this moment, I'll just like to say hi to our folks out there who are commenting. Thank you so much for your questions and comments. We are definitely going to get to each one of these questions of yours. But quickly, Abiyo Dun is saying hello, everyone. So hello to you too. And Deepika Rao, thank you so much for joining. Akbar, we also have Vishnu Vardhan. Thank you so much for joining us. We will take up your questions. Just stay with us for now. All right. So, without further ado, let's get to our topic for today. The topic is, what are the challenges in transitioning from F1 to H1B? So, we will definitely talk about the challenges we face and how maybe what solutions we have today. And Chand, thank you so much for joining us for this topic. Maybe we can tell the friends out there what can they expect from us in this under this topic today in today's episode.
Sure. So I think the biggest challenge is make sure you're following the rules, and that is the biggest
Mhm.
challenge. So that means no crimes while you're on F1. No, not, I mean, I would say like try not even get a speeding ticket. That's how
Okay.
good your record should be. That being said, always, I mean, there are some things that are probably not in your hand, like speeding. Sometimes accidental speeding once in your lifetime. But overall, I mean, the challenges are the big challenges you see are making sure you're maintaining your status, making sure you're doing what you're supposed to do, and then everybody's goal is once you graduate, your career. You're studying so hard, you're getting a degree, an
Mhm.
American degree, to have a good career. So I think the biggest thing, the biggest challenge is finding the right career, the right occupation, the right company to work with that aligns with your goals. So overall, what we will discuss is the legal aspects that you should keep in mind to make sure you have a seamless transition from F1 to a H1B, because your goal is, end of the day, you want to have a good career, you want to follow the rules, and do something good in your life that will also benefit the society, where you can use your education to benefit both your family and also the society. So we will talk about all the legal challenges that you might see, and the precautions that you are supposed to take to make sure that you don't see any kind of things that you cannot avoid. Things like bad RFEs, where they will say you did something bad, you did not work during your OPT, uh, or something of that sort. So we will talk about all the legal aspects that revolve around moving from F1 to H1B.
Definitely, we will. So it's a very critical process, for many individuals, especially those who are navigating their career paths, in the United States. So understanding the hurdles and, it can really make a big difference. So today, Chand is here to help us with that. And so I got this first question for you, Chand, right now that's coming up. Maybe before we get really deep into the topic, you can just give us the base, just in simple words, to folks out there, what is an F1 visa and what is an H1B visa?
So both the visas, they are non-immigrant visas. So non-immigrant visas mean you have a temporary purpose. So you go, you finish up your job, finish up your what you're supposed to do under the terms of that visa, and then you're done. So that's a non-immigrant visa. It's not a permanent visa. It is given for a duration. And when we talk about an F1 visa, the F1 visa in simplest terms is it's a visa given to international students, and their only intention is to study full time, and they want to study full time in either a university, a college, or a school, and they're living in the United States. They are going to one of these educational institutions and they're studying. That's all it means. So F1 is for international people, but who want to be students and study in US. So that is what is an F1 visa. H1B visa, again, it's a non-immigrant visa, but it is a visa for those people who want to come to US and work. And these people want to work in highly specialized fields like technology, engineering, or medicine. It is not any kind of work. It is a specialized work and a specialized field where you at least have a bachelor's degree. So that is what is an H1B visa, a work visa in a highly specialized field. And normally you get this H1B visa for 3 years max each time. So each time you are eligible, you typically get it for 3 years. And there is a duration, which is why it is called a non-immigrant visa, because it is not a permanent visa.
All right. Thank you so much, Chand, for getting our ground ready for today's topic. All right. So moving on, I have this next question, and if you could provide a complete timeline, outlining the process from F1 visa to an H1B visa, including any challenges faced, such as STEM OPT denial or an H1B transfer, also.
Sure. So in terms of the timeline from F1 visa to OPT and to an H1, so it's a process that is spread out over a couple of years. So the study program. So people are typically doing either their bachelor's or their master's, or some people do their PhD. So people have to account for the time period that they're doing their studies. And once their studies are over, typically what happens is there is this like very nice feature in United States called optional practical training. So most of the students, what they do is they transition to this OPT, this uh, thing where they are still technically under student status, F1 visa, but they're not students. They're actually working in the industry. So that is what typically people are supposed to do. They are supposed to finish their studies, and then they're supposed to get this practical training. So practical training is where they can just get some training done, where they shadow somebody at the company and get some training done, or they can actually work, earn money, and learn in their course of study. So that is what somebody is supposed to do. Basically, they're supposed to utilize their OPT program and get some training done. And what that means for everybody is you have to start really planning early for your OPT. And there are strict guidelines. So you actually have to physically apply. It is not automatic. You have to apply. You have to go to USCIS, make a 765 application, pay the fees, and there is a process for that. You have to work with your school DSO, get the I-20, and apply before the deadline, and get your OPT. So get your OPT, and there are strict rules on what you're supposed to do. You're supposed to make sure you're at least getting training for 20 hours or more. You do that part, and once you're doing that part, uh, finish your OPT and look for good career options. Because what happens is, as you get your training, as you increase your skills, the industry skills, you will get more and more good offers. So look for companies that are legitimate. look for companies that are in your line and try to get a job offer from them. And while you're doing that, you secure H1B sponsorship, because what needs to happen is your OPT is limited. So you get OPT for 1 year, and if you're lucky and in the STEM field, you get 2 more years. So if you're in STEM field, you get 3 years of OPT. And once you're done with that, you eventually have to find a H1B sponsor. So your goal during the OPT and STEM OPT is to find the right employer, because you'll find a lot of employers out there, and some employers are probably even shady. There are a lot of these consulting companies who are small companies, sometimes probably even large companies who are not probably following the rules. So always during your OPT, you have enough time. Research your companies, target your employers. Don't just randomly take any H1B sponsorship, because we had cases where people just randomly went to this any employer, and these employers did multiple filings, multiple registration issues, and a lot of students, they were impacted. So target your employers, do a lot of research, and make sure the people you're working with, the employers who are giving you the job offer and saying that they're going to sponsor your H1B, they are legitimate people, they're legitimate companies. You have enough time, there is no hurry. So take your time, do that research, and then make sure the company applies for your H1B. Okay, so that is basically the final thing that you're supposed to do. Ensure that you get your OPT properly done, your STEM OPT properly done, and don't get a denial for your OPT or STEM OPT, and eventually have the company sponsor your H1. And if the company is legitimate, more than likely your case will get approved, because most of the time what happens is, if you're on F1, you are getting a solid US education, and when the US CIS officers, they see that you graduated, you got all this education done in US, they are inclined to approve your case, unless the company is bad or company is shady. So your bottom line is, you already have that US education, make sure you work with a legitimate company, and then majority of the time the case will get approved if the company is legitimate.
All right. Thank you so much. And also, since I feel like it is kind of timely, let's take up this question quickly from Facebook, from KP Karupu, asking, what about the difference between CPT and OPT?
So OPT is optional practical training. So the word OPT means you typically finished your degree program, you graduated, and then after graduation, you're going and getting this practical training. So practical training basically means you're going out in the industry and you're working in the industry, and most of the time you're getting paid. So OPT is basically limited to those times where you graduated and getting this training, this work authorization after your graduation. CPT, on the other hand, again, it is practical training. It is actually, you're working in the industry, you're probably getting paid. The only difference is it is curriculum practical training. So you probably have not graduated yet, you're still studying, you're still attending classes full time, and while you're attending classes, you're going off campus and working in the field of your study. So CPT means you are still a student attending classes full time, you have to attend classes full time, and then you're working and making money. OPT means you finished your graduation, you're not attending classes, all you're doing is only working. So that is the difference. One is where you're still attending classes full time, the other is where
Mhm.
you finished your graduation.
All right. Thank you so much. And KP, thank you for your question. I hope that is very much clear. All right, moving on now. Chand, I have this next question for you, and that is, what are the top 5 tips for successfully transitioning from an F1 student visa to OPT and ultimately to an H1B visa?
Sure. I think the main thing is, again, applying for OPT, graduating at the right time, because you do have to graduate. You do have to graduate with good GPA, because GPA is sometimes a lot of good companies actually look at your GPA. So your first and foremost thing should be, make sure you graduate well. You don't have any academic probations. You don't have any low grades. That is very important. Make sure you're taking right coursework, because a lot of schools, they have the core curriculum and then they have electives. So always look for electives that are in highly demanding fields. For example, for H1B, most of the cases that nowadays that I see are for data engineers, data scientists, AI. So that is where I see a lot of demand. When I see a lot of my H1B cases, where what we are filing at a law firm, I see a lot of these BI engineers, data engineers, data scientists. That is where I see a lot of focus. So definitely try to get electives done in those high demand areas, because that way you can market yourself to the companies. That is very important. So good coursework. And once you're done with that, the OPT. So the OPT is the next big thing. And the big tip for OPT is start conversations with your school DSO well ahead of time. I just saw a denial today where somebody sent me a denial and said if you can fight it. And the denial was, so when you are applying for the OPT, you have very, very strict deadlines. So you have to apply within a certain timeline, and then you have to get an I-20 that is going to have your school DSO's recommendation, and then within 30 days of that recommendation, you have to apply for the OPT. And in this case, what happened is this young person, talked to the school DSO. He got the I-20, but then he did not apply within 30 days. He applied on 33rd day, and USCIS gave that and said, on technicality, this case has to be denied because you failed to meet the 30-day time period after your I-20 was issued. So very, very important tip is don't wait until the last minute. Know the rules about OPT, the initial OPT. Know when you're required to apply, the duration you're supposed to meet. Get the I-20 from your school. Be ready to apply within the time frame. Very, very important. If you miss the timeline, you're going to be in serious trouble with OPT. And the same thing with STEM OPT. The third thing is don't forget your STEM OPT. A lot of people who are doing STEM fields, science, technology, engineering, math, you also get additionally 2 more years. Okay, so the third tip is don't forget your STEM OPT. Again, STEM OPT again has deadlines. You do have to apply well ahead of time. You can't wait until your OPT expires. You have to get again the I-20 recommendation. You have to get the 983. So there are some requirements. So make sure you go through that and apply for STEM OPT timely. That is very, very important. And while you're on STEM OPT, very important thing to notice: employment, the wages. While you're in initial OPT, you can just do training. So even unpaid training is fine. But in STEM OPT, you don't have a choice. You have to get paid. So you have to find not only training, but you have to find paid work. So you have to find productive work, not just training. That is very important. A lot of people miss it. We get that RFE during H1B. So make sure during STEM OPT, you are getting paid, and know your unemployment limits. So there are unemployment limits. So the tip is, for OPT, you can have 90 days of unemployment. For the entire OPT plus STEM OPT, you can have 150 days of unemployment. So make sure you are actually looking at your unemployment days. You are figuring it out. At the time of your H1B, they will look at your unemployment. So make sure you don't, no matter what, you don't exceed your allowed unemployment dates. This is very important. And once this is all done, you find a good sponsor, and the sponsor is applying for your H1B. At that point of time, there is something called cap gap, and there is also something about traveling after your H1B is filed. So make sure once your H1B is filed, to successfully transition to H1B, you look at cap gap if it is applicable to you. If you have any travel plans, make sure you talk to your employer or to the attorney. Don't travel without telling them if your H1B has already been filed. Very important. You have a change of status request filed and you travel, the change of status is going to get denied. So be very, very careful about traveling after your H1B is filed. So I think overall, I think if you take care of these things, I think you'll have a seamless transition to H1B, because most of the time people, I think, they are not aware of the rules. They're not aware of the deadlines. So they forget about cap gap. They forget about travel requirements. They forget about getting paid during their STEM OPT. It's not just basic training. It is more than training. It is showing productive work and getting paid. So overall, I think if they take care of all these issues, they know that these are issues and do some research, I think they will have successful transition to H1B.
All right. Very important to keep all these rules in mind and never to miss out on dates. It's always important to make sure that the dates are correct, and not just the dates that you should file, but also keeping in mind the dates of each form, because even the forms have dates of issue, right, Chand? What about that?
Right, right. And this is another thing I see a lot of people missing. So the
Yes.
765, sometimes people, you can do online filing, but sometimes people also do paper filing. And sometimes
Yes.
they use the wrong edition. And these editions keep
Right.
changing. So people also, when they're filing their 765s, especially if they're doing the the paper filing, be very, very cognizant of the edition dates. If you mess up the edition dates or you mess up the fees that you're supposed to pay, you'll get a denial. And then by the time you're able to react back, sometimes the deadlines are passed. The USS will come back and say you passed the deadline. Now you can't have an OPT approved. So very, very important. Edition dates are super important, and the deadlines are super important.
Thank you, Chand. Thank you for taking that up. Well, I will take up this next question now I have for you. Can someone on an F2 visa change their status to H1B? Specifically, are they allowed to search for a job while on an F2 visa? And if they secure employment, can they transition to an H1B?
Sure. So F2 visa is basically for the spouses of the students. So students are on F1. So F2 is the spouses. And a lot of times the spouses are also well qualified. They have a good degree in India, for example. They have a computer science degree from India, but they came in as spouse. And since they're on their spouses, F2 spouses cannot work. So they have to stay without working. But sometimes they get a good job offer. And yes, the F2 person can change to H1B. It is allowed. And the way it works is they find an employer, again, just like anybody else. And that employer has to go through the lottery because they're on F2. So, I mean, if they went through the lottery in the past, they don't have to go through the lottery. But if this is the first time that they want to get on H1B, that employer has to go through the lottery and then apply for H1B. So just like any other regular H1B, what happens is that employer will say, this person is on F2 and we want to change their status from F2 to H1B. So you can do a change of status filing from F2 to H1B, and F2 people can search for a job, can look for a job. There is nothing wrong with that. The only thing is they cannot really start the job unless the H1B is approved. So if they find a good employer, they can look for an employer. If they find an employer, that employer can sponsor their H1. And the only thing to keep in mind is wait until that H1B is approved. And once the H1B is approved, they're good to start.
All right. Thank you so much, Chand. And well, the conversation is getting really interesting, but I think it's kind of time to take a short break. But I'll quickly say hi to Sanket, Dennis. Thank you for your questions. Kavita, also, we will take up your questions for sure. Please stay with us. And also, Dennis Bang now. Thank you so much. We will take up your questions. Also, if you want to contact Attorney Chand directly, you can always write to him. It's always good to consult an expert and get your cases scrutinized because each case is very individualistic. And so, yes, you can find the details on the screen scrolling. And definitely to get to know more about Attorney Chand, go visit his website, spblawfirm.com. You can call him on his number 817-523-8247. You can even mail him law@spblawfirm.com. And we'll just go for a short break now. Friends, don't go anywhere because right after the break, we will talk more about the challenges in transitioning from F1 to H1B on Immigration and Jobs Talk Show. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com. Welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we are discussing about what are the challenges in transitioning from an F1 visa to H1B visa. And it is a very critical process for many individuals navigating their career paths. So, and helping us out today is none other than Attorney Chand Parvathaneni. And it's been really good so far, so good. Chand, we've already covered much ground on this topic. And I think folks out there are also very curious because they have a lot of questions I can see. I think we should take a few of them if that's fine.
Sure. Yeah.
All right. So let's quickly take this one from Vishnu Vardhan. Hello, Chand. I need your help in my case. Thank you, Vishnu, for your questions. I'm working for MNC company in India and having H1B I-797B approved petition, which is filed in 2022. My current employer is not sending me for stamping and travel since 1 year. I wanted to resign from my current company and do visa transfer to some other company as I have my I-797B and planning to travel United States. My concern here is will it be possible? And is there any chance to revoke my H1B by my current employer? Or and number three is will revocation impact my transfer process and how much time will it take for employer revoking?
Sure. So the good thing is you have a H1B approval in 2022. And what that means is you went through the lottery in 2022 and you got an approval. And that makes you cap exempt. So you are cap exempt for the purposes of H1B. So another employer, if you have another employer who has given you a job offer, they can sponsor your H1B and they can do a transfer. So basically, they just have to show proof that you got an approval in the past. You went through the lottery. So you do have your 2022 approval. And they can use that to file a new petition for you under cap exemption. And since this case has been approved for a long time and has not been revoked by USCIS, you are eligible for a transfer. It does not matter that this other company will revoke your H1B. You should still be eligible for cap exemption based on the fact that you went through a lottery in the past and got an approval. So if you have a good employer who's willing to sponsor your H1B, I think you should explore that option and you should be eligible. At least from a cap exemption perspective, you don't have to go through a lottery. You are eligible for a transfer. So, I mean, good luck in your process and hopefully you have a very good employer. And I don't see any problems in your case. And even if the other employer decides to revoke your case, I don't think it should impact you because you are cap exempt.
Great. All the best, Vishnu Vardhan. Sounds like it's a good scene for you. So all the very best. Let us know if you make it. All right. All right. So this next question is from Abiodun. Hello, everyone. Hello to you too, Abio. Moving on, let's take up this one from Deepika Rao. I'm currently on an F1 visa and want to transition to H1B. Can you explain the cap gap rules and how they impact my status?
So, cap gap is, I mean, it's going to come into picture when your F1 status is about to end, but then you have a H1B filing that has been done for you. So, to give an example, what happens is, for example, you go through the lottery process in March, and your H1B is picked up in the lottery. But say your OPT is expiring in the month of, say, for example, April, for example. So, April, your OPT expires, so your student status is expiring, but then your H1B has been selected in the lottery. And when H1B is selected in the lottery, the earliest they can ask for approval is October 1st. So they cannot file a H1B for you before October 1st, but your student status is expiring. So in those cases, cap gap means there is a gap between the time your F1 status expires and the time when they can ask for your H1B. So this gap is called gap can be fixed by doing something called cap gap. So cap gap is a feature where if your H1B is filed with USCIS, if your H1B is pending with USCIS, you are allowed to stay back in the country until your H1B is approved. And depending on when your OPT card, your EAD is expiring, your employment can be extended automatically. Even if your OPT, STEM OPT expires for example, in April, and they do a H1B filing for you, uh, the time after your OPT EAD card expires, you can get extension of your employment until September 30th. So basically, they are filling up that gap because you have a H1B that is in process. So cap gap is a feature where you can extend your status even after your student status expires if you meet certain conditions, and the primary condition is you have a pending H1B.
Okay. Thank you so much. And Deepika, thank you for your question. I hope you've got your answer. Let's take up this next one. This is from Dennis. Any update on EB3 in October, or prediction or possibility of direction?
Sure. And I think I'll talk about India because India is a country that is severely backlogged for EB3. So EB3 refers to the green cards. So green cards under employment third category. And October, the reason October is very special is because October is the time when the new numbers. So the fiscal year for USCIS starts on October 1st. So starting October 1st, USCIS will have 140,000 green cards that they can issue under employment based categories. Every year, October 1st, it gets reset and the numbers come back again. So the general consensus is October is a time when big movement is possible. And theoretically, historically, every year we see good jumps in October. And that being said, I think a lot of countries went back, rest of the world went back. And those people, I think, will again see good movement. I think it will move back up in October. But when it comes to India, India is stuck in 2012 right now. And if you see what has been happening in the last 6, 7 months in the visa bulletins, India is not really moving ahead at all. It has been stuck in 2012 for such a long time. October, I definitely think that we will see forward movement. This month, we did not see any movement at all in September bulletin. October, I think you'll definitely see some forward movement. Will it be drastic where it is like 1, 2 years? Definitely not. But I think you'll see a few months of jump. Definitely, you're going to see a forward movement, a few months movement. I don't think it'll go more than a year for sure. It'll be definitely, I think my opinion is it's going to be less than a year. Probably a few months is what I think you can expect in the month of October. And then we'll have to see how the rest of the world demand is, because the rest of the world demand will predict what could happen to the India dates in the future.
Right, right, right. All right. Before we take up more from to, okay, let's take this one from Kavita. I was previously on F1 and transitioned to H1B, but my H1B petition was revoked due to a company merger. Can I revert back to F1 status, or do I need to leave the US and reapply for a new H1B?
So, so looks like you did get your H1B approved, and if the H1B petition was revoked after October 1st, say you got your approval, and after October 1st your H1B got revoked, you are cap exempt, and what that means is you can find another employer and probably be able to do a H1B transfer. But we had some cases last year where the big companies they got an approval because you can file H1B from April, May, and June time periods, and people get an approval, but that approval is only valid from October 1st. And in your case, if this H1B was revoked before October 1st, you cannot really use that H1B for cap exemption. Only after October 1st, if your H1B is revoked, you will still be okay. You can go and look for another H1B sponsor. You can use cap exemption. So what you would need to do and research is when exactly did your H1B get revoked? Was it after you started H1B or before your H1B October 1st date? And based on that, you may or may not be eligible for cap exemption. But if you're eligible for cap exemption, you can just simply find a new employer and try to work on H1B.
All right, Kavita, all the best. And yes, now I think let's take up this next question. This is from Nikhil. Okay, let's take this one first before Nikhil's question. Nikhil, just stay with us. This is Sanket. Can you please tell me about New Zealand visa? I do not have a job offer. Okay, that's the
I'm
question.
not much sure about countries other than US, but again, I don't know anything special about New Zealand, but Australia. So people, a lot of Indians, what happens is they go to Australia, they work, they get citizenship in Australia. So anytime somebody is a citizen of Australia, they have a separate class of non-immigrant work visas called E3 visas. So if somebody is a citizen of, goes to work in Australia, becomes a citizen of Australia, they have this special feature called E3 visas, where they can use that to come to US and work in the United States. But as far as New Zealand is concerned, I'm not sure how the New Zealand rules work. But if you're working in New Zealand and want to come to US, you can definitely use H1B, but you would need a job offer and you would need a company in US to sponsor your work visa to come to US.
All right. Thank you, Sankeet, for your question. And if that was what you're looking for, I hope you got your answer. But if you have more questions, you can always keep commenting. Thank you. All right, now this next one. Yes, Nikhil on YouTube is asking, Hey Chand, I'm Nikhil. I have a master's degree in computer science and I am currently working for a DOL program called Job Corps. Do I have any chance for filing for a green card? I really appreciate.
Sure. So in the employment-based categories, typically you need a job offer for majority of the cases. So EB2, EB3, you always need a job offer. And what that means is you need to have an employer, and that employer should be filing your petition, your I-140 petition. So whoever your employer is, they would have to file your whole green card process and do the filing done. However, depending on the kind of work you're doing, if it is in the national interest, because you said it's a DOL, it's a federal program, and if you can argue that your work is in the interest of the nation, there is something called EB2NIW, National Interest Waiver. So you can definitely try to explore and see if the kind of work you're doing is in the national interest, which I think potentially it could be. And then you can explore EB2 NIW. So this EB2 NIW, it's this green card filing. It's this immigrant I-140 petition where you self-sponsor yourself. But you do have to prove that whatever work you're doing, it's in the interest of the nation, and that's why you need a waiver. So other people, they have to go through the process, the perm process, the labor process, where the company has to do the filing. So you would have to argue that in the interest of the nation, you qualify for that waiver, national interest waiver, EB2 NIW, and then see what USCIS does. So I think we need to look more into what your program, what your job role is, and what your qualifications are. But definitely explore EB2 NIW because that's a feature where you can just do the sponsorship yourself without even relying on an employer.
Okay. Thank you so much, Nikhil. I hope you got your answer. And if you have more questions, we're still here for a little more time. So quickly tell us if you need more answers. All right. We also had some more questions, Chand, like from our last episode. Sorry I couldn't be here, but the show was great and we had a lot of participation. We had questions from a few of our audience, and we'll take up two today as well. So definitely we will. But quickly, we will take up right now this one from Amitabh. I am an F1 student who completed my degree and am now on the 60-day grace period. My employer filed an H1B petition for me, but it's still pending. If the H1B petition is approved, but my OPT has expired, can I still travel internationally and re-enter the US on H1B status? Or do I need to wait for the H1B approval and then leave and re-enter the US?
So again, this is a good question. And I think because travel, anytime you have your H1B in process, it's something that you really have to consider and take some legal opinion, number one. And number two, I see that you're within the grace period and looks like your H1B has already been applied. So you are a classic example of cap gap. So you should talk to your school and you might be eligible for cap gap because looks like your H1B has been filed before your OPT expired, and then you're also within the grace period. So anytime your H1B is applied before your grace period, you should be able to stay back in the country till your H1B is adjudicated. And if your H1B has been filed before your OPT has been expired, what happens is you get an automatic extension of your OPT till September 30th. So you might even be able to work. So go to your school DSO, show them proof that your H1B has been filed, show them the receipt, and talk to them about cap gap and see if you are a candidate for cap gap. And normally they look at the rules, they will see when your H1B has been applied, and then they will see when your grace period has started, when your OPT has expired, and they will tell you if you're eligible for cap gap. So definitely talk to your school about cap gap. You might be eligible. They might be able to issue a new I-20 as one thing. And the other thing is, say for personal reasons, you want to go out of the country, if you travel out of the country. If you do travel out of the country and your H1B was filed with change of status, what will happen is your H1B can still be approved, but your change of status, that will be denied. And what that means to you from a practical standpoint is you have to wait outside until you get your H1B approval. Once you get your H1B approval, you go for stamping, and then you get a H1B visa, and then you enter back into the country. So talk to your school DSO. If you're eligible for cap gap, take cap gap and stay back in the country. But if you have to depart from the country, just understand that you would have to wait until you get visa stamping done and come back. Okay. So either way, I think your H1B should not be impacted. Uh, if you're eligible for cap gap, you can basically, even after your grace period, you can stay back in the country. If you're not eligible for cap gap and your school refuses to give you an I-20, travel out of the country, be prepared to go for stamping, and then come back into the country.
Okay. All right. All the best, Amitabh. Thank you for your question. And now, Chand, let's. I was telling you about the questions from our last show, so let's take up this one. This is from Mr. 260319885. What is prediction for EB1 India in October 2024?
So EB1 right now in September bulletin, if you see, the date has moved back to November. So it is November 2022, and last couple of months EB1 has also been pretty bad. Sorry, India is sorry, February. China is November. India is February 2022. And what that means is anybody in EB1 category before February 2022 can get a green card now. So after February 2022, even if you have an I-140 approved with EB1, you cannot get a green card. So more than 2 years plus of wait time. What will happen in October? I definitely think the dates will move up because October EB1 typically moves a little bit faster. EB2, EB3, I don't think India will move that drastically, but EB1, I definitely think you can probably see at least a couple of months to close to a year. There is a good possibility. I mean, my guess is probably at least a year is what I assume. Because right now you are looking at more than 2 years plus backlog because the priority date is stuck in February 2022. So definitely, my guess is you can expect close to a year. And that being said, what I always do is look at the second chart, the date of filing chart. And in September bulletin, the date of filing chart is not that attractive. If you look at the chart 1 and chart 2, they're very close. Both are in February 2022. So it some people interpret that as saying that, hey, the dates might not move very far ahead because even the second chart is pretty backlogged. But because it is October, because we know that another 40,000 green cards can be given under EB1 category. So it is 40,000 for EB1, and out of which 7% is for India. So which means that there is still a good potential. And I would say a couple of months to a year is probably what we can expect in October for EB1 India.
Still, some movement is still better than nothing. So I think that'll still be good. Thank you so much, Chant, for the prediction, and let's hope for the best. Okay, now this next one. Yes, this is also from our. This is from G1F1. So the question is, how about countries that have not been oversubscribed? Would the retrogression still affect them? I think this retrogression is supposed to be by country. Those that have been oversubscribed should be listed, and those that have no should also be listed so that we can know what expectations we are to have from our embassy.
Sure. So, I mean, again, in September bulletin, it was kind of shocking because EB3, which is rest of the world, EB3 for rest of the world, we saw like the dates go back. They went back almost to 2020. And EB3 rest of the world is typically not that backlogged, but it did go back. It was heavily retrogressed back to 2020. But my guess is rest of the world will definitely come back up in October. Rest of the world typically doesn't see that kind of huge backlog. So retrogression, I think, is still going to impact countries like India, China, the oversubscribed countries, but not really rest of the world. Rest of the world, I do think that you will see some forward jump in October. Probably a good jump in October.
Good jump. All right. Thank you for your question, G1. I hope you got your answer. And thank you, Chand. All right. So let's move on now quickly back to our audiences right now who are looking for more questions. And Nikhil, by the way, whose question we took up earlier, says thanks also. So thank you, Nikhil, for your question as well. Now let's take up Sakshi. As a consultant working on F1 OPT, I have been assigned to a client project at a third party worksite. My employer filed an H1B petition for me, but the petition lists my employer's office address, not the client site where I'll be working. If the H1B petition is approved, will I need an H1B amendment or a new labor condition application, LCA, to work at the client site? And another question is, and what documentation will be required to ensure compliance with USCIS regulations and DOL requirements?
Sure. So for everybody out here who has an H1B filing in process or about to be done, remember your rights. Your right is that LCA copy has to be given to you. So every employer has to give the copy of the LCA underlying your H1B filing to you. It's not an option for the employers. They have to give it to you. So make sure you do have the copy of the LCA in your hand. Take a look at the LCA. LCA will have something called the worksite address. So look at the LCA, look at the worksite address. Once the H1B is approved, you can only work as per the terms of this LCA. So if the LCA says you're supposed to work at so and so location, you have to work at that location. Or at least you have to be within the commutable distance, at least in the same metropolitan statistical area, the same metro area of that LCA. So if your company has a H1B filing done for you to work as a software developer, say for example in client Verizon in Dallas area as a software developer, and tomorrow your project can change. But if you're again working in Dallas area, maybe for another client, but still in the same occupation, you don't really require an amendment. So the bottom line is take a look at your LCA, look at the worksite address. And in your case, if your employer is putting the right location, you're good. But tomorrow, if your employer says, no, you have to work at a different location, which is not in the same metro area. Suppose if it's Dallas, a different project in Dallas area is okay. But if they say, no, you have to work in Austin at our headquarters, for example, you have to have an amendment filing done. Without an amendment filing done, you cannot just relocate. So the crux is you can only work from that city where or that metro area where you're allowed to work. Use the LCA to determine whether you're working at the right location or not. If not, you're not in compliance. You're not in compliance with the H1B regulations unless an amendment is filed. So always a good idea for all of you to take a look at your LCA. If there's any discrepancy, bring it to the employer. Say, hey, the rules say that an amendment is required. Okay, and document it. Okay, so that way, if they accidentally overlooked something, you can make sure that you did point it out to them and got the filing done. And if not in compliance with the LCA, you're gonna have trouble when you go for stamping down the line, maybe at a USA site visit and so on. So it's good at least you notice this discrepancy. So just check with your employer and see what happened, and maybe they have a different project in mind from October. So check with them and make sure you are working only at the locations as stated in your LCA.
Very important. Thank you so much, Chand, for taking that up for Sakshi. And Sakshi, thank you for your question as well. Let's move on now to this next question. This is from Jagadish Kumar. Hey Chand, I'm Jagdish. Any update on pilot project? What is a pilot project? And
I think
where have you
it's
taken?
yeah, I think the only pilot project I was aware is earlier this year they had a pilot project for H1B visas. So basically, stateside H1B visas where people don't really have to go to India to get stamping. So it was a pilot project where they said they will only let some people get H1Bs stateside, basically within US, without traveling out of the country. And they're going to use the data from that project to kind of open it up to more wider audience. And I've seen this in January, February. Initially people a lot of people were successful. Whoever were allowed to apply, they were successful because they had some criteria. They said only if you meet this certain criteria you can apply, you can be a part of that pilot project. And the way I saw it was the pilot project was definitely successful because I did see a lot of people get the H1B visas in that pilot project, where it's a pilot test run where they're trying to see how it works. But now we are in the middle of an election year. We are in the middle of an administration change. So I don't know whether they will make or open up that pilot project, make it more wider, and let everybody use that process where they can get H1B visa while they're in US without traveling to India. So we don't have more news about it in the recent times, but they have data. So I think it was a successful pilot test run, and we have to see, because they will also look at their administrative burden and what kind of challenges they had on the administrative side. And I think down the line we will know whether it's going to be opened up for more people, or whether they will shut it down. At this point of time, we don't know what's going to happen. Definitely the administration will change after the elections, so I think a lot will depend on the priorities of the new government, new administration, new president.
Definitely, definitely. And I mean, come November, we are definitely going to have a lot more changes. But before that, we also have October, which is going to be a new fiscal year for us. And I think we are all looking forward for big changes this October. And let's take up the last question for today, Chand. And this is from RK on YouTube, asking, how do you think high NIW approvals have impacted EB2 row? They historically haven't been backlog, and we see that the category has been backlog over the past 2 years, which previously never happened.
Sure. I think definitely high NIW approvals will impact EB2 rest of the world also to some extent. The reason is there is a fixed limit. USCIS cannot exceed the 40,000 EB2 green cards. So under EB2, we again have 40,000 green cards. 7% can come to each country. And when we have NIWs, so what happens is we have NIWs, so we have other countries. So some people probably have priority dates well in the past. So the demand, as we are seeing more NIW approvals, it means that there is more demand on the EB2 side. And again, NIWs can be from different countries, but always you have more approvals, which means more demand. And whenever there is more demand, EB2 or ROW is going to get impacted, because DOS, Department of State, USCIS, they're indicating that they are seeing demand from rest of the world. So more approvals, more people getting into the system is going to impact the priority dates, because there is only 40,000 green cards that can be issued under EB2, and there is not much spillover. This current year, from their disclosure, they're saying that only they had about 20,000 spillover from the other categories. So 140,000 is set in law. So no matter what, 140,000 is allowed to be given for all the employment-based categories. On top of it, they had 20,000 extra green cards. So they had 160,000 green cards. There was not a lot of spillover. So not having a lot of spillover like they had in the previous years, I think also impacted rest of the world. That was one reason. And definitely, I think a lot of demand. And when you say a lot of EB2 NIW approvals, it definitely means that there is a lot of demand from everywhere.
Yes. Definitely, definitely. RK, thank you for your question. Really good to have you participate as well. And Chand, also very enthusiastically, you answered so many questions from the audience today, and also our questions. Thank you so much, Chand, for today.
Thank you, Nipasa.
But I think, there's a lot more to talk about this topic. And I think we should surely continue with this topic in the coming week also, if possible. But also before we leave,
Sure.
Chand, if give our audience an end note just to wrap up this discussion for today.
Sure. And I think a lot of audience today are probably students, because students are trying to transition to H1B. I think this was a great platform, because I think because of your platform, I think we're making people aware of the kind of arrests that are happening. So we want people to be aware. I mean, the reason I think we need to bring up these kind of things is not to shame some people who have done the crime. That's not the goal at all. The goal is to show that, hey, look, a small crime could totally jeopardize your career. So that awareness has to be raised in the society. And I think it's times like these where you go back and reflect and say, hey, the small people think it's a small thing, a small crime, but now their entire career is jeopardized. So definitely, I think it's a message to everybody out there to follow the law 100%. It's not like you follow the law 99% of the time and 1% make a small mistake. No, it's like 0% mistakes, especially when somebody's an immigrant coming to US. The burden is even more to make sure that there is 100% compliance. And that's the goal. And I think the forums like this, like talk shows like this, I think it's an opportunity for everybody to kind of regroup and say, hey, this is very important. And you can never, ever forget the importance of following the law.
So true, Chand, and thank you so much for encouraging us with your words as well. We will keep doing our thing. We love doing this. So, friends, you too, don't forget to love us. Just show your love by liking, sharing, commenting, and definitely participating as well. So, thank you so much once again, Chand, for doing this, and I hope to see you again in the coming week.
Yeah, thank you, Nipasa.
Thank you, thank you. And folks out there, thank you so much. It's been lovely having you once again. So don't forget to contact Attorney Chand. His details are on the screen. You can call him at 817-523-8247. You can mail him at law@spblawfirm.com and go visit spblawfirm.com to get to know more about Chand and SPB Law Firm, definitely. So thank you once again. And it's always best to consult an attorney because every case is different. So you might as well. Also, if you're looking for project placement, career opportunities, for maybe looking for sponsorship for H1B, E3, OPT, TN, visas, anything about immigration at all, you can definitely contact me as well. My details are on the screen. My phone number is 408-335-6444, and that's where you can even WhatsApp me. You can even email me, nipa@higherITpeople.com, and definitely to get to know more about us, go check us out at www.higheritpeople.com. Thank you so much, friends, and this is Nipasa Pradhan signing off for now, but don't forget to subscribe to Immigration and Jobs Talk Show. Bye-bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website.
Hello, everyone. Welcome back to Immigration and Jobs Talk Show. Really good to have you here. Really good to be here myself. I'm Nipasa Pradhan, and yes, we're perfectly ready for another webinar, which is going to go on for about an hour. And before we head on to what the topic is going to be and even welcome our guest, I wanted to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, a big hello to everyone and welcome to Immigration and Jobs Talk Show. And we are very happy to have you live with us right now on YouTube, LinkedIn, Facebook, and Twitter also. So today we will be diving into a very critical topic, and the topic is an L1 visa right for you? We are going to debunk myths and explore alternatives for US employment. And friends, to help us get through this, we are very happy to have our guest for today's webinar, none other than Justin Rivera. Please help me welcome him. He's an immigration attorney who has dedicated his career to business immigration, and indeed, thank you so much for joining us today, Justin. Really good to have you here with us. Justin is from Wasden Immigration Litigation.
Yeah, thank you so much for having me. Looking forward to the discussion.
Absolutely, me too. So, as I already told you, this is our topic for today, friends, and it's going to be very helpful for folks out there. So, the L1 visa is a popular choice for for companies looking to transfer employees to the United States, but it also comes with its own set of challenges, misconceptions, and to help us clarify all our doubts, we are going to have Justin guide us through all of this. So, Justin, maybe if you could also tell us what can viewers out there in different platforms where they're joining us from, what can they expect from this session today?
Yeah, I think what we kind of want to discuss today is kind of a general overview of the L1. Obviously, that comes with a lot of distinctions because you're looking at the L1A versus the L1B. There's a
Mhm.
lot of particular nuanced considerations to go into when you look at an L1. Is it a new business, new office being open? Do you have a blanket as the petitioning organization? Is it not a blanket and it's an individual petition? So there's a lot of nuance and there's a lot to get into, especially regarding the evidentiary requirements.
Mhm.
And I'm thankful for the opportunity to discuss that because I do think that it's important to really create that understanding of the distinction between what is required for the L versus what is required for the H, and then the benefits of the L as well. And then even kind of looking at the L as a possible alternative to people that end up not being selected in the H1B lottery and have to depart the United States, but want to re-enter maybe in the future after getting that 1 year of foreign employment. But we'll dive into all of that today and maybe touch on a couple other more specific topics like the L1's relation to the EB1C.
Absolutely, we are. We are. And friends, I'm very happy to tell you at this moment that you can also participate in this webinar. All you have to do is comment wherever you're watching us from. If you have questions, maybe your own cases, maybe you want to get an answer or a tip from Justin here today, you might as well drop your questions in the comments and we'll be very happy to pick them up. All right, so I think without further ado, we should just go dive right into the topic right now. And my first question for you, Justin, is on the screen. What alternative visa options are available for professionals who may not qualify for the H1B or L1 visas?
Okay, so I think in order to kind of really delve into that topic, you have to get a little bit of an understanding, at least a baseline of what those visas
Mm,
require, right? So for the
absolutely. So,
H-1B visa, you're looking at a situation where you need to have that requisite degree in a specific specialty in order to qualify. Now, the H-1B is nuanced in that you typically have to go through the lottery in order to be selected and then have a company file an H-1B for you. Um,
mhm,
versus the L1, you're not looking at that lottery requirement. The L1 has its own specific conditions that need to be satisfied, but it's not as dependent on the randomness of a lottery. So I think that that's a benefit. Obviously, the H-1B has the caveat of the cap exempt employers, which we can touch on a bit later. But anyway, if you're in a situation where you're not going to qualify, for the H because you didn't get selected in the lottery. You can't find a cap exempt employer, and you don't qualify for the L because you haven't spent that 1 year outside the U.S. with a foreign entity that's connected with the U.S. entity that wants to sponsor the
mhm,
L. There are other visa options. I mean, I think not to say default, but I think the F1 is something that's leaned upon heavily for people who want to utilize the work authorization that comes with it. Now,
mhm,
obviously, for OPT, you're not necessarily in situations where you can immediately use it. You might have to be looking at CPT. Another option, which I think we've touched on in other conversations, is the O1. Now, that O1 is subject to a pretty high evidentiary burden, a pretty high bar to qualify.
mhm,
So that is something that I think that you would need to look at that if you're somebody who's pretty experienced in your field or has a high level of acclaim or notoriety. You have the country-specific visas, the E3, which is oftentimes called the H1B for Australians. But again, that is only going to be for Australians. You could maybe look into the E2 as well. And then the TN visa, which is something that I'm particularly proficient in. But that's, again, going to be only for Canadians and Mexican foreign nationals. So those are just a couple ideas that you can get into. There's obviously going to be even more. There's a litany of visa options in the U.S., but each of them is going to carry their own specific requirements. And, no case is going to be as straightforward as you could just say, you qualify for this. I think it all would take a heightened level of scrutiny in order to make that determination.
Very well put, and it's so true. So every case is different, and it's only when we really consult an expert, an attorney, that we would know which one best suits us. So maybe to guide us through it, if you could help us understand, the key differences between an L1 visa and H1B, and a cap exempt H1B visa, so that people out there have a better idea, just the key differences, and how should one decide which visa is the best for their situation, the best fit?
Yeah, so the L1, the first part of that L1 visa is that qualifying relationship. And without getting too far into the weeds, it basically means that you have to have been working at a foreign entity for a set amount of time within the 3 years preceding your application for the L. So that's going to disqualify a lot of people. That anyone that's been in the U.S. basically and is looking for a visa option, you're not going to be qualified for that L because you've already been here working. Now, there could be caveats to that. Maybe you did work prior to coming into the U.S. and it's within those 3 preceding years. But generally speaking, the L is mostly done for people who are outside the U.S. at the time the case is filed, for the initial L. The H1B, on the other hand, so you are looking at that nuance of cap subject versus cap exempt. So cap subject is going to be the gross majority of individuals that are going to be on H1Bs. Those individuals have to go through a lottery. That lottery process basically means you have an employer that petitions for you, that agrees to register you in a lottery. And then they have your name put into the registration process. A lottery is ran. There's 2 different types of lotteries. There's your master's cap and your regular cap. Those lotteries are ran and individuals are selected. Their registration notice gives them a period in which to file their H1B. That H1B, when it's approved, is only active on October 1st. So that would be the first date that you are eligible to begin working on that H1B. Rather, the difference now with a cap exempt employer is a cap exempt employer can actually file an H1B for you at any time of the year. They are not forced to comply with the lottery requirements. Now, cap exempt employers, there are a couple different types. Usually they're going to be universities, nonprofit organizations, or people that are like institutions that are private but affiliated with nonprofits or placing an entity at a nonprofit. So those are options that can be explored. And then I think something that I often hear about is, okay, well, how do I know if a company is going to qualify as cap exempt? I would just say you need to work with the attorney and the company. The company's probably filed cap exempt H's in the past. What I've seen typically for sponsorships is you're looking at a university, but I've also seen healthcare as an option because a lot of hospitals have a university affiliation. And because of that university affiliation, they can qualify as a cap exempt employer. So that's another opportunity that can be explored. I even think, don't quote me on it, but recently I believe I saw that the employer filing the most cap exempt H's, or at least LCAs, was actually the Mayo Clinic. That's, I think, an avenue that can be explored if you're looking for cap exempt employers. It maybe doesn't just have to be a university. But anyway, that's basically kind of the difference between all of those. And in determining what works best for you or what's going to be the best option for you, I think it really turns on what your degree is, whether you really qualify for that H1B. There are not always degree requirements tied to the L1. So I think that whether or not you have a degree matters. And then also where you are, whether you're in the US or outside of the US, I think can play a role as well. and then the relationship, obviously, that you have with the sponsoring employer. So all of those are variables that should be looked at when determining which avenue to pursue for the visa.
Thank you. Thank you so much, Justin, for giving us this brief introduction to these, these visas, especially L1, H1B, and cap exempt, especially because people are always in a dilemma which visa best fits for them. So, but then again, every case is different. So it's always best to consult an attorney for that. So, Justin, if you can also provide a detailed overview of the American L1 visa process, including practical insights and common challenges, what should, professionals or entrepreneurs be aware of while applying for this visa?
Yeah, so I think the first thing to really point to is the blanket versus individual L petition. And what do I mean by blanket versus individual? A blanket L is for a company that has what's called an approved blanket. And what this does is it allows them to establish the qualifying relationship between the foreign and US company at the outset of the filing. So what do I mean by that? When you're filing an L, you have to meet certain requirements. First of which is going to be, is there a qualifying relationship between the foreign company and the US entity? Now, when you have that blanket, you've already bypassed that because you already have an approved blanket that shows there's a relationship between company A and company B, either a parent subsidiary, affiliate. There's a multitude of ways, but that relationship has already been satisfied, which it makes it an easier process. The alternative is the individual petition. The individual petition, when you're going to have to do a qualifying relationship, it's going to be a higher burden because you have to show USCIS when you're filing that initial individual petition, which you do have to file through USCIS and then attend a visa interview abroad. When you're filing initially, you have to show that qualifying relationship, and you do that by showing, certificates of business incorporation. You show that there's maybe an organizational chart showing the relationship between the companies. You show ownership. There's a lot of evidence that needs to be produced, financial documentation and everything. That makes it a much more difficult process as opposed to if you have a blanket. It's not an impossible burden. It's something you can do. It's just going to take more time. You're also going to have to work a lot more with the foreign entity and the U.S. entity in tandem to produce this documentation. I would also say, because you're filing with USCIS, any evidence that's provided to them that's not in English has to be translated. So you go into a situation where you also have this evidentiary requirement that requires a litany of documentation that also is going to need to be translated when it's submitted. So that's kind of that first part is showing the qualifying relationship between the parties. Then you need to also show that the individual has that requisite 1 year of work abroad in the 3 preceding years. That's typically just done through pay stubs. It's not that difficult to do. I mean, in my experience, it's not been something that I've really run into too many issues with, but that is another thing that has to be shown. And now pivotally, you have the distinction between the L1A and the L1B. So L1A is for managers or executives. Those are typically going to be individuals that are managing degree professionals, professionals in either a team or a unit of the organization. Just to give a quick distinction between what's a manager and an executive, the executive's pretty high up typically in the company. They're probably reporting directly to the board or ownership, and then they have, everything runs lower to them. The manager that's not necessarily be super high up on the food chain, but they're typically going to at least have direct reports. Oftentimes you have individuals who have direct reports who themselves have reports. They show that they manage other managers. So the L1A is, like I said, manager or executive, carries with it a maximum period of 7 years. Just to touch on it briefly, what that means basically is that you're admitted for typically a period of 3 years, and then you get 2-year extensions. The L1B, as an alternative, is for an individual that has specialized knowledge. Without going really deep into what specialized knowledge is, it's basically an intimate, unique, detailed understanding of either maybe a technology utilized by the organization, a process utilized by the organization, something that really differentiates that individual from other employees, not only within the company, but at large within that field. That they need to use in the United States. It needs to be utilized from the foreign country to the United States. So a couple kind of quick examples of what that could be would maybe be someone who created a technology or created a product, something like that, while working within this company that is now being utilized in the United States. They need this person to come over because they know how to use it, and they need them to train others to use it, or they need them to implement it in the US as well. A lot of times that can be done with IT individuals, people who work in information technology. I've seen people who maybe specialize in medical devices, technologies like that, but it's a broad spectrum, specialized knowledge. I've even seen it applied to HR individuals who they have a very unique understanding of the HR processes of a company that they can't readily find with another person, with another organization. So as a result, they need to bring that individual that's in the foreign affiliate into the United States to perform those functions. And so that L1B is that's a 5-year max. So that's going to be a situation where you're only going to be entitled to that one 2-year extension. Just touching, putting a button on this because I know I'm talking a lot. With the L1, the individual L1, you have to apply it with USCIS and get an approved I-797. So USCIS is going to adjudicate your petition. You do have access to premium processing. And once it is approved, you will schedule your visa interview abroad, attend your visa interview, get your visa, and then come into the United States. And that's kind of an overview of how the process works. It can take a while based on how long it takes to get all the documentation together, especially for those individual petitions. I would say you're not looking at the turnaround that you get with an H1B because it's a lot more evidence that's going to be required. And as a result, I think if you're realistic, an individual petition should probably take 2 to 3 months to get everything together, to get it filed with USCIS, get it approved. And that's versus an H1B where I think most H1Bs, you're probably looking at a turnaround of, maybe 7 to 15, 20 days. So yeah, it's a much longer process.
All right. Thank you so much, Justin, for touching up and giving us a thorough, walkthrough. Thank you so much for clarifying. And I'm sure folks out there really are very much clear about this right now. Thank you so much once again. And I can see Rag. Hi, Rag. Thank you so much for joining us. I think you have joined us earlier as well, so it's really good to have you back. And yes, Rag has a question. Individual L1 has better success rates than blanket L1. Blanket L1 holds better for L1B than L1A. Is that a question?
It's an interesting idea to posit. I would definitely say that I don't think you can apply a blanket statement. Hilarious. A blanket statement on the blanket L1. I don't think you can really sit back and say the blanket L1 is better for this than it is for that. I'm speaking from personal experience. I represented a company quite recently that only did blanket Ls, and they did them for both L1Bs and L1As, and they had 100% success rate. There was no problem between the two. I think where it matters is the employer. What is the employer's reputation? How much documentation is the employer putting forth? And does the employer have a history of visa denials? So if you're in a situation where you're being sponsored by a company that has a high rate of visa denials at certain consulates, it's possible that the officer is going to look at that application differently than a company that doesn't have those kinds of issues. That being said, the individual L, in my experience, is almost always harder than the blanket L. For one thing, the blanket, you're not having to file through USCIS. You can go apply at the consulate. And so just by the nature of that, you're skipping over the entire step of the application going through USCIS, receiving an RFE, and having to respond to the RFE. I mean, L1 RFEs are typically rather difficult. They are hard because the evidentiary requirements to be met are going to be pretty high, because they're going to want to see very specific evidence. For the L1A, for example, you're probably looking at information relating to the direct reports, things like the direct reports degrees, maybe examples of their work product, job descriptions, specialized knowledge. They might be asking for specific examples of projects or products that have been worked on by the employee. So it's a lot that's going to be required for that individual L in the event that you get a request for evidence. So I would say that I would say you pretty much always want a blanket over an individual, just because you're not dealing with USCIS. I mean, I've even had clients that I've represented that have had blankets that their employees could obviously extend their H1Bs in the US, but the client's like, no, go abroad, because it's just easier to apply at the consulate, because that way we don't have to go through the burden that USCIS is going to provide. Now that can ebb and flow with administrations, because based on whoever's in positions of authority, they may provide edicts to USCIS that are targeting certain types of visas more or less. But I think generally speaking, the blankets is probably the better way to go. If you can get it. That's not easy. There are a lot of requirements to get a blanket. So not every company just has a blanket.
Exactly. And Rag, thank you for that opinion. And there you go. Thank you so much. Also, like Justin, it looks like large multinational companies like Infosys, TCS, Wipro, they have abused blanket L1s, if I'm not wrong. So, and plus L1B workers started working at client sites, and they're required to work from employers' offices. What are your thoughts on this?
Okay, first off, I definitely want to say I'm not going to paint with a broad brush and say that those companies have abused blanket L1s. I haven't worked with those companies, so I'm not in a position to make those statements. If that's information that's available, then sure, we could say it's available. The thing about the L1 is you are supposed to work in the in the area that is designated within the I-129S. If you're filing that blanket, or the I-129 if you're filing that individual petition. So you are supposed to work. There is that area intended of employment where you're supposed to be working. Now, here's the thing. The L1 is not, there's no LCA for the L1. And what that means is you're not confined to an area of intended employment in the way that you are with an H1B. So I would push back a little bit and say that with the L1, it's not as rigorous as to the physical work location that the individual is working at. Now, they should work with the employer that's designated on their application, generally speaking. And then they should perform the duties that conform with what was provided in that support letter that was presented when they applied. Those things should all be the same. What I don't think is okay would be a situation where you're bringing someone in on an L and they basically go to work at a completely different company. So if you're an individual petitioner and you bring someone in to work at company X, and then you basically just farm them out to another company and they don't do any sort of reporting. There's no actual work relationship between them. Then yes, I think that's an issue that could be problematic. It's not necessarily the same with the blanket, because when you enter with the blanket, there's a little more wiggle room to work with other entities that are covered on the blanket. So it's not as rigorously determined there. I mean, there is nuance. But I'll just put it that way. But that also, we're really starting to dive into Canadian entries at the port of entry versus people who have to apply for visas. So I won't go into all of that. But I mean, I would say generally speaking, you're not confined to the LCA requirement the way you are for the H1B. But I think as a rule of thumb, you should try and make sure that you're complying with what's in the petition. So if you're not complying with what's in the petition, then yeah, I think you're looking at abuse of an L.
Okay. Thank you so much for taking that up also, and Justin for, clarifying and giving us your views about this. And well, thank you for your questions. And I'll just quickly greet our folks out there. So hi again to Rag, and then of course Shaukat, Shivangani, Pooja, Akbar, Dan, Preeti. Thank you so much for joining us. It's really great having you. We will take up your questions. Just stay with us. And I think we should quickly go for a short break. Justin, what do you say?
Yeah, that sounds good.
And
Thanks.
yeah, we'll be back with more questions. And folks out there, don't go anywhere. Stay with us on Immigration and Jobs Talk Show, because today we are discussing on, is an L1 visa right for you? And we are definitely going to debunk more myths and explore different alternatives and discuss further under this topic. So don't go anywhere. Stay with us.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back after this short break to Immigration and Jobs Talk Show. I am Nipasa Pradhan, your host for today, and welcome back, friends. This is the second half of the webinar we are having, and our guest for today is none other than Justin Rivera from Wasden Immigration Litigation. So it's really good to have you with us, Justin. And I just received a message, or rather news about this case in Denton, Texas, and if you don't mind, if we can take a question about that. So, what are the potential
Oh,
immigration consequences, for Indian students arrested in Denton, Texas on charges like solicitation of prostitution and evading arrest? And how might these legal issues affect their visa status and even future immigration prospects? I mean, what lessons can we take away from this case, because many immigrants out there are watching this right now.
right. So, unfortunately, in that circumstance, that charge, solicitation of prostitution, is pretty generally a crime, a crime of moral turpitude. That's usually going to carry consequences that can include inadmissibility, visa revocation, and in some instances, deportation if there's a conviction. Now, that being said, I'm sure that those individuals have hopefully, retained legal representation and are doing everything possible they can to get a plea. If this is the first time these individuals have ever been arrested, then it's likely that they'll, the court will work with them to get them lower level defense or some sort of probation. But those charges, when you're looking at the consequences, they really do turn on what is the maximum penalty that can be provided. Is that maximum penalty more than 1 year? Is it more than a set amount of money that could make it a higher tiered problem for them? I would definitely say that even if there is not a conviction against those individuals in the future, they could deal with inadmissibility issues at the consulate abroad. So that could definitely put them in a circumstance where they're going to be potentially asked, at a visa interview about the issue and have to provide an explanation. In that circumstance, they have to be clear on their DS-160s, about what's happened, and then that information really needs to line up. And if it doesn't, then they could look at, getting one of those 221Gs with an inadmissibility finding. So it complicates everything in your legal process, in your immigration process. The other issue where that's going to come up too is going to be adjustment of status. in the future if they are lucky enough to, be able to apply for that LPR. It's possible that once again, this issue is going to come up. I mean, it's going to come up definitively. So that it's going to unfortunately be something that they're dealing with here for pretty much the remainder of their immigration status in the United States. So yeah, I would say first off, generally speaking, you need to get an attorney, criminal attorney. And that criminal attorney needs to be aware of your immigration status because they have to make special considerations as a result of the fact that you are not a U.S. citizen. I think the next thing that needs to be done is you need to be working in tandem with your immigration attorney so that you guys are aligned kind of on what the strategy is moving forward. Because again, there does need to be that special consideration taken.
So do you think, are they going to be charged with a misdemeanor case or a felony? I mean, felony charges.
It all depends on what the regulation is in the state. It really depends on that. What the regulation is in the state will dictate whether the charge is a misdemeanor versus a felony. And then moving further into that, I'm not a criminal attorney, so it's not something that's well within my wheelhouse. But I would definitely say that I'm hopeful that those individuals don't have any sort of prior criminal history, because if they do, it's exponentially going to make their situation worse. But yeah, I mean, I really think it depends on, do they have prior convictions or charges, and how is that going to play out with the current charge? I think my understanding of the situation is that it was a police operation. So,
Yes.
maybe,
Operation.
yeah, sting operation. So you got to kind of look at the factors that were involved with the particular individuals to see what kind of charges are going to come out. But I'm sure it's something that people will be following because they're going to want to see what the consequences are. I don't know. Did you have anything else you wanted to add on it?
Well, I'm assuming they will be, maybe it's a misdemeanor A with at least 1 year jail term based on the research in Texas. I mean,
Mhm.
state laws. But
Yeah,
since this, I mean, yeah, please say.
yeah, I think if that's the case, and it carries a penalty of more than 1 year in prison, then that can make the situation even more problematic from an inadmissibility standpoint. And again, that's even whether or not there is a conviction. It still can carry
Mhm.
issues abroad.
Yes. And since you are an immigration attorney, maybe you could give out a tip, or maybe what can we learn from this? Goes without saying, of course, that we should stay away from fraudulent activities or criminal activities, whether minor or major for that matter. But if you could give out some tips for people out there who are watching us, it would be great.
I mean, I have to tell you in my history practicing that there are two real things that I've seen mostly come up, and it's issues related to solicitation of prostitution and DUIs. And
Mhm.
those seem to be the two biggest issues that are encountered by non-immigrants in the United States in terms of being charged for crimes. Um, don't do them is the easiest way around it. But also, I just definitely think when you come into the United States, understand that you're here as a privilege and not a right. If you're choosing to come into the United States on a non-immigrant visa, this is not something that is guaranteed to you. It is something that you've been provided as an
Right.
opportunity. You are going to be held to a standard that is likely higher than that of your US citizen counterparts because
Mhm.
you're not a citizen. And you should always strive to operate in your best behavior when you're visiting another person's country. So yeah,
Absolutely.
I do think, unfortunately, that a lot of times these charges befall young people because they're young, and when we're young, we're just not making as
Rebellious.
yeah, and we're not making intelligent decisions that are as fully informed as they are when we're adults. Um, so I get that people learn and grow and everything, but at the same time, you have to be cognizant of the fact that there's
Mhm.
such a high bar of consequence to performing illegal activities in the United States while you're here. So just
Right.
be on your best behavior because that's what you're supposed to be doing.
So true. Very well put. And thank you so much, Justin, for taking that up as well. So
Hmm.
now let's get back to our topic, what we are here for. And I think we should quickly take up questions from our audience before I go into my questions again. because they are waiting for a long time. Let's take this one from Mangu. Infosys settled with the Justice Department for $34 million over allegations of widespread visa fraud between 2010 and 2012. They were the fourth highest recipient of H1B visas with 6,550 visas. This was in 2013. So, what do you have to say about this case?
I'm not sure. I mean, if that's in relation to the previous comment was about L's. So
Yes.
I was answering the
Sure.
question as it relates to L's.
Yes.
If that's the case for H1B visas, I think Infosys, unless I'm wrong, continues to still be one of the higher employers for H1B visas. So they haven't seemingly been deterred by that previous action. I think just as a kind of general statement, though, on H1B visa fraud, I think you're if you're the employee in that circumstance, you're really in a bad spot, because the petitioner's typically the actor there. They're the ones that are actually committing the fraud, because they're the ones that are signing and attesting in the petition, the LCA, that conformance to those activities will exist. I've definitely seen excuse me, I've definitely seen situations where employees, maybe never get copies of their labor condition applications. So they're not actually told where they're supposed to be working. And then they get put at a work site, but in a consultancy situation where they're violating the conditions of the H1B by violating the LCA, but they have no idea. They don't know that. They're just complying with what the employer has told them to do. And then that puts them in a bad situation, because you get into an issue of maintaining non-immigrant status. So unfortunately, it can create, a problem. Now, I will definitely say this as a general matter: you should be receiving a copy of your LCA if you're an H1B employee. You should be receiving a copy of your petition after your case is approved, because you need that eventually to go for visa stamping. So those are things that your employer needs to be furbishing to you. And now, is that necessarily them furbishing a physical copy or just providing you online access to the document? That's either way is fine, but you still should have access to that information. And I would be I would be vigilant as an employee to make sure that what you're doing is in compliance with what's in that petition. Obviously, you should be working, your employer should be working with an immigration attorney. I wouldn't recommend anyone in the current day and age file any sort of NIV application without representation. And if you are, then that's, do so at your own risk. But you should be making sure that what you're doing is compliant, because I think that it's very often that USCIS says that, your lack of knowledge is not an excuse for the violation that's occurred, or the inability to maintain status or violate status. So yeah, I would just say be sure you know that. And then while I'm on my soapbox, I do kind of want to make a point of something, and that is remote work. Remote work is obviously fine in today's day and age. People work remotely all the time. Something I've noticed recently that's going to come up, and I think it's going to continue to come up as we are kind of always transitioning into an era where we have remote workers, is whether or not that remote address is on the labor condition application. As a general rule of thumb, you need to have it on there. If you're in a situation where, you were previously working exclusively at a client site or working at your offices, and you went remote and the companies retained their remote policy, did you include that remote address on an amendment? Obviously, it may not necessarily be required if you're still in the same metropolitan statistical area. But if you're coming up for an extension, should you make a decision to include it as well? If you're not in the same metropolitan statistical area, did you file an amendment timely? Because if you didn't, then you're probably looking at a possible violation of non-immigrant status. So those are the kind of like nuanced things to look at, especially I've noticed with, not to paint with a broad brush, but I've noticed with consulting companies that sometimes there's not as much attention paid in that situation because the worker is working at a third-party site. and that third party site makes a decision to go work from home or hybrid or something like that, the employer may not have knowledge of that if it's never been provided to them by the employee. So I think you need to be proactive as the employee in that circumstance to make sure that your H1B is still compliant with its requirements.
So true, so true. And like you were saying about remote working, I think very much the rates are going up. People prefer working from home, but like Justin has mentioned, friends, if you have a change of address, it's always important to update as soon as possible. Moving on, let's take up another question now from the audience. Arag had another follow-up, so let's take that. USCIS preponderance rule holds good for L1 too.
Yes, that's an evidentiary standard. Yes, that's an easy answer. It's for an non-American. Yes.
Thank you, Rag, for staying with us and for your questions.
Now
let's take this next.
Whether or not they actually apply that preponderance of the evidence standard as USCIS, I would argue is debatable. Because I, for whatever reason, the USCIS definitely seems to operate as if it's a higher threshold for the L. I mean, the L does require more information to be provided, but I do feel personally like you're going to be provided a higher level of scrutiny, unfortunately. But it still should be held to the same to the same standard.
Great. All the best, Rag. I hope that was very helpful. Thank you for your questions. Now let's move on to this next one. Let's take this one from Preeti. I am an Indian national working for a US company in India as a software engineer. My company wants to transfer me to their US office, but I am currently on a 6-month maternity leave. Can I apply for an L1B visa while on leave, or do I need to return to work first?
So the thing about it is it has to be the 3 years preceding your application. So it doesn't have to necessarily be the year leading right up to your application. So what I mean by that is as long as within the prior 3 years you can show that 12 months, then you're eligible to apply. So I would say that I would argue, yes, you could apply. Now, the easiest way is always to just show the pay stubs for the preceding year before your application, but you don't have to do that. As long as you can show that those pay stubs for that time frame within the past 3 years, you're okay to apply.
Thank you, Preeti, for your question, and all the best. I know you'll figure out the best way possible. And congratulations also, I mean, for being a new mom. So yes, Preeti,
yeah, and I mean
that's really nice.
that's tough though. I mean, if you're on maternity leave and basically it sounds like they want you to come to the US right when you come back to work, I'm assuming you're having to move your family with you and everything. I'm sure there's a lot of considerations that have to go in there.
Yes, but I'm sure it's all going to fall in place and everything is going to be good.
Yeah,
all right, Preeti, thank you once again.
That kind of gives me into something I haven't touched on at all for this conversation about L1s, and that's the dependent L2.
Please.
So
tell us about it.
A great benefit of the L, the dependent L, the L2, is that for your spouse, it's going to come with work authorization incident to status. So what that means is literally just by entry into the United States, your partner is immediately granted work authorization in the US, which is awesome. I mean, that's such a huge benefit when you're looking at it versus the H1B. With the H1B, you have your spouse has to go through the issue of getting an approved I-140 before you're going to be able to file for that H4 EAD. So I've actually even seen in the past, unfortunately, we had someone get selected in the lottery for a company I represented, a Canadian individual, and they ended up never coming to the US because their spouse made more money than they did, but wouldn't have been authorized to work in the US when they entered. And so because of that hurdle, they never came. And their company went through the entire process of getting that H1B sponsored for them, getting it filed, getting it approved. But at the end of the day, the employee realized I'm better off where I live for my family because my spouse can't work in the US until I go through the whole process of getting an approved I-140. So yeah, that L2S, that's really awesome. It's really, really helpful to have that. So just another thing to point to for the L1 and how it's a good option.
Beneficial, very beneficial. So thank you so much for highlighting that as well, Justin. Thank you. And folks, I just want to say that you should definitely go follow Wasden Immigration Litigation on LinkedIn for more updates on immigration and also the recent Denton County case as well. Thank you so much, Justin. And let's move on now to this next question we have. This is from Sanjay. I am a Canadian citizen and entrepreneur who wants to start a US subsidiary for my existing business. I have a US citizen spouse, but we are currently living in Canada. Can I use the L1 visa to enter the US and set up my business? And how will my spouse's citizenship impact my immigration options?
So I'll just speak with that in the perspective of the L, because for the L, you can use it for new businesses, for opening new offices in the United States. Now, the thing about that is USCIS seems to be particularly picky about new offices. And as such, you are going to be looking at a higher burden than you would if you have an established business. And the thing about that is, you're coming in to open a new office. That means you can't show that you've been continuously doing business in the United States. It just makes it harder. It's harder to show that, there's an actual valid working company that's going to be existing in the US for the individual to work at. It can be done. It is an option. But in doing it, I think you're going to be looking at a more difficult circumstance. That also being said, which we haven't really touched on that much, but the other issue that creates is in relation to the EB1C. The EB1C is an opportunity to apply for an I-140 through the EB1 category. People usually look at it as a better option versus EB3 or EB2. However, one of those requirements for the EB1C is that the U.S. company is continuously doing business for a period of at least 1 year. So why do I bring all that up? If you're coming in to start a new company, you're not able to show that you're continuously doing business for 1 year. So that avenue is at least initially precluded, where you can't just come in on an L1A and then file an L. You can't come in on L1A immediately and then file an EB1C because you haven't met that requirement. You're going to have to remain for a couple of years. But yeah, you definitely can explore that option. One thing that I think is interesting for Canadians, I know that it's not particularly referenced in this question, but what's something that's unique for Canadians is if you have a blanket employer, if you have an employer that has a blanket, an L1 blanket, you can actually apply for your L at CBP. And that's incredibly unique in comparison to what everyone else in the world has to do in order to qualify for an L. So what does that mean? That means you can prepare your L1 packet, bring your necessary fees, and actually apply either at the airport at the pre-flight clearance CBP before your flight, or at a border, at a port of entry. And what's amazing about that is the L1s that I've prepared for Canadians for CBP, they're just not going to have to require the same amount of evidentiary. Like the volume of evidence is usually lesser because CBP is not just going to approve it. You're going to be subjected to questioning, and it's going to be an interview process. But you're not dealing with the consulate officers, and you're not dealing with USCIS. And it's just such an advantage to have for those individuals. So I definitely would say Canadians, if a company is approaching you for an L and the company has a blanket, I would strongly consider that because it really is one of the easiest ways to get into the U.S. on an L1.
It is. What about, for Indians as well, is it? Is it one of the good options?
That's what's the Canadians are given this special opportunity that's literally just not available to anyone else.
Anyone
If
else?
no, if you're an Indian foreign national, you're dealing with going through USCIS unless you're working with a company that has a blanket.
Mhm.
So it's just a completely different opportunity. And I think that's definitely why you see companies, I can't give you the names of the companies I've represented, but companies that have a lot of business in Canada and the US, they're using that option because it's a great alternative to the TN visa. Because the TN visa has very specific classifications that you need to fall into. And a lot of times, if you're a manager, you're not falling into those classifications. So as a result, they utilize the L1 as an alternative.
Thank you, Justin. Thank you. All right. So, hi, P Man. Um, Thanks for joining us. He's saying hi from Nigeria. I'm from Nigeria, guys. Hi, hello, hola, he says. And now let's go on to Jitendra's question. I am in United States on L2S visa, if I'm right, and currently working. I've been selected in this year H1B lottery. I opted consular processing instead of change of status so that I can continue utilizing L2S. However,
Smart.
when I'll go to India and want to stamp H1B, will that the whole question is not showing here, but let me just read it out. Will
Yeah,
that be
I
a
think
Dropbox or in person? And I heard that if you are in any active visa, then you don't need to go on in personal interview for other visa type. Please
yeah,
suggest.
look, the easiest answer I can give anyone for Dropbox. I get Dropbox questions all the time. Try to schedule the appointment and see if you're eligible for Dropbox. It's going to tell you.
Okay.
It's the clearest advice I can give on it. If it's an option, it should be an option that's presented to you when you're scheduling. And that's it.
Okay.
That's really all I have for Dropbox. I'm sorry. I get Dropbox specific questions all the time, and that's really just my 2 cents on it. Just schedule, see if it's given to you as an option or not.
Yes. Best way to find out. So thank you so much, Jitendra, for that question. And thank you, Justin, for best advice. Arpita, now let's take this question from Arpita. I've heard that L1 visas are only for large multinational companies with extensive resources and a strong presence in the United States. Is this a myth or reality? Can smaller companies or startups or even sole proprietors use L1 visas to transfer employees to the United States? Or are there specific requirements or restrictions that make it difficult for them to qualify?
Yeah, that's a great question, and I think that I think that's definitely a thing that people think is, if I'm on an L, I got to be with Amazon or Apple or these giant multinational conglomerates that they do this all the time. They're probably gonna have a blanket. Does it make it
Mhm.
easier? Yes. Is it impossible for a small company to do an L? No, of course not. You can absolutely qualify for an L as a smaller company as long as you meet the requirements. Um, I've done L's for several companies, where they had to come over and worked in the United States and have an office space here that's defined, where you're going to be working, and they are maybe Spain or German or just a company that has that foreign presence that's expanding into the U.S. Those individuals can qualify for an L1. You just have to meet the requirements. Chiefly, if Mitch is going to be those qualifying relationships between the foreign affiliate and the U.S. entity. And so I think as long as you're able to show that qualifying relationship and show that the position qualifies and you have that year that you've worked abroad, then you're going to be fine. I will say, touching on individual L's, that's something that's important to consider is timeline. I've definitely worked with clients who become frustrated with how long it takes to prepare and submit an L and get it approved. Because with the individual L, it's not done when the case is approved. You still have to
Mhm.
schedule and attend a visa interview abroad. So you really need to parse out that timeline. If you're an employer, and you need to be understanding of that timeline if you're an employee. This is not a 2-week thing. This is something that is going
Okay.
to take months. And so I think also that's something that should be baked in to your validity period, the time period that you're requesting on your approval. Because if you're
Mhm.
saying, I want a 3-year approval and we're going to start working on my case today. And I want my start date to be September 1st. It's not going to happen. You are not going to start on September 1st, and it's not going to happen. So really, you need
Not
to look
possible.
into that and really understand that calculus when you're looking at the L1. Just getting on my soapbox again.
Well, here's another question. What are the key factors that USCIS considers when evaluating L1 visa applications from smaller companies? And how can I increase my chances of approval if I'm applying from a smaller organization?
Yeah, so I think you want to have a robust petition when you're applying. You're going to want to have to show a lot of evidence. Obviously, that qualifying relationship is very important because when it's a smaller company, USCIS isn't supposed to provide more scrutiny, but it's, the officer may, as a result of not being familiar with the company, have a little bit more of a, oh, what is this when they're reviewing it. So I think it's really pivotal to be able to clearly explain the qualifying relationship, show that the company's doing business, show that the company's active and has the ability to pay the U.S. worker. Aside from all of that, which I haven't really been able to get into a ton of, but it's showing the position qualifies. So for that L1A, typically that's going to be managing employees, but it can also be managing a function. USCIS seems to be kind of suspicious of functional managers because I think it's more so that they don't understand how a functional manager is defined. And so that does require your attorney to kind of put on their teacher cap and really explain, this is the function, this is why it's essential, and this is how it's managed. That needs to be done through two things, your support letter and your evidence. And so I think for that, you're going to be looking at a higher bar when you're that smaller company. What I mean by that is because a function managed needs to be an essential function. And if you're a smaller company, it's like, oh, I'm just generally speaking, I'm an HR manager. Okay, well, you're an HR manager of a 7-person company. How is that essential? Versus maybe if you're an HR manager of a 45 or 50 person or a 200-person company, maybe that creates a difference. So for that smaller company, you might have that issue. For the L1B, kind of a similar circumstance, you have to show that specialized knowledge. That specialized knowledge should be company specific and unique against when you're comparing yourself to the rest of individuals within your industry, because you're trying to, again, show I have such specific skill sets and abilities that my company has to bring me over. They can't just hire another person in the US job market because they're not going to be qualified to perform these skills. And so I have to be the person that's being utilized. So I will say if you're a smaller company, you're going to have to be able to present all of that evidence, and it's going to be tedious, but it's completely doable. It's definitely something that can be done. It's something that I've done working with smaller companies in the past. So I know that it's possible.
Thank you so much. Well, Justin and Arpita as well for your question. Justin, like you were saying about, these visas taking very long. Sometimes it's not just about filing it correctly, but also having that patience and being mentally prepared. So do you have cases where you really have to, console your clients and maybe make them prepared, or tell them not to worry, maybe they'll have another chance next time?
Well, yeah, so speaking personally, I think one of the biggest frustrations I ever had practicing was an individual L that we did for a company that we filed, and they didn't want to pay for premium processing. So already they didn't want to pay to process. Then they immediately started complaining about a month after the case was filed that the case wasn't approved because the employee wants to schedule his visa interview. We explained you can't do that because you don't have the approval notice. You need the approval notice to schedule. So we tell them again, you can upgrade to premium. They don't want to pay it. They're frustrated because they've already paid, which I will say with the L, there's a lot of fees involved. It's expensive. You are paying a lot of money to USCIS. So I will give them that, but they didn't want to pay for premium and they were upset. So we filed the case, and the case actually gets approved about, I believe it was 3.5 months after the case was filed. It was approved. We get the approval notice. We're very excited about this because it was a difficult case. I can't remember exactly what the position was, but it was an L1B that took a little bit. I think he was a land surveyor or something like that. Took a little bit of that extra work. Anyway, we get this guy the approval. We send it to him. We say, hey, we're going to help you schedule your visa appointment. And the employee says, I don't want to go to the U.S. anymore.
Okay.
Like, I just don't want to go. Yeah. He just didn't go. And I'm like, your company paid us X amount of money. They paid USCIS
Yes.
X amount of money. And they've set up everything to move you to the US. And you're just going to change your mind because you're upset that it took too long. And that's what I mean by you really need to make sure that everyone has a clear picture at the outset of what's going to happen. And if the attorney hasn't really explained that, which I promise we did, then the employer needs to make sure that that's clearly explained. Because otherwise, you're wasting a lot of time, money, and effort from not only the employer, but the employer abroad, because they have to present all this information too, and the attorneys that have going through all the time to prepare it. So as a result, yes, unfortunately, people on else do sometimes have egos. But as a result, it's just a frustrating key point. So I would definitely say this. Your timeline is much longer for an L than it is for an H1. Realize that, know it up front, and plan around it as a result. Because there are factors that come in. Like I gotta say, I gotta give a little bit to the employees. If you have kids and your kids need to come in by the time the school year starts, you need to factor that in. You need to think about that when you're getting your case ready. If you're saying I need to be there by September because my kids will start school, I need them enrolled. We need to be working on this case, in June, so that we are able to make sure that we get everything taken care of. Yeah, you need a couple of months to make sure that it's filed, approved, and you attend your visa interview and everything. So I would just say, be aware of timelines. It's not the same as an H. It's not as fast as an H. It's just how it is. So outside of that timeline, I think the L it's an excellent option for people. And the people who I really want to put it out there to as thinking about the L are any individuals who are in a circumstance where you've maxed out your time on your F1, haven't been selected in an H1B, and you've got to leave. Look into the options with your employer. If you have an employer that's multinational, look into the idea with your employer of working at a foreign affiliate for that 1 year, that requisite year. Understand that it doesn't have to just be in your home country. Your employer may have foreign affiliates in different countries. Maybe if you're an Indian foreign national, that means going to Canada, Germany, Great Britain, England. There are options for you. So you are not necessarily precluded from eventually returning to the U.S. to be employed simply because you haven't been selected in the H-1B lottery. So that's kind of my last little bit to put on this as we're going over an hour, is just that, keep your options open and definitely work with an immigration attorney in the event that you're trying to pursue an L. You would be an absolutely crazy person to try and file on your own.
Thank you, Justin. I'd just say thank you because I think it was very intriguing, this whole session we spoke about and touched about on L1, H1B, the CAP exempt, and even the Denton County case, and even got a few examples, from your personal cases. Thank you so much. It was really fun having this discussion with you today.
Thank you so much for having me. It's always a pleasure.
But I think I still have a lot more questions. Would you want to continue this topic maybe in the coming session, or maybe another fresh topic also? It's cool.
Yeah, absolutely. I'd love to come back on in the future. And then I would also definitely say to anybody whose question we weren't able to get to or weren't able to answer, there's an email address for you right there, the support@wasden.law. We're more than welcome to, maybe look into scheduling a consultation or something like that for you for your specific immigration issues. And thank you for everyone that took the time to be on here today. It was a pleasure speaking and interacting with you all.
Thank you so much, Justin. And you did half of my work. So there you go. You have the email address, friends. You can also call him on this number, 844-592-7336. And also to get to know more about Wasden Law, go check out their website at wasden.law. Thank you so much, Justin. Once again, you have a great Friday and a happy weekend to you and your family out there.
Thank you. You too. Have a good one.
Thank you. You too, friends. Thank you so much for joining us today. It was really nice having your questions. And Rag says, thanks, Justin and Nipasa. Thank you. Arpita says, thanks a lot for such a detailed explanation. So thank you so much, all of you. Jitendra also says, thank you. Thank you once again, all you folks. Lovely having you. And if you are looking for project placement or H4TN, green cards, anything related to immigration, if you have any questions, you can also contact me. You can email me as well. You can WhatsApp me in this number, 408-335-6444. That is my number where you can even call me. And you can mail me at nipa@highrightypeople.com. And to get to know more about us, go check us out at www.highrightypeople.com. For now, this is it. Y'all out there have a very fun Friday and a happy weekend ahead. But also, thank you so much for joining in. This is Nipasa saying bye-bye for now from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@highrightypeople.com or visit our website